Good morning, everyone. Welcome to the Journal of Law and Public Policy's Fall 2023 Symposium, Free Speech and the U.S. Constitution. Thank you all for joining us today. My name is Olivia Boyer, and I am the Symposium editor for JLPP. We are so looking forward to a day of engaging and informative learning, and we're thankful that you can join us in person and online. I'd now like to hand it off to Interim Dean Nichols, JLPP Editor-in-Chief Mike Petchel, and JLPP Faculty Advisor Professor Charles Reed to continue our welcome.
Thanks, Olivia. I appreciate that. Welcome, everyone. Welcome to all of you, students, guests, panelists, speakers, those of you joining us online. I'm Joel Nichols. I have the pleasure of serving as the Dean at St. Thomas right now. I've been a professor here since 2007. Delighted that you're here. One of my favorite parts of this role is to get to say hello to you and welcome you. I've already talked to some of our guests and just want to say this to the students especially. They continue to say nice things about you, about your hospitality, your organization, putting things on. So that's making its way to me. Good for you, yes. But I'm really proud of our students, especially want to shout out to Mike and to Olivia. But I know there are several of you whose names I don't know. I know lots of names, right? But who put in specific work on tasks and along the way here. So thank you for that and for making it run smoothly along the way. A couple of quick kind of welcome remarks from me as I think about this. I told Mike and Olivia ahead of time, it's always a danger to give me a microphone because deans and professors can talk for a really long time. Dr. Reed and I were kind of laughing about this ahead of time. So I'll try to be shorter so I cede more of my 29 minutes to him, as it were. As we think about free speech, I mean, a couple of key things come to mind. I know it's wide ranging on the program today. But especially as I see the title of it, it's free speech in the U.S. Constitution, right? Harkens in my mind. Well, what is this a space where the U.S. is exceptional, right? Yes, in some ways. But as we think about free speech for every person globally, not just here, well, why is it we're set up the way that we are? And if we're going to be exceptional, are there principles we articulate that actually should become the norm everywhere, every place, or are they somehow unique to our place, our experience, our instantiation of the lived experience of the human endeavor? Because every time we have free speech, right, there's some tension here of the individual against the community, however the community is defined. In Catholic social thought, we sometimes will give shorthand, and this is too brief, right? But a shorthand to human dignity on the individual side. The dignity of the person speaking, the ability to think their thoughts aloud. I'm a verbal out loud kind of person. Some of you are going to be more in your head kind of person, but I need some ability to do that. I need some ability to say my truth, to laud and applaud what's going on around me, to criticize what's going on around me, in part to get to where I land, in part to maybe be lauding someone or criticizing. But I also have to be mindful of your individual, your dignity, the ways that my words hurt, right? And I'm still thinking of this in an individualistic way. I recognize speech comes out. One of our topics is who speaks, so what does it mean for that to attach? But it comes against the other side, which is the community and the role of community. So we think of this often in Catholic social tradition with solidarity, with the way that we are connected one to another. In fact, the responsibilities we have one to another, the rights that not just I have, but that we have collectively, and knowing that speech hurts at times. And so as we think about the community role and our connectedness, part of this driver is how do we balance this challenging tension of allowing a full, robust space for speech while recognizing the reality that it hurts, right? And that hurt isn't something we should be minimizing. But it also hurts in some other ways, right? When we come in and tamp it down, especially if the tamping down is a governmental act or a governmental space and regulation. we could easily come up with examples of times and places where that's happened in ways that violate human dignity. So this is kind of that dance, that space in which we're operating. And my one minor suggestion as I sit down, and I'm ceding lots of time to you, even though I'm talking a lot, see this, is for us to also bear in mind, well, I'll quote one of my teachers that Dr. Reed knows well, right? Harold Berman, one of the gurus of law and religion, would say this as well. I know that John Whitty and I have talked about this, but Hal would think about the way that law is a blunt instrument, right? It doesn't cut fine lines. It struggles to do more precise things that we want it to do. And I would pivot around the corner just slightly and say that sometimes we ask or think that law and the legal system is going to solve and or enforce problems that it just is really ill-equipped to do. But there's still real problems. And so we need to be really cognizant of the limitations of law as well as its possibilities. And then what other tools, what other mechanisms do we have to notice each other, to speak into one another's reality and truth, and to empower each other. So with that, I look forward to hearing the kind of wide-ranging remarks today. And thank you again for being with us.
Without freedom of thought, there can be no such thing as wisdom, and no such thing as public liberty without freedom of speech, which is the right of every man, as far as by it he does not hurt or control the right of another. And this is the only check which it ought to suffer, the only bounds which it ought to know. This sacred privilege is so essential to free government that the security of property and the freedom of speech always go together. And in those wretched countries where a man cannot call his tongue his own, he can scarce call anything else his own. Whoever would overthrow the liberty of a nation must begin by subduing the freedom of speech. Thomas Gordon wrote that in Cato's letter number 15 in 1720. The First Amendment in relevant part states, Congress shall make no law abridging the freedom of speech or of the press or the right of the people peaceably to assemble. Embedded in those two quotes is the greatest fear of our founders, a powerful and oppressive central government. That was a different time. Nearly all interactions were face-to-face between neighbors within communities stable in membership. Contrast that with today, where it is entirely possible to sustain life with minimal human contact. Food can be ordered from a corporation, paid for by phone, without talking, delivered by someone who we will never meet, never talk to, nor otherwise engage with. Those with whom we do engage is purely by choice, and increasingly with those who we agree. A breeding ground for tribalism and a deathbed for tolerance and enriching worldviews. But the underlying principle is the same today as it was back then. For a society of the people, by the people, for the people, to survive, the people must speak to one another. Not whether we disagree, but because we disagree. And with that, I would like to welcome everybody to the Journal of Law and Public Policy's Fall Symposium at the University of St. Thomas School of Law. Before we begin, I'd like to thank, number one, our wonderful contributors who are joining us both in person and virtually on Zoom, Dean Nichols and Professor Reed for their support for the journal members writ large, and last but not least, Olivia Boyer, our symposium editor and the symposium committee, whose hard work is the only reason we're able to host this event. With that, I will turn it over to Professor Reed.
Michael, thank you. We are here this morning to ask and to answer the question, why free speech? The easy answer is it's in the Constitution. And we believe in free speech because our ancestors believed in free speech. They believed in it so highly, they wrote it into our founding documents. The founders gave us free speech. But free speech has to be a more important value than simply a text enshrined in a body of positive law. Our society is better served by freedom of speech. We challenge received wisdom through freedom of speech. And we often discover that received wisdom is wrong. We've recently gone through the COVID pandemic. We know now that the narrative, the simple narrative that developed around the pandemic in the spring and summer of 2020, it was a system of binaries, and we know now that there's a much more complex narrative beginning to emerge around the everything from the origins of the virus to the political response to the virus. And we know this because of freedom of inquiry. We can inquire, we can engage in speech. We know we have discovered a greater layer of complexity there because we ask questions. So it's free speech serves an instrumental good. It helps society develop proper answers, proper responses to crises, to problems. But free speech also has an intrinsic purpose. It helps the human person develop as a human being. The small child begins speech, begins to learn how to talk by asking why. Why? How does this work? Why does this work? And it's those why questions that help the human person develop from the time the child first learns how to speak words, through adulthood, on through the totality of one's life. Free speech is a mark of human personal development as much as it is a social development. Those are good points to bear in mind as we go forward. And as we go forward, we will begin panel one with the question, free speech versus equal protection. We have here David Schultz, Ainsley Johnson Brown, Michael Smith, and Stephen Green, who will be addressing this question in turn. I'll begin by introducing David Schultz, who will be speaking about democracy and disagreement, reconciling a thick equal protection and a thin theory of free speech. David, we welcome you once again here at the University of St. Thomas. Please join us.
Not unless you want to.
I think we should. We
Okay,
need to know
all
about
right,
what
all
you've
right.
done.
Okay, it's up to you.
Thank you, Professor Reed. I just want to read a short bio about each of our speakers so that everyone knows how accomplished these folks are. So like Professor Reed said, we're honored to host our first panel of speakers. I'd like to introduce Professor David Schultz, who is a 4-time Fulbright scholar and national expert on election law and state constitutional law, and teaches various courses at Hamline University, the University of Minnesota School of Law, and here at St. Thomas. Additionally, we have Ms. Ainsley Johnson Brown, who is a constitutional law scholar and policy strategist with a focus on the intersections of free speech, the Constitution, and cultural topics, including LGBTQ and transgender issues, who currently serves as the Ohio Policy and Movement Building Director for URGE. Additionally, we have Professor Michael Smith, who is an assistant professor of law at St. Mary's University School of Law in San Antonio, Texas, and has focused his research on issues relating to constitutional law, including constitutional interpretation, originalism, and state constitutional law. Finally, we have Professor Stephen Green here with us, who is the Fred H. Palos Professor of Law and Affiliated Professor of History and Religious Studies at Willamette University in Salem, Oregon, where he teaches courses in constitutional law, the First Amendment, legal history, and education law, among many other topics. We're delighted to have each of you with us this morning. As you can see, we're doing a hybrid model. We have some folks here, some folks in person, so we appreciate the patience as we navigate that. And with that, Professor Schultz, please go ahead.
Thank you very much. Sorry about messing up your protocol a little bit there. Okay. So just a couple of quick things here. One is that I do have to duck out at 9:30 because I have a couple of classes I have to do online yet. I'll be joining the rest of you for lunch later in the day, so my apologies. And the second thing I just sort of want to mention here as I'm starting off here is I didn't recognize you, Nadine, when we first walked in, and I don't think you're going to remember me. Because I remember when I was the vice president of the South Texas chapter of the ACLU, you called me once and said, and I was in San Antonio, I'm not going to be far away from you. Can you come up and see me where I'm going to be in Texas? And I said, where are you? And you said, Amarillo, Texas. And I had to explain to you that it was about 700 miles away or something like that. And then the other, which we can talk about later on, when I was the vice president of the MCLU here, during the 1990s when there was a lot of dysfunction, and we'll let it go as that. I will say I was on the good guy's side. And so we can have a conversation later on in terms about all that stuff here. So my title is Democracy and Disagreement, Reconciling a Thick Theory of Equal Protection with a Thin Theory of the Free Speech. And as I start to do my presentation here, part of what I've been exploring for a long time, and I've had so many notes on this over the years, is really thinking about the market metaphor that becomes really popular within sort of our whole thinking about the First Amendment. And embedded somewhere in my talk today is thinking about that market metaphor. But let's think about it this way in terms of my talk. Equality and freedom are two imperatives, or twin imperatives, I should say, that are often thought of as mutually reinforcing in a democracy. And both of us think that they are very important. Yet some people in the recent years are arguing that in fact they're in conflict. In recent years, proponents of equality, especially those identified with the critical legal studies or critical race theory, have proposed that the demands of the Equal Protection Clause and the goals of combating societal discrimination can often outweigh or become more important than First Amendment free speech claims. This is especially the case when it comes to addressing issues such as hate speech or the use of words or symbols that target women, people of color, or members of the LGBTQ community. Among the critics of free speech and its current doctrine of neutrality include most recently Ibram X. Kendi from his book How to Be Anti-Racist, Derek Bell, Kimberly Crenshaw, Richard Delgado, Catherine McKinnon. In fact, McKinnon herself argues that there's a collision between free speech and the promotion of equality in our society. Thus, for many of them, they're arguing for what I would call is a thick theory of equal protection. A thick theory of equal protection as driving a First Amendment theory. Phrased another way, what they're arguing for is that in many ways that the First Amendment should almost become a junior, or let us say a junior varsity equal protection clause. The idea of saying that we are also going to use the First Amendment as a way of combating discrimination in our society, and in a way that would target, and in a way that would address language which is inherently what some people argue racist, sexist, homophobic, or otherwise hierarchical. I'm going to take a contrary position. I'm going to argue that in fact the Equal Protection Clause and the First Amendment are what? They're distinct clauses. They're separate, and they have different tasks they're supposed to perform in our society. I'm going to argue and say that I will concede, in fact, that discrimination is a major problem in our society. For anybody who thinks that it's not, of course, we live this school was maybe 4 miles from where George Floyd was murdered. We live in a society, we live in a city that has among the worst racial disparities in America in terms of criminal justice, wealth, a whole bunch of different things. But I'm going to argue, and only I can do a tantalizing small bit of it today, is that this is not about the issue of free speech. This is about a different issue. It is about addressing the problems of inequality in our society. It is about the issues of what the Equal Protection Clause is supposed to address. And that, in fact, there are two different ways, or rather, these clauses perform two different functions. I will also concede that words can hurt, words can harm. But we're also looking at very different goals for what the First Amendment and the Equal Protection Clause are supposed to do. So my title today is I'm going to argue for what I call a thick theory of equal protection, that we have probably in our society and the courts have underappreciated the role that the Equal Protection Clause should have in our society. But at the same time, we are asking too much of the Free Speech Clause if we think its goal is to address substantive inequality in our society. It has different purposes. So as part of my broader talk, I'm obviously going to skip over an awful lot of stuff here because I'm on a short leash in terms of time here, and I'm very cognizant of the fact that we all have free speech, but we all would be smart not to abuse it at some point, especially when we're under time frames for speaking here. I could go through, as Charlie did here, and I could go through all the historic and classic arguments regarding why we should have free speech. We could talk about the importance of free speech in terms of political expression and the importance to a democracy. We could talk about it in terms of the sense of self-expression. It It could be about the discovery of truth for those of us who believe in truth, and for those of people who are postmoderns who don't believe in its truth, maybe it's about the equality of all ideas in our society. But behind all of that, for many of us, and historically, has been the concept of the marketplace of ideas. Somehow the idea, and it goes back to at least Oliver Wendell Holmes, if not further at this point, is that what we're going to do is almost do what? Let 1,000 truths bloom, let 1,000 ideas bloom, and we're going to let the marketplace of ideas sort this out. Well, perhaps. And again, I could go through a long history. I could take us back to what? The religious battles in Europe. I could take us back to a longer discussion in terms of people like John Milton, John Locke, John Stuart Mill, and run through the entire gamut sort of First Amendment theory that's out there. I don't need to do that for now. I could also talk about the issues of the market metaphor, the issues of how we've come to think about free speech in terms of sort of a market competition. And in that, in a broader talk, what I would talk a little bit about is what the market metaphor means in terms of economics. I would talk about the market metaphor in terms of what John Stuart Mill talks about in On Liberty. And then what I would eventually get to into, again, a larger discussion would be to say, what's wrong with the market metaphor? And we could go back and talk about economics. We could talk about the fact that in an economic sphere, markets don't work as free all the time, that we know there are monopolies. We know there are all types of market failures. We know there's problems of free rider. We know there's problems of collective action, et cetera, et cetera. We could also talk about, if we're thinking about the economic metaphor, in terms of a whole bunch of other issues, in terms of what's emerged in our society in the last 50 years, in terms of how markets don't always work. But what I'm getting at here is that when we get to legal theory for the First Amendment, we have a whole bevy of scholars, some political scientists, some lawyers. The political scientists such as Robert Dahl, Grant McConnell, E.E. Schatzsnyder, Ted Loy. We've got First Amendment scholars, Mecklejohn, Scallon, Wellington, a whole bunch of others that buy into the concept of the marketplace of ideas. And it is, if we look through so many cases, such as Abrams, such as Brandenburg versus Ohio, if we look at all of those, at its best, the marketplace does great things in terms of saying we should let lots of ideas flourish. However, in the last few years, there's been a variety of people who have argued that perhaps maybe the marketplace metaphor doesn't work effectively anymore. That if we start to look at people such as, again, Catherine McKinnon, we look at people such as Delgado, Kimberly Crenshaw, the argument would be much in the same way that the market metaphor or the market doesn't work in economics in terms of a free market. Maybe it doesn't work also in terms of First Amendment. Maybe there are, if I can draw an analogy here, maybe there are antitrust problems in terms of First Amendment theory. Maybe there are monopolies. Maybe there is coercion going on. And for a lot of these scholars, the argument would be that we need to be rethinking the First Amendment, that the First Amendment should not be simply about let a million ideas bloom, that we have to recognize that there perhaps is a hierarchy in terms of who the speakers are, a hierarchy in the sense of that some speakers use some ideas as a way of being able to persecute and put others down. And if we look at this, again, if I had more time today, I would talk about people such as Michel Foucault. I would look at people such as Herbert Marcuse. I would look at people like Antonio Gramsci and talk about how what? It's about how words, about how the language that we use can be tools and instrument to suppress. It is how they would argue, along with some of the more recent scholars, how racist, sexist, and other forms of speech contribute to this inequality. And what they would tell us is that some of the most landmark cases in America were decided wrong. Brandenburg versus Ohio. I increasingly find very few students who support the lines that were drawn back in 1968. American Booksellers versus Hudnut, famous case regarding trying to criminalize the sale of obscene, say, violent pornography against women, would be argued to be wrong. And to go back to my ACLU connections here, I actually was involved in the RAV versus St. Paul case, defending basically individuals the right to be able to burn, to basically be able to use hate speech. Don't defend them burning crosses on people's private property, but I defend the fact that they could express their ideas. And most of us in this room probably would not like the Westboro Baptist decision in terms of what the group was doing and what they were saying. And some of you might go so far as to say they shouldn't have been allowed to do what they did. What I'm getting at here is that there is this movement, and coming from both the left and the right, in which on both directions the First Amendment is being criticized. And for some, the argument is going to be that what? That we need to be rethinking the First Amendment, thinking in terms of its relationship to equal protection. And there's an argument being made that in many ways that the First Amendment should also be a tool used alongside of the Equal Protection Clause as a way of addressing inequalities and subordination in our society. And the argument I will make, and again, I know I'm running out of time and I want to be mindful of everybody else here. The argument that I'm going to make is sort of twofold here. One is that part of the problem is we've never taken the Equal Protection Clause very seriously. That in many, many ways, we have watered it down. We have watered it down, and I speak as a political scientist, not as a lawyer now. We look at the fact that what? We have a court over the last 50 years that is increasingly retrenched what the Equal Protection Clause can do. We live in a society that in many ways doesn't take seriously the racial disparities or the class disparities or the gender disparities in our society. And what I would want to argue is for a thick theory, a thicker, more robust theory of the Equal Protection Clause. But also what I'd argue is that part of the failure of the First Amendment is because we don't have, or First Amendment for some of the critics, I should say, we don't have a thicker theory of the Equal Protection Clause. We don't put people in a position of equality in our society where they can articulate their views in a way that they are not put in a subordinate position. We have failed to address the basic racial, sexual, and other inequalities in our society, which contribute to what? The hierarchies under the First Amendment. And I would argue we have also made this confusion, I think what a lot of scholars have, between, as I mentioned before, what the Equal Protection Clause versus what the First Amendment is supposed to do. And I fear, as I start to put my closing together here, is that if we were to start to use even more robustly, as some would advocate, to say that the First Amendment should serve as this sort of, I'll call it, junior Equal Protection Clause, think about the implications first. The weapons that could be used by the weak will eventually be used against them at a future point. The evolution, for the critics who are arguing right now that there's something wrong with the First Amendment and said that it's somehow strayed from where it's supposed to be. And somehow now, if we write it with this anti-subordination principle, things will only work out better. Well, history has a way of ugly repeating itself, and it could undermine itself. Second, for people who want to be saying there's something wrong with the First Amendment theory right now, and that what we have to do is invigorate it, strengthen it, to address inequalities. Are we trusting this current court or a future court to do that work? I don't know about you, I'm not going to do that. I also think, and when I argue against a fat or thick theory of the First Amendment, I think that type of theory undermines the basic concepts of pluralism, undermines the concepts of public and private space, and really sets up a vision for a totalitarian vision of society. I spend a lot of my time teaching in Eastern Europe. I have a lot of friends who lived under the communist regime, in a regime in which they policed speech heavily. Go back to Joel's comment here about, are we a model for the rest of the world? On some things, yes. On some things, God, no, and I hope not, or something like that. But the one thing I think I've learned from being over there is the importance of giving people space to think. to talk, to say what they want, to believe what they want, and even if it's hurtful. Because if it's hurtful, there are other mechanisms of addressing that inequality that we haven't used in our society, and we need to do that. Thus, my conclusion, I think how we reconcile the First Amendment and equal protection is to recognize the different goals and purposes they serve, and to have what I would argue a fatter or thicker theory of equal protection and a thinner theory of free speech that addresses and protects the rights of free speech. Thank you.
While she gets her internet figured out, maybe we can pivot and go to Professor Michael Smith, if you would.
Sure thing. Can you all hear me okay?
We can. Thank you so much.
Awesome. All right. Well, I do hope to hear from Ainsley shortly. I've written on drag bans myself. I'm very interested in seeing what she has to say on that, but that's not what I'm here to talk about today. I'm here to talk about a few recent cases and potentially an upcoming case, the net choice cases and 303 Creative versus Alenis. Before I get into it, though, thank you so much for the opportunity to present. Thank you for the opportunity for me to allow me to present remotely. I am in Baltimore at the moment on another pre-existing scheduling conflict, but I'm happy to be able to participate remotely and sort of do two things in one weekend. So the background, my presentation is titled Social Media Regulation in the Wake of 303 Creative. And I'm interested in the interplay of the court's recent decision in 303 Creative versus Alenis, and how some upcoming cases, specifically Moody versus Net Choice and Net Choice versus Paxton, might interplay with the recent 303 Creative decision, both how 303 Creative might influence the court's ultimate decision in those cases, and how those cases may indicate a broad or a narrow reading of 303 Creative. But some background on what these cases are in the first place. The net choice cases come out of Florida and Texas. Both of them involve different, but for our purposes, similar enough rules by states, statutes passed, restricting social media companies from taking various actions, including shadow banning people, banning political figures, providing notice of why people are being banned or demoted or shadow banned before that action is taken. A number of restrictions in these states, which led to a pretty decisive circuit split. The 11th Circuit concluded that these laws were unconstitutional violations of the First Amendment, and the 5th Circuit concluded to the contrary, that they were not. I'm going to start by running through briefly those two circuits' reasonings and sort of how each of them reached their diametrically opposed conclusions. The 11th Circuit took up Florida's law prohibiting, restricting social media companies' actions in various ways, and concluded that the law implicated free expression rights, specifically the First Amendment right of editorial judgment, exercising editorial judgment or control over the website. The court looked to the case of Miami Herald Publishing Company versus Tornillo, concluding that there, where a newspaper had challenged a rule that infringed upon its ability to control its content and editorial judgment, specifically to require the publishing of anything responding to any story or letter critical of a political candidate, the court looked to that decision and concluded that Florida was trying to do the same. It was trying to control the speech rights of these social media companies and how they regulated the content displayed on their sites. The court also concluded that this editorial judgment was inherently expressive conduct. In support of that aspect of the analysis, it cited the case Coral Ridge Ministries Incorporated versus Amazon.com. That's an 11th Circuit case, and it cited it specifically for the provision that if there's going to be an instance of expressive conduct, it needs to be just whether a reasonable person would interpret some conduct as sending a sort of message. No need to prove a specific message, but that the conduct itself is just interpreted as expressive. Applying that here, the court concluded that this ability to control users' content, either by banning people, by restricting them, by promoting or demoting their posts, that constituted a First Amendment exercise of editorial judgment, and the law infringed on that First Amendment freedom. The court applied intermediate scrutiny rather than strict scrutiny, concluding that was sufficient to determine the case, and struck down a number of the restrictions. Now, pivoting to the Fifth Circuit, Net Choice versus Paxton, the Fifth Circuit framed things differently, finding that the law restricting social media companies didn't chill speech, but instead chilled censorship. It concluded that this exercise of editorial judgment didn't exist, at least not for First Amendment purposes, distinguishing the case from Miami Herald and arguing that these social media sites don't really curate and put in the effort to really choose and form what's shared on their sites. They use these broad algorithms, they use these generalized screening, but there's really no intensive review. It's all kind of done automatically. And that makes this a different case, according to the Fifth Circuit, than Miami Herald. As a result, and the court also analogizes to a number of other cases, most notably Hurley versus Irish American Gay, Lesbian, and Bisexual Group of Boston, which involved a parade organizer's right to choose who is participating or not participating in the parade. Here as well, the Fifth Circuit concluded, the organizers here, the social media companies here, aren't really that intimately connected with the speech they're hosting, and so their First Amendment rights are not implicated as well. As a result, the court determined that the law was permissible, that there was not a sufficient enough infringement on free expression, and that Texas's restrictions could stand. This split has led to the Supreme Court granting cert, and that grant was given on September 29th, 2023. I think a briefing schedule has been set. I don't believe an argument has been scheduled at this point. So that's where we stand with the net choice cases. So these cases, I think, are all influenced by and maybe influential on a third case. And I will be done with my summarizing soon, I promise, but one more case, 303 Creative versus Alenis. This was decided on the last day of the court's last term, and it involved Colorado's public accommodations law that prohibited businesses from refusing to serve people on the basis of sexual orientation. In this case, Lori Smith was a website developer who wanted to get into the wedding website business, but she did not want to make wedding websites for same-sex couples, concerned that doing so would require her to send messages, create content that expressed a view about marriage that she did not believe in, that she believed to be false. Seeing this conflict coming, she sought to challenge Colorado's public accommodations law, and the court concluded that was enough for her to have standing and go ahead and make the challenge. The court, Smith and Colorado also stipulated that all of her business would be expressive, that she would be expressing views, and this would be expressive conduct at issue. The case was very much a creature of stipulations and speculation. Smith never got into the wedding website business before the dispute began. She never turned down any particular customers. A lot of questions are unanswered. How much the customers would have been writing versus how much Smith would have been writing. Would these have been template websites for website users? Would she have interviewed people and then written it in herself? There's, I think, a lot of nitty-gritty questions that are missing here. But nevertheless, the court takes up the case anyway and concludes that the public accommodations law, as applied against Ms. Smith in this case, would violate the First Amendment if it were enforced in the matters the parties stipulated it would be. It concluded that Ms. Smith's expression would be restricted, that she would be required effectively by the law to make speech that she did not agree with. In doing so, the court cited a number of examples talking about what a contrary decision would mean. It talked about a Muslim filmmaker being required to produce a Zionist film. It talked about a gay website developer being required to create a message speaking out against same-sex marriage. These examples I've written elsewhere, I don't think really apply. They seem to assume that only, say, Jewish people would want a Zionist film. Only straight heterosexual people would want to speak out against same-sex marriage. That's the only way we can really actually fit it in under the law that's actually at issue. But wasn't a problem for the court. Those hypotheticals motivated its decision significantly. And the dissenting justices caught on to this, pointing out that there didn't seem to be any limiting principles and pointing out what I think is a fairly easy next step. Well, what's to stop Lori Smith or others from refusing to serve interracial couples who want to get married? What about interracial couples and that interest being used to effectively discriminate now on the basis of race? And the majority essentially dodged. saying that, well, those facts are not this case, and trying to limit its decision, saying, well, this is only a situation where businesses are engaged in expressive conduct. It won't apply to other situations. That limit rings hollow, though, because expressive conduct, the nature of that, wasn't litigated, it was stipulated. And so we're left in a situation of what is expressive conduct? And here's where we get to the overlap. Here's where we get to net choice and 303 creative. I think that 303 creative, in part, might influence how the court decides the net choice cases. 303 creative, while it relied on stipulations to determine that expressive speech was at issue, at least gives us some signposts, gives us some indications. The thinking that, well, developing a website for customers to use was at least stipulated to be expressive conduct and was treated that way for purposes of overturning a law as applied to an individual. So that seems to have some force. But even more significantly, I could see net choice impacting the reach of 303 creative in different ways. I'm with the dissenters of 303 creative. I'm concerned about this case potentially expanding into more concerning cases, including discrimination based on race. The way the court came down in 303 creative was fairly strong. Once expressive conduct is implicated, that interest overrides, with no real limitations as to the subject matter of that interest. Commentary I've seen on the case has indicated that, well, yep, a limiting principle is lacking, and that's just something we have to live with. I think Akil Amar in particular, at least on his podcast, America's Constitution, has been saying, well, yep, vendors can refuse to serve interracial couples. That is what 303 Creative stands for, and that's something we need to live with. I don't sit with that result as easily. I am concerned that 303 Creative can open the door for further conduct that is deemed expressive, and I think net choice may influence what is expressive or is not expressive in our world of, social media, image curation, and public perception. We live in a world of social media and image cultivation. I think there's a strong view for taking conduct to be expressive on a broader view. As an example of this, let's think of masking restrictions by private companies and businesses. Businesses might require masks, they may prohibit masks, and frequently, while there are ostensibly public health reasons for this, frequently those are treated as sort of a political statement, given the politicized nature of COVID-19 pandemic restrictions and regulations and messages that businesses want to send as a result. We see this in weddings, too. 303 Creative held that the simple fact of a same-sex wedding was essentially equivalent to someone, say, speaking out against same-sex marriage. Instead, the court equivocates a same-sex marriage with speaking out in favor of same-sex marriage. But I'm not sure that's a fair inference to make or a completely accurate one to make. When I got married, I didn't think I was making a bold political statement on the acceptability of interracial marriages. I was in love. And I just wanted to marry my wife, who I loved, and continue to love. Net choice presents the possibility of expanding the notion of creative expression. That's one of the issues that are the crux of the Supreme Court's eventual determination of this case. Is it expressive conduct to ban users from social media? Is it expressive conduct to promote certain users' views, to demote their views? That's going to be one of the questions that I think the court needs to answer. And I think it will then be a signal of how expansive we treat expressive conduct and how much that interest can be used by other businesses to potentially discriminate against customers pursuant to the ruling in 303 Creative. I think that this also cuts against some political views on the net choice cases. The laws in net choice were all passed by conservative legislators and governors. There seems to be sort of a conservative push behind restricting social media companies. And on the other hand, I think that people on sort of the critical field might take a different view of this, but I think a good number of progressives and liberals, by virtue of the fact that these are laws passed by conservatives, by Republicans, are going to take the opposite view. No, we need to strike down these oppressive Florida laws, these Texas laws. We need to give social media companies their free expression back. But if we take that to its conclusion and how it might influence 303 Creative, each side might be a little surprised. If the conservatives win in the net choice cases, the laws are upheld, well, that's a pretty restrictive view on what expressive conduct is, and that potentially will limit the scope of 303 Creative and its application to businesses to the extent that their expressive conduct is deemed to be infringed or not by public accommodations and other laws. And as for the liberals who might be in favor of the social media companies and net choice, Well, they may be all in favor of it now, but if they win and expressive conduct is defined expansively, well, then we have 303 creative potentially expanding into many more contexts as well. And that is an outcome that I don't think these liberals would enjoy. So it's a complicated case, made complicated by, in closing, what I want to sort of describe as the absolutist nature of right disputes. In this 303 creative, I think, is a great example of sort of the all or nothing view of rights. If the expressive interest is implicated, that's basically it. There is no limiting principle. There's very little balancing. There's a little lip service paid to discrimination and preventing disadvantaged groups from being harmed at the beginning of the opinion, but that's quickly lost to the importance of free expression. And I think that if we continue in this absolutist approach, we're going to get to a situation where we're going to have to face some extreme consequences. It looks like 303 Creative is potentially setting us on the course for essentially an all or nothing approach, where if it is expressive, discrimination and dignity interests of those who are discriminated against are relegated to the background. I think that we would do well to look to the work of people like Jamal Green, who push for a more proportionate approach to rights disputes, evaluate the interests on both sides and weigh them against each other. I think if we look at it more balanced and contextualized way, we could step away from the polarization and extremes of the current debate. I don't know if that's necessarily going to happen, but I remain hopeful, and I think that would be the best way to thread the needle here. But with that, I do believe I'm out of time. Again, thank you so much for the opportunity. I look forward to hearing any questions or comments you may have.
I'm Stephen Green, and I want to thank the Law Review, thank Charles and Olivia and Mike and Dean Nichols, who I've known forever. It's good to see him. I knew him when he was back at Emory a long time ago. He was just a baby lawyer. Shows you how old I am. Thank you for this invitation. And I want to thank Michael for his just most recent presentation, because I'm going to talk about 303 Creative, but I'm going to talk about it kind of more internal. And so I think we're kind of doing a nice counterpoint, and I actually agree with most everything he said. Thank you. Even most casual observers of the First Amendment have noticed a significant transformation in free speech and religion clause doctrine in recent years. Just within the First Amendment itself, we're witnessing the undoing of a balance that we traditionally have had within the religion clauses through an expansion of free exercise considerations at the expense of non-establishment considerations. Not only has the Supreme Court dismantled the prohibition against funding of religious entities such as parochial schools, which means that government can now permissibly fund religious education. More recent decisions have actually held that the failure to do so actually discriminates against religion, basically going 180 degrees from what the Supreme Court had said in its initial funding cases. Religious claimants are also now entitled to exemptions from beneficial, neutral, health, safety, non-discrimination regulations under a regime of, quote, most favored nation treatment of religiously based claims. And finally, governments are now able to display inherently religious symbols like crosses, Ten Commandments, based upon some ill-defined and ill-conceived notion of historical practices and traditions, whatever that means. So recent holdings have replaced what was a symmetrical understanding of the religion clauses with an asymmetrical approach, one that seems to favor the free exercise side. So too, this symmetry has been undermined when it comes to conflicts between enhanced free speech, free exercise claims, and non-discrimination public accommodations laws, as was just mentioned in the 303 Creative case. As we all remember, back about 5 years ago in the Masterpiece Cake Shop case, the court affirmed, basically gave lip service, I agree with Michael, to the principle that laws and the Constitution can, in some instances, must protect members of the LGBTQ community in the exercise of their civil rights. But that promise has been quickly dismantled by the court, such as in the City of Fulton case, where the court basically found that a neutral and generally applicable non-discrimination policy, when it applied to a private foster care agency, didn't apply because of the religious objections of that foster care agency. So, and then this last term, the court returned to the issues that were left hanging in Masterpiece, because in Masterpiece, the court basically found there was intentional discrimination. In that case, it just was not a neutral law, neutral application. So return to this about whether marriage-related small businesses vendors can raise religious and free speech objections to complying with public accommodations regulations. 303 Creative, in my mind, and I think Michael suggested this, was a case in search of a controversy. Laurie Smith had yet to launch her wedding design business, had yet to turn away any gay couples seeking to employ her services, and had yet to be penalized by the Colorado Civil Rights Commission. Notwithstanding, the court reached out to take this case. I teach constitutional law, I teach standing doctrine. I don't know what's happened to the standing doctrine sometimes. As it's known, the court split along ideological grounds to hold to enforce the non-discrimination law against Ms. Smith and effectively required her to to do a wedding website for a gay couple would compel her speech. Even though I vigorously support non-discrimination laws and conflicts over their application to small businesses, those businesses that raise religiously based objections to provide services to LGBTQ community members, I actually basically kind of agree with the 303 Creative holding. I think it's likely correct. Based upon the nature of the business, web designing, if the enforcement of the non-discrimination law would have been in place, it would have resulted in her compelled speech. I think the decision is arguably correct, but that's not my point. My concern is it presented an easy case as a result of the facts presented. The parties agreed it was quote unquote pure speech. That stands in contrast with the mill run of other public accommodations cases, including photographers, bakers, florists, caterers, etc., who are providing tangible physical products when their speech is more auxiliary. The majority opinion provided little guidance for addressing these controversies, and its tepid acknowledgement of the otherwise compelling nature of public accommodations laws will only foster confusion in adjudicating some conflicts in the future. So as Michael's presentation was looking outside of the wedding vendor situation, mine is to look more back within the wedding vendor scenario. Already, the attorneys for Jack Phillips of Masterpiece Cake Shop fame have raised precedent of 303 Creative in their latest appeal to the Colorado Supreme Court. Well, I'm not the only person who believes this, but the compelled speech doctrine is a mess. Certainly, its principles are admirable, at least when they're articulated. Forced controversy of thought strikes at the heart of freedom of conscience, a concern that is informed both free exercise and free speech. The court has provided several rationales over the years that basically to compel speech is to constrict the individual's freedom of their mind. Closely related is an autonomy concern, that it insults freedom of conscience to force individuals to affirm philosophical, ideological positions with which they find repellent. Other core free speech rationales apply. That compel speech distorts the open debate of issues and runs counter to an unlimited marketplace of ideas where you can have this exchange of ideas. The compelling individuals to speak a particular message alters the content of their speech, and that the enforced conformity of opinion will undermine reciprocal relationship between people and representative governments. Those are all our principles the courts have articulated over various times. And so to an extent, that's why probably 303 Creative, assuming the controversy was in fact ripe, it was at least a stronger case for applying the compelled speech doctrine, unlike so many of the other cases, like in the Rumsfeld versus Fair case, the military recruitment case, and probably closer to the flag salute case. Laurie Smith would be engaging in undisputably expressive activity. Her expression would not only be the product or service, would be the only product or service she is supplying, and requiring her to create a pro-gay marriage website would probably violate her autonomy interests by constricting her expression and her dignity interests, forcing her potentially to embrace a relational lifestyle that she would object to on religious grounds. That's not to say her claim was clear-cut. To say that Smith would be forced to mouth a government orthodoxy would exaggerate matters. Although Colorado, like many states, promotes the value of non-discrimination through its regulations, the state is not seeking to distort public debate over contestable issues through its regulatory authority. The overarching goal is to ensure that no person is denied access to public accommodations, including businesses that openly serve the public. The government is not seeking to force Christian wedding vendors to declare that quote-unquote gay marriage is great. The vendors can continue to state their Christian views about marriage as a holy institution, and they can continue to state their objections to that. Thus, the government is not really attempting to distort the debate over gay marriage. It's just seeking to try to ensure there's open access to services. Okay. The salient issue surprised by 303 Creative, though, is how broadly the courts will interpret this holding, as Michael was suggesting. As stated, I think it sets an easier case. This is why the court reached out to hear it. But with the uncertainty of the compelled speech doctrine, the concern is that precedent will stretch way beyond the doctrine's reasonable applications. And again, unfortunately, the majority was unwilling to explain how its holding might apply to other vendor situations, other than just saying this is not those cases. Right. The values underlying the compelled speech doctrine, I think, lose clarity when you move past Ms. Smith's situation to other forms that involve more symbolic speech. In the majority wedding vendor situations, photographers, bakers, caterers, florists, the question arises whether the service or product provided contains sufficient expressive component to trigger First Amendment considerations. When the government seeks to regulate conduct with an expressive component, courts ask first whether the actor intended to express a particularized message, and then second, whether the message is to be understood by the audience. As to the first question, wedding vendors will undoubtedly maintain that they intend to express a particularized message through their product. After all, what wedding vendor would not assert the creative nature of their endeavor and that the product contains artistic expression. And in fact, in several places in the majority opinion in 303 Creative, the court emphasized the quote-unquote original artwork, the original customized nature of the websites that were in fact in the matter. That artistic conduct, however, may have artistry, does not necessarily mean it's expressive in and of itself. That cannot be decisive. What matters is not the type of creative artistry, but whether the creative artistry furthers a message of endorsement. Assume a religious vendor is not a web designer or photographer, but a custom wedding dress maker, who, after agreeing to create a wedding dress for a woman client, discovers that the client wants a second one for her wife-to-be. Three questions arise. First, is the dressmaker engaged in significant expressive activity in designing the wedding dress beyond the creative aspect? Second, would the finished dress be seen as expressing a perspective on the issue of gay marriage, even though the identical dress would be provided to a heterosexual couple? And then third, assuming the answer to those first two questions is yes, which I'm not necessarily sure it would be, would the regulation requiring the dressmaker to serve the lesbian couple compel the expression or merely require that she deliver a product, a dress? To blithely assert that conduct is creative and even has an expressive component begs the question of whether the speech aspect of the conduct is sufficiently prominent in the service that it's entitled to protection. The second question, of course, is whether it would be perceived as someone speaking out. In several instances, the court has suggested the violation of compelled speech may turn on whether the listener would perceive the compelled entity as having endorsed the views it has putatively embraced. Basically meaning that a reasonable person would perceive that you are actually embracing this particular message. That's why I think the holding in actually the Woolley versus Maynard case, which is the infamous license plate case, the free or die, was wrong, because no one would perceive that Mr. Maynard, driving down the highways of New Hampshire, was endorsing this particular message that was on the bottom of his license plate, right? I argue that the expressive component and the audience perception of it is lessened when the vendor is providing a tangible product with which speech is auxiliary, a wedding cake, flower arrangements, catered food. The more that the vendor's service or product possesses an independent, fungible quality, the less likely it's the primary expressive or would be perceived as much. To adopt Professor Volok's phrase, it may lack a coherent speech product, like a parade or a banner or a newspaper. Now, arguably, and I'll go on more in the paper, and I'm saying I'm starting to run out of time. Wedding photographers present a more difficult case than most of the other vendors. Obviously, we have recognized that photography is a form of expressive activity. Ansel Adams was not just going out and taking whatever photographs he wanted to, he was trying to communicate a particular statement about Yosemite Falls or whatever, right? Certainly some wedding photographers are involved in some creative activity. It's more expressive. But 3 additional questions become salient. One is discussed, whether it would be attributed to that particular person. And once again, I acknowledge that maybe in wedding photography situations, that might be a closer case if the photographer is in the wedding, is actually positioning the couple in particular poses, particular affectionate poses, then we could say that potentially, yes, that there is possibly some attribution. But the second related question involves the dignitary concern of respecting opposing views of the vendors. Photographers regularly photograph subjects they may find to be distasteful, such as a war correspondent who's documenting war atrocities. As Steve Schifrin has noted, wedding photographers, quote, undoubtedly photograph persons that they don't like and couples they think are unsuited to get married all the time. And requiring a photographer to photograph a gay wedding also does not implicate the third aspect, compelled speech doctrine, that of garbling the preferred message of the primary speaker, such as in the Hurley case. Unlike Hurley, wedding photographers have no separate preferred message to convey. It's unlikely that in all the previous weddings that Elaine Photography, the famous case out of New Mexico, was first and foremost conveying a message of heterosexual marriage, was the only biblically ordained form of marriage. I doubt it. She was just taking pictures of wedding couples. And so consequently, she's taking pictures of the commitment and joy of these individuals. Granted, I still say wedding photographers presents a closer case, but seeing that as a closer case, in my mind, means that most of the other wedding vendor cases are not close cases. They're chiefly providing a fungible product, despite some arguably creative aspect, where the product is not chiefly expressive, nor will it be perceived as such. Thank you.
Thank you to each of our speakers this morning. And we unfortunately lost connection with Ms. Johnson-Brown, but we'll hope to pick her back up at a later time today. But at this time, I'd like to pass it off to Professor Reed to begin some questions for anyone in the audience or online. Feel free to throw questions in the chat or raise your hand and we will get a microphone to you. But Professor Reed.
Olivia, thank you. And I'd like to pose a question to each of our panelists, and as a way of initiating some discussion. And for David Schultz, wonderful talk. I look forward to your paper, and very, very, very rich talk. But let me just ask the following question. Free speech, you're an historian, and I'm going to pose the question, how much of our free speech doctrine is contingent and contextualized? I think, for example, of some of the cases you cited in your presentation, and particularly the Communist Party cases, particularly the Brandenburg case, and all of these cases arise from a particular political perspective, and that is to make room for controversial radical speech. Have we perhaps changed our focus now in the 21st century to now a concern, as you pointed out, a concern with issues of structural inequality? And do we really require a new balancing? You've posed that question somewhat, but I'd like to hear you expand on that. For Professor Smith, I have a question. The net choice cases I find fascinating cases. And let me pose a question based on some debates I've seen regarding the net choice cases, and that is, shouldn't we consider the social media companies in the net choice cases as a kind of common carrier? They're serving as transmitters of information rather than editors or curators of information. And shouldn't we apply rules of rules governing common carriers, non-discrimination among viewpoints, most particularly to the transmission of ideas developed and created by others? And then finally, Professor Green, I'd like to ask the distinctions between expressive activity, creative activity, and auxiliary or principal activities. I'd like to ask the question, well, premised on this, all activity is to some extent creative and expressive. My choice of what to wear this morning was a creative, expressive activity. We all engage in creative, expressive activities all day long. So let me ask, how stable are the distinctions between auxiliary expression and other forms of expression that the cases you cite rely on? How stable are they? How arbitrary are they? That's the other side of that. So I will let each of you speak in turn. Thank you.
Okay, great. Thank you very much. A very good question here. And I guess how I want to approach it is to say that I think you're right in the sense that if we think about sort of the history of the expressive freedoms in the United States, they've been driven by what? They've been driven by unions, communists, dissidents, bigots. They've been driven by a whole bunch of people who have unpopular views, some of which many of us probably in this room don't like those views or something like that. But I'm trying to think of the metaphor here, and maybe the metaphor I'm thinking about is it's a wrench. They've opened up the wrench of speech. They opened up the wrench for allow us to be able to communicate. And I think that's good. I think for all the reasons that we could talk about from a history perspective as to why we want to have this kind of very wide open space and be able to talk. And within First Amendment doctrine, we have this notion of what viewpoint neutrality, which some people have described as almost like an equal protection concept within the First Amendment. And I do think you're right, though. I think what we're seeing is in the last decade or more, couple decades, the shift of focus. The shift of focus, as I was talking about in my paper, to say that we want the First Amendment to do something else. And this is at the very heart of what my argument is here. My argument is to say that I think we're confusing what different parts of our Constitution are supposed to be doing. Is that I'm kind of a holistic person. I'm a structuralist person in the sense of saying that we have to be thinking about all the different parts of the Constitution operating and performing different types of functions. And what my argument is to push back against the idea that we tighten the wrench again in terms of free speech. Instead, what we need to be doing, and this is the failure, I think, of constitutional theory, I think it's been the failure of equal protection theory for the last 50 years, is that at the same time we've opened up our free speech, we've not thought about the substantive underlying conditions that address and make it possible to have free speech. And instead, what we're doing is saying, all right, free speech hurts. The solution is close free speech. No, the solution is not close free speech. It's to address those underlying conditions that are making it possible for people to be able to use speech to hurt people.
Professor Smith.
Thank you for the question, and it's definitely one that lurks in both of the Court of Appeal decision and the net choice cases, something the courts are grappling with. I think there's sort of two ways to go about answering it. One would be sort of the existing common carrier and maybe historic common carrier regulations, kind of who qualifies as a common carrier, what the rules are. That is a literature and set of cases I am not all that familiar with, although I will highlight work by my colleague Adam McLeod, who's written about this extensively in the 303 creative context, with businesses being deemed common carriers or not. The way I want to maybe approach the question, though, is kind of thinking about what if we do treat them as common carriers, sort of as more as transmitters rather than editors, and what the implications of that conclusion might be for doctrine and policy. On the policy level, I think that such a treatment would perhaps open up the potential for more regulation. In the internet context, though, and I think some arguments against this may not sound so much from a First Amendment or free speech perspective, and maybe sound more in a sort of policy blunt instrument and incompetence sort of vein, where kind of legislative measures may end up, being more destructive than expected, or have sort of outcomes that we don't expect. For instance, the Florida law, I think, had a notice provision where it's like you have to notify everyone in writing before any adverse action against their account. With that requirement basically being, how the heck are we going to provide this individualized notice for, hundreds of millions of users situation, and how are we going to implement this? Other unexpected consequences might be spam and harassment. If there are sort of this this broader treatment, if we treat them as public carriers and then pass laws like those in Florida and Texas, we may essentially create this effective chilling that leads to a very hands-off approach by the companies saying, well, we're not going to take any adverse measures ourselves. It's up to you, users. And that, I think, as we've seen in other cases and sort of more free reign websites, and in maybe some trends as sort of where we've seen Twitter, or is it X, going recently, that I think can create sort of a harassing, more toxic area, specifically one that I think may crowd out certain views and certain communities, in particular, LGBTQ individuals and people of color. I do think, though, that that's an important point to raise, because maybe it's a way of curtailing the scope to the extent that we're looking at the net choice cases in the context of 303 created. If the Supreme Court wants to decide this maybe on common carrier grounds, let's call these social media sites common carriers and decide it sort of with a specific reference to that kind of business. Well, maybe that's one way that even a sort of broad expressive content, if we take a broad view or a narrow view of expressive content, maybe we're just cabining it to the common carriers and sort of leaving it open as to what expressive content is going to be for these other businesses, service providers, non-common carriers. Maybe that would be a way of threading the needle and avoiding some of these implications that I discussed in my talk. But I think it is an important question.
Well, thank you. And Professor Green.
Well, actually, you asked the central question of my presentation, central question of what's going on. I'm not necessarily sure I have the perfect answer to it, but yes. I mean, intuitively, almost all activity has an expressive component. We can't necessarily say, therefore, as the court seemed to almost be saying, though, in the 303 creative case, therefore that wins, that trumps things. I'm not necessarily the biggest fan of what the court has given us when it comes to the various standards, but the court has at least said that's just the first consideration. Just because you think you may be expressing something, that does not necessarily guarantee you your absolute right to go forward with your expression. I mean, whether you agree with the intermediate scrutiny standard, obviously, Mr. O'Brien was not burning his draft card for the purpose of, using it to roll a marijuana cigarette. He was burning it in the middle of a protest with cameras all there ready for him. Everybody knew exactly what was going on. But even then, the court said, we're going to apply an intermediate scrutiny standard in this particular instance because of the supposedly important governmental interest of making sure you walk around and have your draft card. I mean, I was the last year of people who had to register for the Vietnam War, and I remember fighting tooth and nail with my father. I'm not going to go get my draft card because I disagree with the Vietnam War. But it was like you had to have it to present it to some police officer who would stop you because you had long hair. I'm digressing, I realize. But anyway, the point is that that's just the threshold question of whether someone's engaging in some type of expressive activity. The court really did not explain in 303 Creative how far that will go other than seeming to give almost a carte blanche to it. But once again, we've never really said that becomes predeterminative. People are compelled to speak all the time. A police officer says, pulls you over, give me your driver's license, identify who you are. We're all under an obligation if we see a crime to call the police, on and on. There are many instances where people are compelled to speak for certain reasons. And so consequently, what the court has done is sometimes in this area is focused on kind of the dignitary aspects, sometimes it's focused on the confusion, the disruption of political discourse, governmental orthodoxy. I would just like the court to kind of maybe give us a hierarchy and settle on some of these maybe are more important for the purposes of our First Amendment doctrine. We don't want the government necessarily forcing orthodoxy down people's throat and having them then turn around and mouth that orthodoxy. But like I said, I don't necessarily think that's what most of the public accommodation laws are trying to do. They're trying to say serve the general public regardless of their sexual orientation, their race, their religion, or whatever. That's what they're trying to accomplish. They're not trying to control the debate.
Thank you. Nadine.
I have a lot of comments, but I'll engage in self-censorship and be selective. So first, on the 303 creative case, many thanks to both of you for pointing out the potentially negative implications, but special thanks for further cases downstream. But special thanks to you, Steve, for underscoring that what the court actually decided should be celebrated by First Amendment advocates for on the facts and the issue in that case. The exact question presented, and it was not a question, the same question that was sought, on which cert was sought. But here's the question, the sole question on which the Supreme Court granted cert: whether applying a public accommodation law to compel an artist to speak or stay silent violates the free speech clause of the First Amendment. Can you imagine if the Supreme Court had given a negative answer to that question? The First Amendment is not violated by compelling an artist to speak or stay silent. I was discussing this case, invited to discuss this case with Kristen Wagner, the lawyer who argued it in the Supreme Court. And I was invited at Yale Law School, the Floyd Abrams First Amendment Institute, Floyd being a great First Amendment lawyer and a great friend of mine. And I called Floyd and I said, you know, they're expecting me to debate Kristen Wagner, but I agree with her on this case, you know, and I'm not independent-minded enough that I don't seek company. I knew I was on the other side of the ACLU and other liberal colleagues, so I called Floyd and he said, Nadine, and he gave me permission to quote him. He said, Nadine, the way the question is presented, how could we not want the Supreme Court to answer it the way the ADF wants it to be answered? Also, I think in terms of the facts of this case, again, recognizing other cases are already coming down the pike, but on the facts of this case, it was stipulated by Colorado that Kristen Wagner did not engage in any discrimination at all, or to use a less loaded term, any selectivity at all on the basis of the identity of the people who were seeking her services. She selected solely on the basis of message. So it was stipulated that she would serve anybody of any gender identity or sexual orientation if it was not for a message that violated her conscience. And by the way, one of the messages that was stipulated violated her conscience was any discriminatory message, including a message that discriminated on the basis of sexual orientation or gender identity. I completely agree that this involved, somebody used a felicitous phrase, maybe it was you, Mike, or you, Steve. This is a matter of stipulation and speculation. But I would also say, especially to the law students in the room, this was a matter of lawyering. When I did that discussion at Yale Law School, the students were blown away to find out that all of the issues that have been contested in other cases, including the Phillips Cake case, were not issues here because they had been stipulated away. And one student who was self-identified as being a progressive said, you know, what has gone on here is that Colorado has been out-lawyered. And I thought that didn't gel and crystallize in my mind until I heard the students say that. And I thought, this is such an important lesson. I'm looking at the students here, so many of whom think, well, you know, I've got self-righteousness and moral clarity on my side. I don't need to do the hard work of digging through the facts and worrying about what's in the stipulation. I can just stand up and say, discrimination, you know, against LGBTQ people, and I should win. That's not enough. And so, yes, we have to be concerned about what's coming down the pike, or at least I am concerned. But specifically on the facts and issues of this case, it was a great victory for free speech. And I already know many, many contexts where the protection against compelled speech is going to be wielded in a way that I consider very important. One example being a new lawsuit that was brought by FIRE about a month, Foundation for Individual Rights and Expression, about a month ago, against mandatory, compelled, so-called DEI statements that are very, very detailed and really indoctrinating some kind of intellectual orthodoxy on very important, sensitive questions about race and gender that are being required by the community college system in California. And this is going to be a very helpful precedent in that important litigation. I'm sorry that my old ACLU colleague David had to leave, but because I'm a little bit confused by his presentation. To the extent that David's major point was a point that he made in response to your excellent question, Charles, to the extent that his major point is that legal protection for freedom of speech is not sufficient for meaningful freedom of speech, I could not agree more. That is precisely why I oppose so-called cancel culture, which can be completely consistent with the First Amendment, but undermine it as a practical matter. It's why I completely support the generous provision of educational, technological, psychological, other resources to really empower everybody to actually exercise freedom of speech. But to the extent, I thought I also heard David in his initial presentation suggesting that there has not previously been understanding of or critique of a robust First Amendment free speech law because there hasn't been enough attention to the alleged tension between robust free speech and equality. And I could say nothing is further from the truth. That issue has been hotly contested throughout my entire adult lifetime, which is very long, and going through even earlier to the ACLU's very earliest days when the ACLU started from the outset in the 1920s, defending freedom even for the thought that we hate, including anti-civil liberties speech. And we were attacked from the get-go from people from the left who said we should not be defending free speech for fascists and for members of the KKK. These are very serious arguments. I think they should be revisited and revisited and revisited. I constantly do myself as a Jew. And a Zionist, you can imagine that I have been asked repeatedly since October 7th, do you really defend free speech for Students for Justice in Palestine and others who are making what I consider to be anti-Semitic and pro-terrorist statements? And you can see, I've written a couple of publications that say I still do. So I welcome the ongoing discussion, but I want to underscore that these are very old arguments that go back a long time, and that the concept of interpreting the Equal Protection Clause consistently or in light of the Free Speech Clause is one that has been addressed powerfully before, I think no more powerfully than by Supreme Court Justice Thurgood Marshall, the first Black justice on the United States Supreme Court in 1972 in Chicago versus Mosley, which was the first time that the court articulated the viewpoint neutrality principle of First Amendment law. Marshall didn't even refer expressly to the First Amendment. He was treating it as a case under the Equal Protection Clause and said we violate the Equal Protection Clause if we discriminate against speech on the basis of ideas. And Marshall is just one of many Black advocates for civil rights who have maintained that a robust First Amendment free speech understanding, which is robust enough to extend to so-called hate speech, is essential to counter racial injustice and to advance equality. One more point, please, and I could write a whole article about this. One more point. One of the cases that was criticized by David is Brandenburg versus Ohio, decided unanimously in 1969, and he's saying he did say he was no longer a fan of it. Well, I want to tell you one person who is still a fan of it. Her name is Eleanor Holmes Norton. She was the first Black woman to chair the Equal Employment Opportunity Commission appointed by President Jimmy Carter. She has long been the representative for the District of Columbia in Washington, D.C. When she was a young lawyer, she was the ACLU Counsel of Record in that case, and she is so proud of that case. She was interviewed very recently, within the last year. It appears in a documentary film series that I happen to host, so I've watched it many times. She says it's one of her proudest moments. She continues to believe that even though the immediate beneficiary of the strong free speech protection in that case was Clarence Brandenburg, an avowed KKK member, that the principle that was established is especially important for advocates of racial justice and other minority causes. And let me give you one other example. Emerson Sykes, a staff lawyer at the ACLU who is Black and Muslim and a progressive, and Emerson wrote an entire law review article about 2 years ago in the Brooklyn Law Review as part of the Symposium on Free Speech, in which he expressly defended Brandenburg as still being especially important, not just in terms of some abstract fidelity to free speech principles, but especially important as an engine for lifting the voices of religious and racial and political minorities who are much more likely to be suppressed by any expansion of government power to limit speech, including under the rubric of so-called hate speech.
A question both for Professor Smith and Green, and I think it relates to Ms. Strausson's comments as well. But I'm curious, and I understand that the court framed the question really narrowly and painted Elenis as an artist. But one of the things that I think Sotomayor brought up in the dissent that I found compelling was, and you touched on it, Professor Green, this idea of once you are not acting as an artist but as a participant in the market, so you're holding yourself out as a business more than an artist, at what point can we as a society say that the expressive conduct there is limited in all sorts of ways? And kind of drawing on the parallels to we regulate racist speech in the market, we regulate all sorts of speech. So I'm okay with the stipulation that it's expressive conduct, but were we to re-ask the question of when can we compel or restrict speech of a business or just a purely economic participant that's expressive because it's so deeply entrenched in our tradition of public accommodations law. So I'm curious if you would just expand on your thoughts there. And I think you did a little bit about the purpose, but I'd love to hear from both of you on that.
Well, like I kind of said, not derogatorily, but anyway, what I said is, what wedding vendor is not going to want to claim they're an artist, right? I mean, that's what people want to project. And so consequently, it begs the question. It just starts the discussion. But you see in Theory Creative, Justice Gorsuch several times, this is his emphasis, the inherently creative aspect of what she is doing, right? No, I still think, and I don't know exactly where these lines are, Charles. It's hard to know. But still, and I'm borrowing actually from Professor Corbin, a liberal friend of mine, Gene Volokh, a conservative friend of mine, who all agree that there's going to be some limitations going to be placed on how far this principle goes, how far it applies, certainly to types of wedding vendors. And I don't know. I mean, when the more that if Jack Phillips wants to say, I make Christian wedding cakes, that's fine. He can put that out front, and he can basically say those are the types of cakes he's wanting. If an Orthodox Jewish baker wants to do, I'm only going to do kosher food, I'm going to do kosher weddings. They can put that out front. But when you don't do that and you open it up to any person who walks through the door, you don't place these restrictions, and the product you're otherwise doing is a product. Again, most of Philip's cakes are not quote unquote heterosexual cakes. They're wedding cakes. That's what he's doing. Same thing with most wedding photographers. They're just doing wedding photography. So they're not necessarily making pro-heterosexual wedding photography. And so consequently, we need to kind of step back and look and see how is this going to, once again, going to be perceived? What are the countervailing important public accommodations reasons that we want to have this available? But just because you're creating a something creative. I mean, in my paper, I go on and talk about a wood carver who makes handcrafted furniture, personal furniture for customers, right? That is highly creative. That's highly artistic. It's expressive in the sense he's saying, I'm making some type of handcrafted piece of furniture. But that's the extent of the message. He's not making a pro-gay or a pro-heterosexual piece of furniture. And so I think we have to be reasonable about this.
And to add on to that, I think I think I agree with pretty much all of that. I think that's sort of one reason why, again, I'm a little bit, discontented with 303 Creative. In a world where the Supreme Court takes so few cases and provides us with, so little guidance on each case, we're going to take this precedent for all its worth and try to apply it as much as we can. But, as far as thinking about it in terms of like the issue presented or the facts of the case, there are no facts of the case. Unlike, Masterpiece Cake Shop and Phillips, like he had a business, he had cakes, like we could maybe point to some of the services he provided. He denied business of a certain customer. We know nothing about what Lori Smith, was going to do, what the format of the websites would be. Would she be creating things? Would they be? So that was, I think it's a little bit, in terms of talking about the facts of the case, I think 303 Creative should be of almost no precedential value on expressive speech because it's a creature of stipulation. It wasn't litigated. It wasn't part of the decision. But that's not how we're going to treat it because that's not how Supreme Court precedent works. And as far as treating things, I think reasonably, I think that gets to sort of this last point of kind of taking a more nuanced and proportionate approach, sort of avoid the kind of absolutist tendency present, not just in the arguments of lawyers where, I was a lawyer for years and that's how I treated things. I advocate, I push for a side. But when the Supreme Court decides something, this practice of sort of, if it's expressive, it's gonna trump. It's a right as trump, as Jamal Green has written. And we see this going back to Hurley. We see this going back to Boy Scouts America versus Dale. Discrimination in the analysis, in the working of how the court reasons its way to the conclusions of those cases. Discrimination falls by the wayside. It gets lost, and expression sort of trumps all. The same happens in 303 Creative. I'm not arguing for equal protection to now trump First Amendment rights. That would just sort of be a trump in the opposite direction. I'm arguing for a more nuanced approach to sort of the court, which is balancing the claims presented on either side, should reason through this in a way that accounts for those discrimination impacts, the dignitary impacts of customers denied service, while also paying attention to the expressive rights and the expression of the speaker. A task there that I think was impossible to do almost in a case where we don't have an actual dispute on the ground and everything is just artificially stipulated by concessions that I think Colorado should not have made. We talk about out-lawyering. I don't know what went on with those stipulations. I don't know why Colorado agreed to that. But I had no control over that. And again, we work with the precedent now that we have going forward.
Thank you, Professor Smith, Professor Green, and Professor Schultz, who has stepped out. We'll now be having a short break before our second panel. We're running a little bit behind schedule, so we'll just take about a 5-minute break and meet everyone back in here for our second panel. Thank you. Welcome back, and to those just joining us, welcome to the Journal of Law and Public Policy's Fall 2023 Symposium, Free Speech and the U.S. Constitution. We're honored to host our next panel of talented speakers that focuses on the principal defenses of free speech, featuring Professor Amna Khalid, Professor Jeff Snyder, and Professor Robert Kahn. I'll introduce each of them in turn. Professor Khalid is an associate professor at Carleton College and host of the Banished podcast, who specializes in modern South Asian history and global free expression. Drawing from her Pakistani upbringing under military dictatorships, Professor Khalid's speeches and publications often focus on censorship and academic freedom. Professor Snyder is an associate professor at Carleton College, who specializes in U.S. educational history, academic freedom, and public education's role in democracy, and is notably recognized for his research on threats to academic freedom in Florida and his book, Making Black History: The Color Line, Culture, and Race in the Age of Jim Crow. Professor Kahn is a professor of law here at the University of St. Thomas School and has focused his research on issues relating to Holocaust denial laws, hate speech directed at Muslims, defamation of religions, cross-burning, and memory laws. We are so excited to have each of you here with us this morning, and I would invite Professors Khalid and Snyder to start off our second panel.
Okay. Amna and I are delighted to be here. Thank you to the Journal of Law and Public Policy for sponsoring this symposium. Thank you to Mike for the kind invitation. A special thanks to Olivia for all of her help with logistics. Thank you to Charles for the expert moderating. For over a century, the mission of higher education has focused on promoting critical thinking and preparing young people for their roles as citizens. Last year, U.S. Circuit Judge Kevin Newsom summed up this twofold mission as follows. Colleges and universities serve as the founts of and the testing grounds for new ideas. Their chief mission is to equip students to examine arguments critically, and perhaps even more importantly, to prepare young citizens to participate in the civic and political life of our democratic republic. So free speech and academic freedom, we're going to argue, are essential to the mission of higher education. Let us just rehearse a few key points along these lines. So academic freedom has been defined and codified by the American Association of University Professors, the AAUP. Founded in 1915, the AAUP said that professors should be able to carry out their research and teaching without fear or favor, because they are experts whose professional work advances the sum of human knowledge and contributes to the public good. Now, the AAUP outlined three fundamental pillars of academic freedom: freedom of inquiry and research, freedom of teaching, and the freedom of extramural utterance and action, right? Which is a fancy way of saying that college and university teachers aren't just educational professionals, they're also citizens. And when they write or speak as citizens, as the AAUP has said, they should be free from institutional censorship or discipline. Especially in the last few years, we've seen that academic freedom and free speech are often conflated. So what's the difference between these two concepts, these two ideals? Free speech, don't need to tell this to this audience, but I'll rehearse it anyways, protected by the First Amendment. Right, public colleges and universities are bound by the First Amendment, private ones are not. In contrast, academic freedom is a guild right, not a constitutional right. If free speech is the right to express one's ideas, however true or false they may be, with academic freedom, in teaching and research, facts, evidence, and accuracy all matter. With academic freedom comes academic responsibility in the form of professional competence developed over years of specialized training. Right, so if I stand in front of my house with a sign that says, "The world is flat, nobody's gonna come arrest me, I've got my basic First Amendment rights." If I am a geology professor and I walk into my Geology 101 classroom with that same sign and spend the entire term endorsing the flat earth thesis, that's a problem. That is a kind of educational malpractice that would not be protected by academic freedom because it violates the norms and standards of the discipline. Okay, so let's turn our attention to threats to free speech and academic freedom on campus. And we're going to focus on two of them, one from outside of the academy and one from within. That's Florida Governor Ron DeSantis. Let's see, to his left, that's Christopher Rufo, the conservative activist. So from outside the academy, we've got this culture wars movement to combat so-called woke indoctrination in public schools, including in public colleges and universities. This movement has been galvanized by conservative media as well as conservative think tanks. Florida is really ground zero for this culture wars assault on public higher education. It's one of 7 states, along with Iowa, Oklahoma, and Tennessee, that have passed laws restricting what can be taught in public colleges and universities. And the Stop Woke Act, signed by Governor DeSantis in April 2022, is the marquee piece of legislation. Last year, Amna and I completed a fellowship with the University of California National Center for Free Speech and Civic Engagement, where we investigated the effects of the Stop Woke Act and other laws targeting higher education in Florida. As part of that research, we conducted interviews with more than a dozen faculty members at Florida's public universities. Now, it's important to note that the Stop Woke Act is currently subject to a preliminary injunction, pending appeal from the state of Florida. Amna and I co-authored an amicus brief with a great deal of help from some pro bono counsel, supporting the plaintiffs who are challenging the law. Now we both know more about Blue Book citation rules than we ever hoped we would have to learn. The Federal Appeals Court for the 11th Circuit is slated to turn their attention to the case at the end of January in the new year. So what's the Stop Woke Act all about? The law basically stipulates that students in Florida's K through 20 public education system, right, from kindergarten to college universities, cannot be subjected to instruction that espouses or advances 8 blacklisted concepts. The Stop Woke Act is an eerie combination, bless you, an eerie combination of Orwell and Kafka, University of History, Florida history professor Jeffrey Adler told us. There are mandates about what we're not supposed to do and about what we're not supposed to say, but the specifics remain frustratingly amorphous. Frank Fernandez, an assistant professor of higher education and policy, higher education administration and policy at the University of Florida, said the law is vague, but the message is clear. And the message is that faculty members should avoid topics related to race, racism, and social inequality. Despite this injunction I mentioned before, the law has already had chilling effects, negatively impacting teaching in areas ranging from African American studies to psychology. And many faculty, we heard from many faculty, especially those lacking the protections of tenure, who have changed their syllabi and are self-censoring in order to avoid falling afoul of the law. It seems to us that when professors are intimidated, students are the big losers. Here's how Fernandez described this dynamic for students in his field. One cannot graduate from a higher ed administration program without encountering critical race theory. I don't care whether you personally believe it, but you need to be familiar with it. I feel like it would be educational malpractice on my part if I did not teach theories or perspectives that are recognized as important and foundational knowledge for students to be aware of, to do research and get jobs. Now, the Stop Woke Act engenders all sorts of teaching problems in this regard for faculty in the humanities and social sciences. So let's just take one of the prohibited concepts, which is number 6. You can't endorse or advance this concept. Quote, a person by virtue of his or her race, color, national origin, or sex should be discriminated against or receive adverse treatment to achieve diversity, equity, or inclusion. This provision basically prohibits the discussion of any material that is pro-affirmative action in a university classroom in Florida. How are students supposed to debate and analyze this vital public policy issue? They couldn't even talk about the recent Students for Fair Admission Supreme Court decision. The absurdity of the Stop Woke Act is further illustrated by the guidance that Florida's public universities provided to faculty after the law was enacted. At North Florida College, for instance, the college's attorney warned that a professor teaching a class on US history and Jim Crow laws could not tell students the historical fact that white people were responsible for enacting these Jim Crow laws. It might potentially violate the 7th concept on the Stop Woke Act's blacklist, which prohibits instruction that advances the notion that a person bears personal responsibility for and must feel guilt, anguish, or other forms of psychological distress for past actions committed by people who share their same racial background. Defending the Stop Woke Act's constitutionality, the state of Florida is arguing that faculty speech inside the classroom is government speech. If you're asleep, please wake up. This is a remarkable argument, right? Faculty speech inside the classroom is government speech. And here's what they said in a recent brief, and I quote, "All the act does is prohibit the state's educators from endorsing the enumerated concepts while teaching the state's curriculum in the state's classrooms on the state's time in return for a state paycheck." This to me sounds like a communique from North Korea's Ministry of Education. Challenging this government speech claim on First Amendment grounds is the crux of the 2 ongoing lawsuits against the Stop Woke Act. Amna and I talked to Ellen Schrecker, who's a professor emerita at Yeshiva University, a leading expert on the history of McCarthyism in universities. She said that what's happening in Florida today is worse than what happened under McCarthy. She said the Red Scare of the 1950s marginalized dissent and chilled the nation's campuses, but it did not interfere with such matters as curriculum or classroom teaching. The Stop Woke Act is only one of many alarms and initiatives many alarming laws and initiatives coming out of Florida. And why does Florida matter so much? As Andrew Gothard, president of the United Faculty of Florida Union, put it in a recent interview, unlike Vegas, what happens in Florida doesn't stay in Florida, right? So with Florida as a beacon, other states are pursuing copycat legislation in the same chilling vein.
So I'm going to take over now and talk about threats to academic freedom and free speech on campuses that are coming from within academia. Last February, Jeff and I wrote this piece, which was published in the Chronicle of Higher Ed, and it was called, "Yes, DEI Can Erode Academic Freedom. Let's Not Pretend Otherwise." Naturally, as you can imagine, we didn't make very many friends when we put this out there. So in this piece, we introduced the term DEI Inc., to give a name to what we see as typical approaches towards diversity, equity, and inclusion on college campuses. Now, before we actually go on and define DEI Inc., I think it's important to clarify that we're in favor of diversity, equity, and inclusion as values. But we're not in favor of what we're calling DEI Inc., which is the specific way in which these ideas have been articulated in administrative language and institutional policies. And even though we're very, very fierce critics of DEI Inc., I just want to say that we firmly stand against diktats to end DEI programming as is happening in Florida. So that's a whole separate kettle of fish that I'm not addressing right now. So what do we mean by DEI Inc.? Well, DEI Inc. is a lingo, a logic, and a set of administrative policies and practices. Well, here's the logic. Education is a product, students are consumers, and campus diversity is a customer service issue that needs to be administered top-down. DEI Inc. purveys a safety and security model of learning that is highly attuned to the idea of harm. The currency of harm is especially valuable in our age of inclusion and belonging, and these are words that I'm borrowing from these DEI initiatives, where colleges and universities make grand promises to create environments in which any individual or group feels welcomed, respected, supported, and valued. Now, we'll come back to this later in the presentation. Lived experience, the intent impact gap, microaggressions, trigger warnings, inclusive excellence, you know the language of DEI Inc. when you hear it. It's a combination of management speak and consultant buzzwords, social justice slogans, and therapy speak. So the standard package of DEI Inc. Administrative initiatives should be familiar. It ranges from anti-racism trainings, diversity trainings, to bias response teams, mandatory diversity statements for hiring and promotion. It runs the whole gambit. But in the interest of time today, what we're going to do is focus only on the framework of harm that underpins the DEI Inc. logic. We contend that the discourse of harm erodes free speech and academic freedom, which in turn seriously infringes on the freedom to teach and learn. So many of you may be familiar with this case, and I won't go into a lot of detail, but I think I'll just run through some basic points. So at Hamline University, the reason we're kind of referring to this case is because it's an ideal case study to show where this conflict lies. Adjunct art history professor bears mentioning, in the fall of 2022, teaches a course on global art history, and as part of that includes a painting, a 14th century painting of Prophet Muhammad. And this was an optional exercise where she warned the students in the syllabus, but also in the class before showing it, that if this offends anyone's religious sensibilities, they could turn the screen off. This was a hybrid class, and that she'll announce it and they can turn it back on. Despite this, one particular Muslim student chose to see this and complained that this was offensive to her Muslim sensibilities. The student complaint set the DEI bureaucracy into motion. The Associate Vice President for Inclusive Excellence made a public statement calling the classroom exercise, and I quote, undeniably inconsiderate, disrespectful, and Islamophobic. The president and the VP of DEI then went on to send out an open letter to the campus asserting that, and I'm quoting again, appreciation of religious and other differences should supersede when we know that what we teach will cause harm. And in particular, respect for the observant Muslim students in the classroom should have superseded academic freedom. The president explained that her decisions were guided by, and I quote again, prioritizing the well-being of our students, especially by minimizing harm. So the case continued, and after the professor sued Hamline University, the president walked back the claim that what she did was Islamophobic. The AAUP investigated Hamline and concluded that Professor Prater's academic freedom was indeed violated. The faculty passed a vote of no confidence in the president, and the saga continues, with the president to date insisting that there was no breach of academic freedom at Hamline. So the case really honestly speaks for itself. You don't need much commentary from me. It shows how this flat discourse of harm undermines academic freedom and encroaches on pedagogical choices of faculty. Now, I'm going to speak as a historian. It makes the teaching of history impossible because most of our primary sources often have offensive language. And mind you, it's not just the humanities and, the social sciences that are going to suffer. With this kind of language of harm and offense, it won't be long before a Christian evangelical student objects to evolution being taught in biology classes. So the irony that I want to underscore over here, which is what I weighed in on personally in this controversy, is that the very office that is supposedly supposed to be promoting diversity, equity, and inclusion is the one that was responsible for flattening and erasing the diversity within the Muslim tradition and Muslim community when it comes to the question of photographs or images, not photographs, but images of Prophet Muhammad being shown. So here's what we're saying. We're saying DEI is in effect at most college campuses across the country. In the aftermath of George Floyd's murder, administrators eager to be seen to be doing the right thing embraced DEI Inc. with renewed gusto. Now, what could be, I'm going to sound cynical, but what could be more convenient from an administrative perspective than making statements, hiring diversity officers, instituting anti-racism trainings, and rehearsing diversity talking points generated by corporate consultants? But as Tyler Austin Harper, Assistant Professor of Environmental Studies, posted on X, formerly known as Twitter, the bet universities made when they began issuing official opinions on current events was that all future events would be morally unambiguous, like school shootings. Colleges set themselves a trap anyone with a brain could have foreseen: the morally ambiguous geopolitical crisis. And it hasn't taken long, The recent campus kerfuffles pertaining to the Middle East crisis have indeed revealed the utter inadequacy of this neoliberal customer satisfaction framework of DEI Inc. Presidents and deans have been caught in a bind as students have looked to them to make institutional statements. Many schools, including Harvard, Stanford, Indiana, and Northwestern, had to issue follow-up statements when their initial messages prompted outrage among Jewish students for not going far enough in their condemnation of Hamas. As expected, a number of Palestinian student groups responded by saying that they no longer felt safe on campus. So this idea of safety should be front and center over here. A pro-Palestinian group at the University of Arizona canceled a protest because it felt it could no longer move forward safely after the school's president declared pro-Palestinian statements as antithetical to the university's values. Chapters of Students for Justice for Palestine at several schools, including George Washington University, San Diego State University, deemed their president's statements about the war as direct attacks on their communities and accused the schools of failing to, I quote, acknowledge the emotions and well-being of Palestinian and Muslim students. Donors too have exerted pressure. At Harvard and UPenn, some prominent Jewish donors have severed their support to protest the response of university administrators to speech they consider anti-Semitic and anti-Israel. The situation has further escalated, with some Jewish groups and political leaders demanding that SJP chapters be banned from campus for providing material support to terrorism, to Hamas. And as Nadine pointed out this morning, and also in her wonderful article, and I'm going to quote, the government may not restrict speech solely because its message is hateful or hated, or because it might indirectly lead to some future harm. Students have the right to express support for Hamas, just as they had the right to express support for North Vietnamese in the 1960s and the Communist Party in the 1950s. To be clear, we are referring here to speech that does not meet the emergency standard, which is different, it has happened on some campuses. So DEI Inc., which undergirds the impetus for institutions to take political positions, is clearly chilling speech on campus. From limiting the academic freedom of faculty to constraining the speech rights of students, DEI Inc. is failing higher education. As Jeff Schullenberger put it in a piece for the Chronicle recently, the current campus controversy about the situation in the Middle East has thrown into sharp relief the paternalistic role universities have arrogated for themselves as protectors of vulnerable groups, often at the expense of any coherent pedagogical mission. For a while, the contradictions of this mission could be brushed aside. Today, competing demands for protection are making the entire enterprise unsustainable. So, to conclude, a principled defense of academic freedom and free speech requires us to acknowledge and resist threats from across the political spectrum. While we're in no way trying to draw an equivalence between these threats, we are saying that we need to be vigilant against all of them. Thank you.
Thank you, Professor Snyder and Khalid, and Professor Khan, if you would come on up. Thank you.
Welcome, and thanks for having me. The talk today is about bringing our current free speech controversies into a historical perspective. In particular, the perspective raised by the three cases, Gitlow, Abrams, and Whitney. And I'm going to suggest, I may not get to the Whitney part, that's less poorly formed, but we have two weddings and a funeral, two causes for celebration and one that is not so much a cause for celebration. With Gitlow, we're talking about, and here I'm talking about the dissents of Holmes and the concurring opinion of Brandeis. Can we ban ideas? Can we ban an idea as opposed to a threat? Abrams, what counts as the bannable idea? How do you read what people are saying? And finally, Whitney, who can be punished? And I'm going to suggest at the end, or maybe in Q&A, that with Whitney, I'm not so sure about that, in part because it was a concurring opinion. So to start with Gitlow, this is something I've wanted to write for 2 years. You know, I'm a student of memory laws. I wanted to say that CRT bans are memory laws, but Timothy Snyder got there first, and then got absolutely reamed by people, and I've written a couple articles about that. But the thing that I couldn't believe that people didn't write is Holmes and Brandeis should be rolling over in their grave based on these CRT bans, if you believe in free speech. And I want to take this first, just a University of St. Thomas caveat. Yes, Holmes is the Holmes of Buck v. Bell, and he has written terrible decisions, Giles v. Harris about Louisiana's grandfather clause, maybe worse. But when I'm looking at Holmes or I'm looking at Brandeis, I'm looking at the opinions and the dissents as symbols, as iconic moments in freedom of speech. So let's just talk about Gitlow on two levels and what Holmes was rejecting. The first is just ideas and punishing ideas. And my favorite critical race theory ban is Virginia's by Governor Youngkin, who has all this discussion about we want to include critical freedom of thought in the classroom. We want to, the worst thing in the world is to have people tell students what to do. And then here are 8 things that you're not allowed to talk about, including that the work ethic has a racist origin. Again, personal favorite. So if you think about Gitlow, John Caldwell Myers, so okay, take a step back. Gitlow involved a left-wing manifesto, which was circulated. Gitlow didn't write it. He just said, I support it. I agree with the manifesto. He was tried at the trial level, found guilty on appeal. It went up to the Supreme Court, and they managed to narrow it to freedom of speech questions. And he was charged under a criminal anarchy statute. It's kind of interesting. The anarchist who killed President McKinley had apparently listened to a Emma Goldman lecture beforehand, and the idea was we're going to target ideas that directly incite to violence. But what seemed to upset the New York authorities that brought the charges against Gitlow wasn't that particular incident, but communism and Bolshevism, and in particular, the Winnipeg General Strike of 1919, in which the strikers provided police and fire services. It's a threat to state sovereignty in a capitalist society. So this case goes forward, and John Caldwell Myers, representing the state of New York, says, in terms of the ideas of Bolshevism, it's important to kill the snake when it's young. And you can think about banishing the snakes, or Donovan about people should kill their own snakes. But the idea is that we're going to punish an idea not because it's threatening, but because we don't want people believing this. And Holmes's response to that was pretty much, every idea is an incitement, and if there is time, very similar to Brandeis a couple years later, you can't punish that speech. But there's a narrower point, and it's an interesting point in terms of the development of critical race theory bans. In 2022, a number of members of the House of Representatives passed a law establishing the Marxist roots of critical race theory and the threat this divisive ideology proposes to the American public. And there are a set of whereases that basically lay out the Marxian elements of CRT, kind of paraphrasing the theses on Feuerbach. The representatives warn that the CRT doesn't only try to understand the world, it seeks to change it. It suggests that CRT's, quote, dialectical conception of the world might violate the Establishment Clause. It talks about how DEI in effect establishes a dictatorship of the anti-racists, analogous to the Marxist vanguard concept of the dictatorship of the proletariat. Therefore, CRT is a Marxist ideology rising to the degree of a clear and present danger. And here it is just worth mentioning Oliver Wendell Holmes's response in the 1920s when you do have the Winnipeg general strike hanging over just 5 years in the past. If the dictatorship of the proletariat is going to be accepted by the dominant forces of society, all we can say is that, freedom of speech allowed this to happen. It is an entirely different way of viewing the world. And it suggests, why Holmes might be rolling around in his grave. Second point is Abrams. Abrams focuses on what gets banned, Holmes's dissent in Abrams. And let me set up what I want to say with two contextual points. First, and this probably comes from my own fairly strongly pacifist leanings, but World War I has trenches, and trenches need bodies. People are dying. And what Debs and Schenck and Frohwerk and a lot of other people who were eventually charged under the Espionage Act and other sentences did was advocate for draft resistance, because if you don't have the bodies going to the trenches, it's a threat to the war effort. And this is where Holmes and Schenck came up with the clear and present danger case, clear and present danger test. In the second context I want to talk about is Holmes's dissent in Abrams is often just seen as the moment he was awakened to John Stuart Mill, and we have the marketplace of ideas, which is really important. But what I want to focus on is Holmes's statutory interpretation skills. There were two pamphlets in Abrams. The first one basically talked about how President Wilson was a coward and how the bullets sent to the Russians, the bullets being made for the Germans were also being sent to the Russians. Part of the issue was during this part of World War I, the original sin of the Bolsheviks was to leave World War I, to make a treaty with the Kaiser, which allowed the Kaiser to focus on the Americans. For a variety of reasons, the Allied forces occupied parts of Russia, and it created this very complex situation. The second pamphlet said Russians in the United States shouldn't produce weapons. There should be general strikes at munitions factories. And Justice Clark, for the majority opinion, basically said, yeah, we can, one of the charges, I'm sorry, again, I'm getting ahead of myself, was to block the production of munitions. And again, Justice Clark said, totally reasonable. A strike at weapons plants means no weapons for Germany. And I want to suggest when we look at comments about Ukraine, comments about what's going on with Israel, Gaza, there's a tendency to go for these broad readings. That's not what Holmes says or does. What Holmes says, in particular related to this charge about the weapons production, is let's look at what the statute says. The statute talks about crippling or hindering the prosecution of this war, World War I, the war against the Germans. Holmes then notes that pamphlet 1 is actually explicitly anti-German, and that pamphlet 2 even is focused on protecting Russia, not undermining the war against Germany. In fact, a lot of the gist of the pamphlet is that the United States or President Wilson is a coward for focusing on Russia rather than Germany. And Holmes, in two interesting analogies, compares this to a citizen who said, United States is wasting too much money on airplanes, or they're creating the wrong type of cannon, and makes the argument that this type of speech wouldn't be seen as undermining the war effort. And this goes to an interesting quote that comes up in Abrams, probably my favorite part of the dissent, right after the Marketplace of Ideas speech, which is that the theory of our Constitution is an experiment, as all life is an experiment. Every year, if not every day, we have to wager our salvation upon some tendency based upon imperfect knowledge. We don't know what people are saying about Ukraine. We don't know what a given student Justice for Palestine chapter is saying. And maybe we should be a little bit more aware of the limitations of what we know. And here, let me focus on two examples from nowadays. The first is Holder v. Humanitarian Law Project, in which Justice Roberts held that speech acts training for lawful objectives of terrorist groups violated the material support provisions, provided there was coordination. And there's an element, the ACLU put out a statement about speech on campuses doesn't necessarily support Hamas because there is not this type of communication. But I think that the decision should have gone further, and there are some troubling moments in the Roberts majority opinion, or at least moments that don't sit well with who Oliver Wendell Holmes was. So there's discussion that maybe some of these groups, like the Humanitarian Law Project, could help train people in alternative dispute resolution. And the response to this by Justice Roberts is, well, yeah, the PKK, the Kurdish terrorist group, might use the negotiating skills they're taught to gain a short-term peace that could then lead to renewed fighting. It's a kind of a very cynical, negative view of the world. There's no sense that maybe a short-term peace could grow into a longer one. There's no possibility that counterinsurgency strategies can shift outcomes, and maybe the peace is tactical, but maybe it can be grown into something else. Another part, all right, I will skip the other part and just very quickly talk about Brandeis. And the Brandeis argument, and why I'm not happy about Whitney, is as follows, and this is new for me, maybe I got it wrong. Charlotte Anna Whitney gave a speech about lynching. That was the purpose of her speech. She was parliamentarian of the Communist Labor Party of California a few years before that, which the Communist Labor Party of California was connected to the International Workers of the World, that was connected back to the Winnipeg strike. And at Whitney's trial, she was basically charged for her connections with the International Workers of the World, not for the actual speech that she was given. And she was also charged for being a communist and all of that, and Brandeis has a wonderful concurring opinion signed off by Holmes that talks about that, men feared women and burned witches. But at the end of the day, he concurs, and he concurs because he says, I don't know. I don't know if her actions actually help the IWW. And not every member who marches in a pro-Palestinian rally is a member of Students for Palestine. Not every person who is at that rally is a supporter of Hamas, any more than any of the 290,000 people who were in the Capitol on Tuesday support all of Benjamin Netanyahu's policies. And I think one of the things that if you follow, and that's an issue I think that we still need a little work on, and to wrap up, the one shining light in Robert's opinion about material support is the emphasis on coordination. And that when we're thinking about who's guilty of what, we ought to really think about what coordination is and what it isn't. Thanks.
Thank you for your remarks this morning. I'd like to turn it over to Professor Reed for some questions, and then to the audience or those on Zoom.
Olivia, thank you. And I'd like to pose a question first to Amna and Jeff, and that is I'd like to bring both of your presentations back to your source, and that is the AAUP statements going back to 1915 on inquiry and research. And I'd like to, I think there's a strong common denominator running through both of your presentations. And if I might, I would suggest that when I look at the Ron DeSantis legislation coming out of Florida, what I see is a misconstrual of what universities are all about. It is, the legislation views universities as static. They view universities as top-down. They view knowledge as a kind of a fixed set of data, incapable of expansion, creation, or development. And I think that is a deep flaw in the Stop Woke Act. Similarly, with the concern with DEI, the concern with harm, the concern now with speech as a form of harm, similarly chills freedom of inquiry, and again raises serious questions about the ongoing function of a university to create knowledge, to raise difficult questions that drive knowledge. It relies on a kind of knowledge as a fixed set of comfortable givens. Professor Kahn, thank you. And let me pose a question to you. And that is running through your presentation, I think, is the idea that there's a relationship between speech and society. Minds are not blank slates, they have ideas about the world, and these ideas have an impact on the world. And when they have an impact on the world, they directly implicate the distribution and exercise of power. The power structure becomes threatened, and we see efforts to ban speech, to restrict speech, precisely because we see the powerful trying to protect their own sovereign interests. So if you could expand on the relationship of speech and the interests of the powerful, I'd enjoy hearing that. Thank you.
Excellent questions. I think that the DeSantis, Christopher Rufo vision of universities, as you said, and of knowledge as static, as top-down, and so on, is a terrific insight that Amna and I should incorporate. I think there's also the most basic misunderstanding about the nature of higher ed that you see in places like Florida is that classrooms are sites of indoctrination. And so I can say quite confidently that for the overwhelming majority of professors, including those of us in the humanities, all right, who are enemy number one for the Rufo types, our goal in a classroom is not to convey our political positions. So one of the women who filed a lawsuit about the Stop Woke Act is a woman called Adriana Novoa, who teaches Latin American history at the University of Florida or the University of South Florida. And she says, if a student makes a claim in my classroom, my response is not, well, how does that resonate with my pre-existing political convictions or beliefs? The claim is met with questions that are related to the specific disciplinary competencies in a history classroom, right? What's your evidence? What are the sources? So I think that is also kind of a fundamental misapprehension of what's being done in humanities and social science classes. We've all got our politics, but then we've got the rules and regulations that define our discipline. And so I do think there's just a deep level of ignorance about what profs actually do in the classroom and how we think about our pedagogy.
If I can just add to that, I'm just remembering a conversation with Andrew Gothard, who's the president of the union in Florida for faculty. And I remember him saying that, this is a very effective tactic, which is they don't know how university education is done. But the minute you say this is going on, even when it's not going on, you've changed the parameters of the argument because you've already established it as something that has to be countered. So I do think that I think there is a profound misunderstanding of what higher education is in this context. I think there's a profound misunderstanding of public in this context as well. Like it's, the idea that this is state funds and the state should have a say, the taxpayer should have a say, is a warping of the notion of public, because here public is public good. But I also think, it's important to note that I think the impetus of DEI Inc. is, like you rightly pointed out, it's treating universities not as centers of knowledge production, but as kindergartens to take care of wards while they're in the care of the university. And that's really not what we should be focusing on. So yeah, I concur with your comments and really appreciate them.
Yeah, I would just say the power question is a really interesting one. I would add power, fear, and confusion. And if you think about the movement to ban CRT, kind of grows out in part of parents' rights movements also targeting mask wearing at public schools, school opening versus closing. And there are a lot of people who wouldn't ban CRT ever, who were up in arms about the fact that schools were closed, particularly the second year of the pandemic. And I think it's a lack of trust of the establishment. It's a sense that there was an overreach in 2021 about COVID, about the response, how dare you not wear a mask? I mean, the other stuff I write about is mask wearing. So I think that that's part of the problem. Likewise, I think there's a foreign policy establishment that uncritically, writes about the United States and the, wars it takes part of, and really you have people on all sides who are criticizing it. That's why, to me, Holder is such a fundamentally disturbing opinion for its foreign policy understanding. They take Turkey, a country that denies the Armenian genocide, a country that has its own brutal history towards the Kurds, and says, oh, gee, we need to actually allow material support for teaching PKK to actually not engage in terrorism, but do something nice. We need to do that Congress could legitimately do it. It suggests a certain, for lack of better word, this is tying all this stuff together, I guess, a Wilsonian idealism in US foreign policy, an idealism of the person who screamed to, birth of a nation in the White House. And, I don't know, I'm kind of just think that it's always, I think that one of the things when you're thinking about power and you're thinking about it is, and this goes to cancel culture, is that particularly in our networked society, you think the other side is powerful, you think the other side knows everything, you think the other side is out to get you. And I think one of the things that free speech can do is say, maybe that's not true. Maybe there's a way of accepting that there's just a complex world and you have to learn to deal with people who you disagree with. And maybe our social media could nudge people a little bit less in that direction.
Nadine.
Really fascinating panel and great questions. Robert, my first question for you is, I've never seen anybody who constantly smiles uninterruptedly the way you do. And I don't know, it looks like an ironic smile, but maybe it's a beatific one, but I enjoyed watching you as well as listening to you. Woodrow Wilson did one great thing, which is his policies were so terrible for civil liberties that he gave rise to the foundation of the ACLU. And Holder was an ACLU case, which the Supreme Court decided the wrong way, 5-4, with an excellent dissent by Breyer, who's not a great defender of the First Amendment. So when even he dissents, you realize there's a problem with that decision. Robert, I want to thank you for mentioning Brandenburg again. That was the case that this morning David said he thought was wrongly decided. Brandenburg has been the main precedent since October 7th for arguing against pressures to outlaw and otherwise penalize students for justice in Palestine and Jewish Voices for Peace. And members of the public who are unfamiliar with Brandenburg say, well, but they're encouraging terrorism. They're supporting terrorism. Brandenburg unanimously said, and not a single Supreme Court justice since then has disagreed with the holding, that even advocacy of lawlessness and violence is constitutionally protected. You only cross that line via intentional incitement. So those who want to jettison Brandenburg because they don't like the fact that it helped Clarence Brandenburg really have to look at all the other people, including a Black Lives Matter leader whose represented by the ACLU, whose case is now going to the Supreme Court for the second time. For Jeff and Amna, in fairness, I completely support the challenges to Stop Woke Act and all of that, but in fairness, there have been some well-publicized examples of indoctrination in the classroom. And in fact, we had one, according to reports, and I'm skeptical enough to know you can't believe everything you hear, but apparently some teaching staff member, not a tenure professor at Stanford, reportedly separated students into Jews and non-Jews, and even the AAUP said there's something wrong with that violates academic freedom. Now, obviously, these examples are blown out of proportion, but I think we have to recognize that there is some nub of concern there that makes people want to do something about indoctrination. On the DEI issue, Barry Weiss wrote an op-ed a couple of weeks ago saying it's so flawed and leads to so much discrimination, not only against particular ideas, but particular groups of people, including Jews, that she just said we ought to get rid of it. This morning in the New York Times, David Brooks has an excellent op-ed in which he says, no, we shouldn't get rid of it, but we have to radically reform it. So one of my questions for the two of you is it salvageable? I think your answer is going to be yes, based on what you said, but I'd like to hear what specific reforms you would advocate. And number two, Amna, you alluded to the history of when college presidents started issuing all of these statements. I wonder if you know exactly when that happened, because now people take it for granted and they say, well, if you stop issuing statements, people are going to read a negative implication into that you're endorsing whatever it is that you're not denouncing. But it seems to me that it was relatively recently that there was no expectation that they would issue these statements at all, and I'd love to know what the history is.
Yeah, I think there are precedents of statements issued in the past, but I think in our recent history, it really did start with, at least for me, I started noticing it in the aftermath of George Floyd's murder. And then it went on to the Dobbs decision, then the affirmative action decision. But it started very much with students asking presidents to condemn the murder of George Floyd. And I do remember at that point, and it's not just students, it's alumni, it's faculty even who are asking for that. So I think there is a fundamental misunderstanding of what the role of the president of the university ought to be. But your question about, your point about indoctrination and that it is indeed going on in certain cases is well taken. And I think, I think it's blown out of proportion, that's one thing, but that doesn't take away from the fact that we need to do something about it. And I'm very much in favor of reform. It's just not reform that should be coming from the state. It's reform that should be done by people on the inside. And in particular, I mean, if I were to blame someone, I would blame tenured faculty for letting things get this bad at many levels. And I think they really need to step up to the plate at this moment.
How much time do we have, Olivia?
Just a few minutes.
Just a few minutes, okay. Really briefly, I think I would make a distinction, Nadine, between DEI that focuses on issues of access, so programs that are designed to facilitate the educational opportunities for, say, veterans or first-generation students. Personally, I think that those kinds of programs are invaluable. I think the other side to DEI is more ideological. And that's where you get into diversity statements and diversity trainings. And there I actually am pretty pessimistic. I don't think that you can rehabilitate this model because it is so fundamentally flawed and so fundamentally intellectually bankrupt. And I believe that you can see that especially in terms of how we think about the Jewish experience. According to the reigning DEI model, they're white people. They've always existed. They're all the same. They don't have any religious differences. There are no class distinctions. And so my students are completely baffled when I ask them, what was the last ethno-racial group to face quotas at colleges and universities in the United States? And the answer is Jews, right? Up through the 60s in some of our most elite institutions. So I think if you have a model of the world that is so flat and schematic, that doesn't make any attempt to understand ethnic, religious differences within this group called white folks, as a historian, as a social scientist, I just don't see that being productive. I think it's a dead end.
Can I just get in here for a sec? I know, I'm going to smile again. And actually, as a Jew, as someone who's read lots of DEI things, I mean, certainly I understand there are places where horrible things happen. I would say, doing my research about CRT bans, there are lots of horrible things in classrooms that are indoctrination, but not DEI related, often, supporting racism. But I'd say I appreciate that there are places where Jews have been excluded from DEI moments, but there are also books like My Grandmother's Hands, which I'd highly recommend, that in describing whiteness also has a place to describe Jews as part of a group that has a historical oppression going through ages. So I get really nervous when people say critical race theory has X wrong. Critical race theory isn't a thing. It's something constructed by Christopher Rufo. DEI Incorporated, I get it's a model, but there are different DEI efforts made by different people some are good, some are bad, some have a bad day. There are things that should never be done again. I absolutely agree with it. But I guess my point is just there's not enough, be a pointillist, have a detailed picture of the world, with different facial expressions. I'm sorry, I can't frown. Rather than saying, this is what CRT is, this is what DEI is, some of it's good, some of it's bad. Everybody makes mistakes. We should kind of, go with that and understand there are going to be things that we disagree with and we try to change them. Yeah.
Thank you for your responses to those questions. And in the interest of time, I do apologize. We're going to have to cut any remaining questions short. We'll take a brief 5-minute break and then be back in here for our keynote address. Thank you. Well, welcome back, and to those of you just joining us, thank you for being here for the Journal of Law and Public Policy's Fall 2023 Symposium, Free Speech and the U.S. Constitution. We are honored to be hosting our next speaker for her keynote address, Professor Nadine Strawson, for a conversation about free speech issues with UST Law Professor Thomas Berg. Professor Strawson is a chaired professor emerita at New York Law School and a past national president of the American Civil Liberties Union. She is also a senior fellow with FIRE and a leading expert and frequent speaker and media commentator on constitutional law and civil liberties, who has testified before Congress on multiple occasions. We are so grateful to have her here with us this morning. Additionally, Professor Berg is the James L. Oberstar Professor of Law and Public Policy here at St. Thomas, where he teaches constitutional law, religious liberty, intellectual property courses, and runs the Religious Liberties Appellate Clinic. We are so pleased that you could join us this morning. We'd like to reserve a little bit of time at the end for questions, but until that, the floor is yours, Professor Berg.
Thank you, Olivia. So what a pleasure it is to be able to sit here with Nadine Strawson and have a talk. Her keynote address will be in a form of this conversation, and it's really an honor for me to do that. I just want to say a little bit at the beginning. Nadine Strawson has been a remarkable combination of full-time law professor, public intellectual and writer, and leader of a national organization, which I assume required a lot of time to be involved with organizational matters as well. The ACLU, and a really vitally important and also, I think it's fair to say, sometimes fractious organization. Yeah?
Tom, that pales in comparison to your being an accomplished scholar and teacher and musician and performer.
Okay. Well, thank you. She researched me. You don't really need to research Nadine as much because she's very well known, and rightly so. But those three things, I don't want to go on here, but those three things done in one life of law professor, public intellectual, and leader of the ACLU would be quite an accomplishment. She did them all three at the same time for 2 decades at least, so it's quite remarkable. Wikipedia says that we share the same birthday, August 18th. Is Wikipedia right on that, or is this like a deep fake on your birthday? And just very briefly, you also had some time in Minnesota practicing law. Can you just tell us a little bit about that?
Even though I was born in New Jersey, which I always used to emphasize when I would meet with Justice Brennan, who was a Jerseyite, but every time I was with Justice Blackmun, I emphasized that I grew up in Minnesota. My father was transferred here when I was 8 years old, so I attended and graduated from what was then and is again the Hopkins High School, where I had just the most phenomenal education in a great public education system. And in particular, I had teachers who instilled habits of critical inquiry, questioning, exploration, debating. Literally, we had an outstanding debate program and an outstanding debate coach, to the extent that I've now been raising money to create a scholarship, an endowed scholarship in the name of my high school debate coach and his wife, who was a very revered elementary school teacher. And it's a scholarship that I'm looking forward to coming out here to present to a couple deserving students next summer.
Great. Well, welcome back this time. I know you've been back many times, but really, we're really happy to have you. So let's get started. You've been writing and speaking about freedom of speech, maybe nonstop or almost nonstop for quite a few years. Why is this such an important priority for you? How did it start and so on?
Thanks, and Tom and I agreed that we could be on a first-name basis with each other. So Tom, thank you for that gracious introduction. Same to you, Olivia, an excellent question. I continue to be passionately committed to the entire agenda of the ACLU, and I should also add the international manifestation of it. Until I became ACLU president, Tom, I was very active. I was on the board and executive committee of Human Rights Watch, which is a preeminent international human rights group. And basically, the missions of both organizations, one can debate whether we actually fulfill them in particular situations, but the mission is to defend and support all fundamental freedoms for all people, no matter who you are, no matter what you believe. By virtue of your humanity, you're entitled to basic human rights. I completely support that, including equality of opportunity, every right that you can name. And I have become more and more convinced that without a robust freedom of speech, we are never going to be able to advocate and defend any of those other rights. And just as freedom of speech throughout history to this day has been the essential engine for promoting any other cause, whether it be racial justice or gender justice, even for dissenting from freedom of speech and critiquing it. No matter what your cause is, you depend on freedom of speech. It became clear to me starting in about 2015 with the rising ferment on college campuses, which I completely welcomed in one sense, having been a student activist in the 1960s and 1970s, I was disturbed about the passivity of college students in intervening decades. Surveys showed that students generally weren't even interested in public issues, let alone becoming involved in and influencing them. So with the tragic killing of Michael Brown in Ferguson, Missouri in 2015, we started to see a sweeping rise and spread of activism in support of racial justice on campus. That was very positive, but very quickly it was accompanied by a demonstrable hostility toward free speech. At the University of Missouri itself, some of you may remember, even student journalists were ousted from covering the protesters. A journalism professor physically accosted a student journalist, and you started to hear all kinds of denunciations of free speech as somehow being antithetical to the social justice causes that these students were advocating. So it was clear to me that those of us who saw that free speech was supporting these causes as well as any other cause, that we had not made that argument persuasively enough, and I decided I had to devote myself to that through speaking and writing, and I've been happy to do that, and thank you for giving me, I welcome every platform, so thank you.
So let's just go into that a little bit more in the context of campus controversies, hate speech, questions of hate speech, and so on. The reaction or objection is that you've got free speech and you've got equality rights, and both of these are in the Constitution. And to strike down hate speech restrictions is to privilege free speech over equality rights, and the court has done too much of that. And so how do you respond to that framing of it or that objection?
Thank you very much, Tom. That is one of the questions that it's such an important question, and therefore I get it over and over. I do not privilege equality, free speech over equality. Most importantly, the United States Supreme Court does not do so. One of the common misunderstandings about First Amendment free speech law, and those of us who support it, is that the law is absolute, that it admits of no exceptions, that it privileges freedom of speech above everything else. And indeed, that those of us who support free speech won't even acknowledge that it can do any harm, including by undermining equality rights. Nothing could be further from the truth. The more I have steeped myself in First Amendment law, as I certainly did for a book that just came out last month, Free Speech, Everything, What Everyone Needs to Know, the more I have steeped myself in that law, the more I recognize that it greatly overlaps with common sense. And the common sense is this, that the court has appropriately allowed government to outlaw and punish the speech that is the most dangerous, while also outlawing the censorship, the speech restrictions that are the most dangerous. Amna Khalid already referred to what is often called the emergency principle, going back to some of the great dissents by Holmes and Brandeis that Robert Kahn referred to, that government may restrict speech when there is such a tight and direct connection between the speech and some imminent direct harm. The only way to prevent the harm is by restricting the speech. Another way of describing that exact same approach, but looking at it from the other perspective, not what the harm is, but what the solution is. All of you students who have taken constitutional law are familiar with the concept of judicial strict scrutiny. And you understand that even the most fundamental rights, including equal protection and including freedom of speech and free exercise of religion for that matter, they're not absolute. Government may restrict them if the restriction is necessary to promote a countervailing goal of compelling importance. And certainly another constitutional right, including equal rights under the Constitution, constitutes a goal of compelling importance. Let me also parenthetically say, this is the same test under international free speech law under Article 19 of the International Convention on Civil and Political Rights. So this is not American exceptionalism, as is often said. But if a restriction on speech is necessary to promote equality as well as to promote safety, then the restriction not only is justified, it's the government should enforce the restriction. And that's why, for example, laws against discriminatory harassment are completely constitutional. I was just yesterday saw a complaint that had been filed the day before against NYU, an 83-page complaint arguing that NYU has fostered discriminatory harassment against its Jewish students. I have no idea how sound the factual allegations are, but if the allegations are proven to be true, and the standard is met for, intentional, targeted, pervasive, and severe discriminatory expression against Jews that so undermines their equality of educational opportunities on that campus, that speech is not protected. What I object to, and more importantly, what First Amendment law objects to, is a looser connection between the hateful speech and any demonstrable harm. What we used to have before Brandenburg in 1969, which was called the bad tendency test. Any speech that might indirectly potentially lead to harm including undermining equality, could be restricted. And by giving the government that much latitude, it's not surprising that it was Martin Luther King and Frederick Douglass and suffragists and anti-war protesters and dissidents of every stripe who were suppressed under that looser language. By definition, if you're a member of a political or an identity minority, you're going to lack majoritarian power, and the government that is directly responsive to the majority of its constituents is likely to find that your speech satisfies the bad tendency test. Again, Robert Kahn cited Holmes's famous statement that every idea is an incitement. So not only does the law now do the right thing in allowing hateful speech that does directly undermine equality or safety, it is allowed to be suppressed. But if we gave the government more latitude, we can predictably say it would be used to undermine advocacy for equality.
So you mentioned the International Covenant, but it's also the case that at least a number of Western countries in Europe have broader hate speech laws that are sort of upheld. And how do you think about that? Are those countries less free than we are? Is there something about America that justifies going in a different direction? Is this a clear superiority in our case because there's obviously a different judgment made by those countries?
So I really do want to come back to a very important point that is not nearly as well known as it should be, which is there is only one truly international law of free speech, and that's under the United Nations instruments, which have been ratified by virtually every country in the world, just a handful of exceptions. It is absolutely true, Tom, that there are domestic laws in every other country around the world, as well as some regional free speech law, for example, under the European Convention and the American Convention. But experts in international human rights law, including David Kaye, a law professor in California, who was the most recent United Nations Special Rapporteur on freedom of speech and expression, has criticized not only many other countries, but also regional human rights courts, including the European Court of Human Rights, for violating the more speech protective standard under the truly international law to which they have subscribed. But, laws are, including our Constitution and our First Amendment free speech guarantee, are only words on a piece of paper. I mean, our free speech guarantee for most of our history was either under-enforced or unenforced. So those of us who advocate free speech have been trying to make that point. But when you look at what's going on in other countries, let me just give the example of what's happening now. Many, many European countries have flat out banned any expression of support for anything relating to Palestinian causes. We're not talking about advocacy of terrorism. We're talking about a two-state solution, and also have outlawed any demonstration that is critical of Israel in any way. Now, I have to say, I'm a Zionist, I support Israel, so I'm making viewpoint neutral points, but I find it appalling that in London and in Berlin and in Vienna and in Paris, people have been arrested for simply, waving the Palestinian flag or for wearing a keffiyeh. That to me is completely inconsistent with freedom of speech and equality and democracy. Now, are these countries where people they're not necessarily being thrown in prison? Although I say not necessarily because, I know Robert Kahn is a great expert on Holocaust denial. He knows that people do get imprisoned for denying that the Holocaust took place or for questioning certain details about it. To me, you know, I'm not going to say living in Germany or France is like living in a totalitarian country, but I would not want to live there for those reasons. And I know many journalists are very frightened of criticizing government officials because the defamation laws there are so punitive. And you know, many of my friends from those other countries say that Americans tend to take for granted our freedom of speech because we have the privilege, talk about privilege, of not being used to a society in which you can be punished for what you said. In my lifetime, though, there was experience of people being, I was a child during the McCarthy Cold War era, and people were being imprisoned and blacklisted and punished terribly simply for expressing support for some tenets of socialism. So the history isn't that ancient in this country of paying a great price. And therefore, I do not take for granted Brandenburg and other speech protective decisions.
So yeah, let's follow up a little. I mean, obviously, the Palestinian and Israeli conflict is on everyone's minds and hearts now. And so in the United States, a person who in front of a crowd says Hamas was absolutely right to do what it did in its attacks on Israel, and says that in the most pointed way, would be protected by Brandenburg. You know, so not just waving the Palestinian flag, obviously. So where should the line be in this context? And then maybe I'll follow up. Criminal prosecution is one thing. The students who have signed on to various petitions supporting the Hamas attacks are being interpreted that way. Some have lost their jobs that they've had. They've been put on sort of shaming lists and so on. That raises questions about what do we mean about a culture of free speech beyond just government prosecution. So maybe that's a compound question.
It is.
Where should the line be in terms of Brandenburg prosecutions, and then maybe we can start talking about these sort of culture
Two
questions.
really important questions. So the first one is, when may government, including public universities, punish students and others for crossing the line between protected and unprotected speech? I already gave one example, Tom. If the facts are proven that expression that constitutes part of a severe and pervasive creating a severe and pervasive, objectively offensive, hostile environment that undermines equal educational opportunities, that's one example of speech that could be punished. By the way, when I emphasize the facts, all of these standards are intensely fact-specific. The core viewpoint neutrality principle means that we may never punish speech solely because of disagreement with or disapproval of the viewpoint. But once you get beyond that, speech with a hateful or pro-terrorist viewpoint, if it satisfies a contextual standard for hostile environment harassment, for intentional incitement of imminent violence, and then let me give you another one which has sadly been relevant on campus, a true threat. And we lawyers use the adjective true to distinguish it from the looser way that we use the word threat in everyday speech. I've heard students say, I feel threatened by the fact that a conservative speaker is going to be on my campus. That does not make it punishable speech. But a true threat, which the Supreme Court actually recently narrowed the definition or focused it more, is when the speaker is targeting a particular individual or small group, identifiable group of individuals, and either recklessly or intentionally instills a reasonable fear that they are going to be subject to harm. That is a punishable true threat. And very importantly, the speaker does not have to intend to carry out the harm. It is considered to be harmful enough to have a reasonable, that is, objective fear, because that already hampers your freedom of movement. not to mention your freedom of speech. And sadly, there are allegations abounding on multiple campuses that that standard has been satisfied by particular factual scenarios. Perhaps let me mention a couple that have been very widely publicized. One already led to an arrest and a criminal prosecution in federal court of a student at Cornell who went online and posted not only virulently anti-Semitic pro-Hamas statements, they could not be punished simply on the basis of their despicable content, but in the context, the student also aimed the remarks at identified Jewish students on campus who were having their meals at a kosher dining facility. You had the FBI, local law enforcement, campus police, and the US attorney for that part of New York agreed that that satisfied the true threat standard, and they've instituted a criminal prosecution against him. There are also reports, and I've seen a videotape. Now, I know videotapes can be doctored, but so it raises a prima facie case worthy of investigation, but we should be open-minded about what the facts will ultimately disclose. But it shows an Israeli student at the Harvard Business School who is walking in the vicinity of some students who are having some kind of pro-Palestinian demonstration. And you see them, surrounding him and circling him at menacingly close distance and saying things like, "Get out," and other insulting language toward his national origin and his religion. That seems to me to quite arguably pass the boundary of protected speech to become an unprotected threat. And let me make this point, Tom, because it's I think First Amendment advocates are not used to making it, which is freedom of speech depends not only on government not punishing constitutionally protected speech, it also depends on government punishing constitutionally unprotected speech, because speech is a double-edged sword. As many speakers, including David Schultz, who has now rejoined us, have made the point that speech can have an intimidating impact on people, and if you are subject to a genuine true threat or intimidation, your own free speech is going to be chilled. So I think it's really important that when discipline and even law enforcement responses are warranted, that they be pursued.
So then what about the second question about other kinds of sanctions that are not government sanctions, and the whole question of cancel culture, where people lose their jobs or are other kinds of losses like that for what they say. Is that a free speech issue? Is most of that counter speech, as a lot of folks would answer? Where do you draw the line?
Very, very important question, and a very difficult one in the sense that I think this is not a binary yes or no question, but really, really depends on complicated matters of judgment that depend on all of the facts and circumstances. So to be very clear, most examples of cancellation and so-called cancel culture do involve exercises of free speech, what we often call counter speech. I wrote a book in 2018 called Hate: Why We Should Resist It with Free Speech, Not Censorship. I am expressly advocating counter speech with the goal of suppressing hateful expression. That is a form of cancellation. But let me pose this question, which is actually the title of an op-ed that was written quite a few years ago by Suzanne Nossel, who is the CEO of PEN America, a wonderful organization that works at the intersection of literature and free speech. And the headline of her op-ed, the title was, "When Does Counter Speech Go Too Far?" And it's a matter of judgment, but those of us who oppose what we call a cancel culture, individual cancellations may well be justified in particular facts and circumstances, but what we're concerned about is a culture that is so harshly, disproportionately punitive that it ends up not only silencing, extreme white supremacist hate mongers, but also intimidates the vast majority of us, and surveys show that what I'm saying is factually accurate, from even expressing mainstream, popularly opinions that are supported by the majority of the population for fear that it will be perceived or misperceived as offensive or insensitive and expose us to accusations of, as one of my friends put it, being some kind of an ist or some kind of an obe. And surveys continue to show that all across the ideological spectrum, people are self-censoring. They have a free speech right to do it, but self-censoring even from addressing the most important topics, including race and gender and abortion and police practices, including on college campuses. And that's what I call a cancel culture. It's a matter of judgment. This concept of proportionality is something that is really important in Eighth Amendment law about cruel and unusual punishments as well. And so I urge applying the same nuanced standards in the current context that I've been urging in other contexts, other debates about cancel culture. I wrote an op-ed, I'm not sure if it's been published yet, in which I oppose the categorical statement, they have the right to do it, but I just think it's not a good idea, of various law firms and other employers saying they would not hire any student who belonged to one of the 34 student groups at Harvard who signed onto a statement that I consider to be an appalling statement that I think was, insufficiently, didn't even recognize the brutality of the Hamas terrorist attacks, but they had a right to do that. The employers have a right to say they're not going to hire them, but I was urging and do urge a more nuanced approach that isn't so categorically engaging in the kind of guilt by association that we saw in the McCarthy era, right? When anybody who even supported or was associated with somebody who was a member of the Communist Party, and many people were members of the Communist Party because it was strongly against Jim Crow and not because they advocated overthrow of the United States government. And I would say the same thing here. There are some students who undoubtedly, of those 34 student groups, didn't even know that the group that some of them probably forgot that they belonged to the organization. If they did, they probably weren't aware of the statement that was issued by the organization. After the statement was issued, they might have resigned from the organization or protested the statement. So I would urge employers, rather than just saying we're not going to hire any of those students, to use it as an opportunity to investigate the individual actions of individual students, and also consistent with a big movement we've had in this country, which I fully support, towards so-called restorative justice, right? We recognize we've had an overly harsh criminal justice or injustice system that even conservative Republicans are saying, even people who have been convicted of homicide, maybe we ought not to treat them in such a harshly punitive way. Maybe it's more constructive to engage in a restorative justice approach. Well, if we can do that for somebody who has actually committed a violent act, I would say even more strongly, as we lawyers say, a fortiori, can't we have that same kind of forgiving, hopeful, educational approach towards somebody who is advocating violence?
Let's shift gears a little bit. How would you apply the free speech standard to the speech that former President Trump gave on January 6th, which is part of the evidence in at least one of the criminal prosecutions against him. How do you analyze that? Did it cross the line?
I don't know all of the facts, and because it is such a fact-specific standard, I will simply recite the facts that I know that have been cited by folks on both sides, although so again, it's the Brandenburg test, intentional incitement of imminent violence that is likely to happen imminently. And while you consider what Donald Trump actually said on January 6th, which means the full details, you can't just cherry pick the most inflammatory statements and the full factual context. Please also bear in mind a case that, as I alluded to earlier, is now going back to the Supreme Court for the second time, which I think raises exactly the same legal issue. The ACLU is representing Delray McKesson, who was a leader of the Black Lives Matter movement. He was giving a very rabble-rousing anti-police violence, anti-police speech in Louisiana a few years ago, during which somebody attending the march threw a brick and struck a police officer. Obviously, the person who hurled, and the police officer was injured. Obviously, the person who hurled the brick is directly accountable and criminally punishable, just as those who engage in the actual violence and lawlessness on January 6th are undeniably directly accountable. But the question is, was McKesson's speech, as has been argued and lower courts held, that he should be held culpable for having intentionally incited this brick thrower, and Donald Trump, the argument goes, should be held culpable for having intentionally incited the rioters on January 6th. The one court, to the best of my knowledge, that has ruled on the Trump case has held that the facts recited in a complaint, it was a civil conspiracy complaint to violate various federal laws that was brought by members of Congress, and there was a motion to dismiss on First Amendment grounds, and the judge rejected the motion to dismiss. Now, for those of you who are remembering, as I'm thinking on my feet about civil procedure, that doesn't mean that the judge conclusively found that the Brandenburg standard was satisfied, but the judge did find that there was a plausible enough claim that Brandenburg was satisfied that he was not going to dismiss the complaint. So Trump made very inflammatory statements, but he also said, go in peace, remember that? And I think he was very well advised by his lawyers, because a few years earlier, there was a case in the Sixth Circuit coming out of Donald Trump's 2016 presidential campaign. In one of the pro-Trump rallies, there was an anti-Trump demonstrator, and Trump said to his supporters, get him out of here. And the supporters allegedly assaulted the anti-Trump demonstrators, who then sought some kind of legal remedy, not only against the assailants, but against Trump himself. And that was decided by a judge. And the judge said, well, Trump did make some pretty inflammatory statements. Clearly, there was a result of assault, but Trump also said, don't hurt him. And the judge said that tips the balance. This does not satisfy the Brandenburg standard. So I think Trump had that in mind, quite frankly, on January 6th when he said, but go in peace. That may well save him under the Brandenburg test.
This may be drilling it into it a little, maybe too much, but we're legal nerds here. The speech is arguably here in the context of an overall scheme to stop the counting of the votes, which included certainly a bunch of unprotected actions as well, if you believe that those allegations are true. Does that make a difference? If some of the acts of the conspiracy, assuming that there is a conspiracy, an alleged conspiracy, include those speech acts, as part of an overall plan to stop the election? Or
Every single fact is relevant, which is why I said I'm going to be agnostic. I'm following the Holmes-Kahn approach of I don't know enough at this point. But that would certainly be a relevant detail, although I would also be concerned that some of that expression seems to me to be clearly political expression, and to make allegations and assertions about whether the election was rigged or not seems to me very important to protect that, even if we disagree with the viewpoint, because in a democracy, there's no speech more important for we the people than to debate about the bona fides and integrity or lack of integrity of an election process.
Underlying some of the concerns about disinformation, political disinformation, including both in the COVID context and the 2020 election, I think is a question about whether the marketplace of ideas metaphor works. Does the marketplace of ideas work? Is technology changing that to the point where we can't really trust counter speech to work? What would you say to whether the marketplace of ideas metaphor remains valid today as a premise for strong protection of freedom of speech?
It does remain valid, and I'm sorry I don't have the exact language. It's already been talked about today. Many people wrongly assume, and I'm not saying this about you, Tom, but many other people wrongly assume that Holmes or others that have invoked that metaphor have said, oh, the marketplace of ideas will lead to truth. He said no such thing, nor has any user, invoker of that metaphor ever said any such thing, to the best of my knowledge. If you look at Holmes' exact language, it's basically to the effect that it's a less imperfect, less flawed, less dangerous approach than entrusting powerful governmental officials to decide what's true and what's false. And I continue to have much more distrust for powerful governmental gatekeepers than I do for the marketplace, i.e. my fellow citizens and government officials of all stripes debating it in the sphere of social media and online platforms. I mean, the whole science, this goes back to the concept not only of free speech, but the concept of academic freedom that Amna and Jeff talked about, the whole scientific method, because this is specifically relevant to COVID, depends on letting all the evidence out, letting all of the analysis out, precisely so that it can be subject to debate, to disproof as well as proof. How can we have any confidence in whether something is true if counter evidence and different interpretations and hypotheses are not allowed to be there? And certainly when we're talking about speech about electoral issues, it seems to me the last thing we want to do is to let government, that is, the officials who then have the power of the majority behind them, to decide what is true and what is false with respect to politics. Of course, predictably, officials are going to use that power to suppress criticism of their policies, whether it's COVID policies or whether it's electoral policies. We've seen this around the world. Different countries have adopted so-called disinformation, COVID disinformation laws, and The Economist, among others, has done studies of how those laws have been enforced. And surprise, surprise, anybody who disagreed with a government policy has been accused of disinformation. And I'm sorry to say that has happened in this country as well. There was one COVID disinformation law that was passed quickly after the pandemic came to attention in this country, in Puerto Rico, the ACLU immediately brought a lawsuit to challenge these different disinformation laws on behalf of two prominent, respected investigative journalists. Tom, who said, look, even the most conscientious journalist can't possibly get every detail correct, especially when you're working on a fast-breaking issue. You'd rather get the information out there. If you're waiting to be 100% sure that it's 100% correct, it's never going to get out there. And it's actually most important in a public health emergency to be sure that the ideas can be out there so we can learn what's best for our health, as well as, consistent with free speech. And the processes of justice go rather slowly. So we just got a decision from the judge earlier this year, who agreed with the ACLU that not only was this anti-disinformation law bad for free speech, but it was really bad for public health as well. And one good thing about the passage of time is we now know that what was considered disinformation or fake news, choose your term, early in the pandemic is now accepted, or at least not rejected, and being taken seriously by scientists.
Let's talk about one specific aspect of technology, and that is deepfakes. The definition of deepfakes: hyper-realistic renderings of actual people's image or voice produced by machine learning or artificial intelligence. There is a bill in Congress now I love this, it's a great acronym. It's called the Deepfakes Accountability Act, and deepfakes is the acronym. And deepfakes in the title stands for defending each and every person from false appearances by keeping exploitation subject to accountability Act of 2021. So that translates into the deepfakes accountability.
Backronym, as we say.
Yeah. So these are right. These are false. Clearly false. What can the government do to prohibit those, limit those, regulate those in a way that would counter falsity or nothing?
So again, one really important point that I should make is, as is true for any speech that satisfies the emergency standard or any restriction that satisfies strict scrutiny, the government can and should appropriately punish certain kinds of false speech. Examples that we know of are fraud and defamation. And it's quite possible that much deepfake material will be punishable under those existing punishable categories. Beyond that, I would say this: there's definitely serious danger from this kind of expression, as well as from other constitutionally protected expression. None of us denies the danger. We just argue that it's even more dangerous to give government greater discretion to punish beyond the emergency and strict scrutiny principles. Let me say this, as a practical matter, we are never going to eliminate all of this dangerous speech, whether it's deep fakes or hate speech. We know that even the most totalitarian regime with the strictest speech controls has never been able to completely suppress speech that it considers dangerous. So government can never fully protect us against exposure to, let's just call it, dangerous speech, including deep fakes. Therefore, even if we wanted to completely prohibit it, that's not going to be enough. We also have to take other measures to make us not so susceptible to the dangers that this speech causes. One of my husband is an economist. A friend who's not an economist used an analogy that I like because of the economic association. He said, look, we're focusing, as with every prohibition strategy, and that's what censorship is, right? A prohibition strategy, like the war on drugs. You're never going to completely eliminate the supply of the dangerous substance or of the dangerous speech. And so this communication scholar said, I wish we would focus more on the demand side. By the way, we saw this with disinformation in the Fox defamation lawsuit, right? Most people assumed that Fox was feeding electoral disinformation to its audience, and therefore its audience adopted those views that the election was stolen. But we learned through the litigation that it was exactly the opposite. Fox was saying Trump lost the election. They started losing their viewers who were demanding news that Trump had really won the election. And so Fox unabashedly gave its viewers what they wanted to hear. And what we have to do is educate all of us to not demand, certainly not to demand fake news or disinformation, but also to have a healthy skepticism, be able to learn skills for separating the true from the false, for doing our own research and fact checking. Some of you may have noticed I have just incorporated that in my own worldview. I'll say, I read this somewhere. I haven't had a chance to investigate whether it's accurate, or I haven't learned all of the facts yet. These are habits of mind that we have to instill. And studies have been done by experts in communications and so forth who call it pre-bunking. They say it's much more effective than debunking misinformation or deep fakes after the fact. To pre-bunk, it's a little bit analogous to immunization against COVID or another disease, that you will be prepared to fight it off rather than waiting until after the fact, which is not as effective.
Before we go to questions, I can't resist asking a question about the area that I write in, and that is religious liberty. So this is a question about the 303 creative case, the web designer case, which for those of you who don't know or remember it.
We had two speakers about it already.
Okay, well then maybe we don't need to remind everyone about it. And have you already said something about what your position is? Okay, maybe we don't need to revisit it, but if you want to say anything more about it, this is a case where you disagree with the position that the ACLU took. So maybe you can expand a little bit on perhaps that disagreement, or how you weigh that.
Well, first of all, as David well knows, the whole reason that the ACLU has boards of directors and state boards of directors is so that we can debate each other. And we do that very ferociously. And in my whole history as ACLU president, I can think of really only one issue where the whole national board was unanimous. So we respect that there is more than, how could a civil libertarian not respect more than one perspective? But I was kind of distressed about the strong extent to which, the overwhelming extent, let me put it that way, to which what I think a very clear legal issue in this particular case, and a clearly correct ruling given the stipulated facts. I'm distressed that the ACLU, which litigated after all the very first case in which the Supreme Court held that compelled speech is an even greater intrusion into individual dignity and freedom of choice and freedom of thought, that compelled speech violates all of those values even more than compelled silence. That was West Virginia Board of Education versus Barnett in 1943, the compelled flag salute case. And I'm completely on board with some of the critiques about standing and how the Supreme Court gerrymandered the issue, and how Colorado just ineptly, in my view, from what I know, what I can perceive, stipulated to facts that basically left on the table an issue that is going to benefit everybody who cares about free speech, including, to go to the issue that Amna and Jeff talked about, not being compelled to utter support for one narrow view of DEI. So I wish that people would be more fact-specific in the positions they take on cases. I think people have grouped themselves into ideological tribes, and they saw this as being a case for the other side. And if I can give another example, abortion. I am passionately committed to reproductive freedom. I am also passionately committed to freedom of speech for those who have the opposite view on this issue. And I am distressed at, the ACLU opposed restrictions on free speech for anti-abortion, pro-life advocates. And we couldn't get anybody else in the pro-choice side to join us, even though, to me, their speech also depends on robust freedom. So I wish that more people would look beyond the particular tribal alignments in a specific case to the underlying values and issues, to have the historical humility to understand that it's in a blink of an eye, those principles that now you oppose because they temporarily or immediately are benefiting somebody whose ideology you oppose, in a minute or across the country at the very same minute, those principles are going to come to the protection of your own ideas.
Just can we take it outside of the free speech context for a second? If the objection by the website designer were not, if we didn't have a case of speech, for example, the cake designer it's argued that Jack Phillips was not engaged in speech there, but is designing a cake. Do you extend the same kind of civil libertarian emphasis to a claim based on the free exercise of religion as opposed to freedom of speech when there's not, at least arguably not a strong and expressive component?
I haven't thought that one through, to tell you the truth. I didn't think that the free speech claim was strong in the cake case, and it's been a long time since I've thought about free exercise of religion, but I do take that right very seriously, and I had testified in Congress, in both the House and the Senate, in support of RFRA, the Religious Freedom Restoration Act, when the Supreme Court, watered it down, and I thought that strict scrutiny should still be required to justify restrictions on religion. That said, my inclination, but we know with the disclaimer that I haven't thought this through, my inclination is that strict scrutiny could well be satisfied by if the restriction is necessary to provide equal access to services, to buying products in the commercial marketplace.
Right. Okay, we've got a few minutes and open it up for questions here.
Yeah, thank you both, Professor Strawson and Professor Berg, for your time this morning. I do believe Professor Reed has a question, if we could get him the microphone. Thank you.
Take mine.
Thank you, Professor Berg. Thank you, Professor Strawson, for what a wonderful, wonderful conversation. But I'd like to bring the conversation back to something that you both talked about, and that is cancel culture. And I think what we have right now, what we're dealing with, is a thin conception of private power. We look at the Hollywood blacklist of the 1950s. We all agree that that was wrong, but that was an exercise of private power. We look at the net choice cases making their way up to the United States Supreme Court, and we see there at least the allegations being made that market power was being used to censor certain views. We're seeing this even more clearly now with the Twitter files that Matt Taibbi and others are surfacing. And maybe this is inevitable in a capitalist context, but are there means available to counter what seems to be an emerging threat to free speech, and that is the power of non-state actors to engage in censorship?
These are very important concerns, and I mentioned after you left, Dave, that to the extent that you were making the point that strong legal freedom of speech is not enough to have actual freedom of speech. This is one of the considerations. because of these various private sector forces. I would make a distinction between the first two examples you gave and the last one for this reason, that sensibly, under existing constitutional law, a nominally private sector action, as you well know, if it is in fact the result of coercion by or conspiracy with or even collaboration with the government, is treated as government action. You remember the state action doctrine from constitutional law, and several court decisions now from the Fifth Circuit have agreed with plaintiffs that these social media companies that ostensibly were deplatforming based on their own content moderation policies were in fact doing so because of pressure by the Biden administration and various officials and agencies within that administration that crossed the line from permissible government encouragement, right? Government should encourage private sector companies, private actors, others to take steps that it thinks are for the public interest. But when it crosses the line, again, this is a matter of judgment, as so much constitutional law is, when it crosses the line from permissible encouragement to impermissible coercion, that becomes tantamount to the government directly engaging in the censorship. And make no mistake about it, all of the expression that's at issue in this litigation is constitutionally protected. It's called disinformation, but it doesn't satisfy the standards for libel or fraud. The government itself would clearly violate the First Amendment if it had directly censored that speech. And so the very serious question is, did the involvement of the government cross the line to make it tantamount to government speech? And for those who are, again, I'm so distressed that this issue has divided people on partisan lines. It's just a coincidence that the defendants in this case are from the Biden administration, because the Trump administration was doing exactly the same thing when it was in power. And if whoever is elected, Donald Trump or anybody else, they're going to do the same thing. So for all of us who are concerned about not letting the government do indirectly what it may not do directly, have a very big stake in this litigation. Now, I put in a separate category, as I alluded to earlier, when there's no government involvement and is truly independently a matter of private sector decision making. I find that very hard. I am opposed to, again, I haven't thought about this, to the same extent as other people, but I have to the extent I have, I'm very nervous about the Texas and Florida laws telling private sector companies how they should engage in content moderation. To me, that is tantamount to telling the New York Times or Fox News or any media platform how they should exercise their editorial discretion. That to me is antithetical to First Amendment values. As a practical matter, though, if you get bounced off these powerful platforms, you are really going to have a hard time expressing your ideas. I strongly objected to Twitter and Facebook deplatforming Donald Trump. Not because I'm a supporter or an opponent of Trump, that's totally beside the point. He's somebody who, at that point, I believe was still an elected official, right? And he is speaking to his supporters, he's speaking to his opponents. Freedom of speech includes not only the right of the speaker to convey a message, but the right of the audience to hear that message. All of us have a stake in being able to hear the ideas of somebody who's got so much political support. So we have to find some solution. I'm very happy that very intelligent scholars I admire, as well as many members of Congress, some of whom I also admire, are seriously thinking about this and looking into a range of approaches, including transparency, from the antitrust approaches, potentially common carriage. The civil libertarian position from the get-go has been to foster individual freedom of choice, user empowerment. So one of the solutions that's advocated by the Electronic Frontier Foundation, which I greatly admire on these issues, is to allow interoperability so that all of the platforms would have to allow access to third parties, other software providers, to put in place whatever filtering mechanism the user opted for, rather so that we would not destroy their own content moderation systems, but allow others to be added to it.
Okay, we're going to go to one online question, and then Lindsay will get you the mic.
This question is from Professor Michael Smith, who spoke earlier. Well, you mentioned earlier in the conversation that rights remain subject to a means-end test, strict scrutiny in many First Amendment cases. The court seems to have abandoned the typical scrutiny approach in the recent cases, such as New York State Rifle and Pistol Association versus Bruin and Kennedy versus Bremerton School District, by focusing on history over government interest in tailoring, as well as in 303 Creative, where means-end scrutiny simply wasn't mentioned at all. So do these recent cases represent a shift away from scrutiny? If so, is this welcome or concerning? If not, why not? And Professor Smith's birthday is also August 18th.
Oh, no.
It was a great day, wasn't it? Yeah.
Can we make a date to celebrate this coming summer? I would love
Yes,
that.
let's do that, yeah.
You know, I think that I have not thought through the implications of an originalist approach to the First Amendment. So let me just start by saying this. I advocate judicial strict scrutiny and the emergency test, not because those are what the Supreme Court has adopted, but what, based on the best of my thinking and scholarship, and the study of actual experience, as well as legal theory and doctrine from around the world, as well as the United States, my conclusion is that that is the appropriate test. I have not done sufficient scholarship into originalism to know what its flaws and strengths are. So not to play law professor, but since you have studied that, Mike, I would be very grateful to hear your view about how that originalist lens would affect First Amendment free speech.
Thank you for bringing me back on. And yes, absolutely, August 18th. I think it should be a holiday, frankly. But as for, I guess my question is sort of about originalism, but also just about abandoning scrutiny more general. For instance, I think Kennedy and Dobbs, neither were really originalist decisions. Kennedy, Gorsuch mentions history and tradition, but he doesn't really implement that test. And in Dobbs, or not Dobbs, in 303 Creative, he doesn't really get into originalism either. I've thought through it a little bit, but again, not all that much. I'm not a fan of originalism. And one reason is I think that in the First Amendment context, it would be hugely disruptive. I think that there's been some great work done by Judd Campbell and Genevieve Lockyer in particular, who've looked into sort of the founding era approach to sort of speech. And it was very much kind of a public interest balanced against the speech itself, with maybe a few hard and fast rules in the context of prior restraint, but otherwise, speech that was potentially harmful to the public could likely be restricted without really any compunction or concern whatsoever. We're talking blasphemy, we're talking speaking out against the government, we're talking about true statements that criticize the government. And I do think that an originalist approach to free speech would upend a lot of the doctrine. I think some people welcome that. I think Justice Thomas welcomes it with respect to at least certain cases, particularly New York Times versus Sullivan. But I think that I generally am concerned about it, mainly just because of the lack of predictability and just sea change that a fully originalist approach would take. And that was, I think, part of what motivated the question. I see originalism doing some of the work, but also just the general abandonment of scrutiny in a few recent cases.
Thank you very much.
I think Calvin's book, Harvey Calvin's book, A Worthy Tradition, is probably the best response to the originalist position on the First Amendment, because it's an incredibly rich history of the first 2 or 3 decades of the Republic in terms of all the types of speech that were actually suppressed. Oh, that's interesting. And going even antecedent to that, Steve Solomon, who's a professor at NYU and runs a First Amendment project there, wrote a book about 5 years ago called Revolutionary Dissent, in which he argues that the First Amendment itself reflects a tradition of dissent, and that was so embedded that the original Constitution didn't even expressly refer to free speech, because it was just so widely assumed that that's what we have, and in fact we wouldn't have had a revolution or a country without it.
And in some ways, New York Times versus Sullivan itself, since you mentioned it, Michael, purports to be or appeals back to a historical example, a historical episode, the Alien and Sedition Acts of 1798, which, I mean, you could read the existence of those incredibly oppressive acts against criticism of the Federalist government. You could read those as an indicator that it was viewed as okay to do that, but there was an uprising against it. Thomas Jefferson, James Madison speaking against it. The court in Sullivan said this is an application of the wrongness of the Alien and Sedition Act is now, as we apply this to the right to criticize public officials and have breathing room. So what exactly does originalism mean? What are we doing originalism there when we say the Alien and Sedition Act episode informs what we say now? In a way, it's originalism, but it's a very kind of flexible, fuzzy version of it. All right, sorry to add to the interventions there. Somebody else have a...
Hi. Okay, I'm going to do 2 things. Probably change the conversation and also probably give you a softball. But I'm really interested in how you, with a background in human rights, look at non-human entities having this quote-unquote freedom of speech. Obviously talking about corporations who are deemed persons. And just wondering if A, you think that's correct, and noticing the power imbalance there, but then also whether or not you would hold it to the same degree. So if we do decide that corporations can speak under law, which I think is questionable at best, right? But if we do decide that, do you think it's the same level of protection, which is, you know, until the extreme end, that we protect those corporate speeches?
So excellent question, and again, one that I understandably get all the time. I think the single most hated decision that the Supreme Court has ever issued is Citizens United, and let me tell you, the ACLU supported that decision. And I think that was correct. I continue to think that was correct. And I don't think of corporations as non-human entities. I think of them the way the Supreme Court has, going back to 1958, when the very first corporation whose First Amendment rights it protected was the NAACP. The Supreme Court has recognized that freedom of speech includes an implied freedom of association, which means the right of individuals to band together to amplify precisely in order to make their speech more powerful, their advocacy more effective than individuals alone could do, especially on controversial issues. And the Supreme Court, not only the Supreme Court as an entity, but every single justice has continued to adhere to that holding. It's true that Citizens United was decided by a 5-4 vote, but the split was not on that fundamental question of should corporations have freedom of speech. By the way, the law that was struck down in Citizens United quite typically restricted the speech not only of for-profit corporations, but also of not-for-profit corporations and also of unions. I'm not aware of a single justice. Now, it's possible that at the end of his life, Justice Stevens changed his views on this issue. But with that possible exception, Every single justice who has sat on the court since 1958 has agreed that court individuals who form groups, whether the group is a club, whether it's a foundation, whether it's a union, whether it's for-profit corporation, whether it's profit corporation, has not only free speech rights, but freedom of association rights. The question about whether the standard should be the same is also, to me, an easy one and an uncontroversial one on the part of the courts. The reason why you get a 5-4 split, and where I think the Citizens United decision could be questioned, is on the whether or not strict scrutiny standard is satisfied. That maybe it is possible to show a compelling government interest, specifically in restricting speech of for-profit corporations, not-for-profit corporations, and unions, and that it is the least speech restrictive alternative. And that's where there was a split, just on the constitutionality of the particular restrictions. But, you know, there are so many complicating factors here. You talk about a power imbalance. Well, the law wasn't even written in terms of power imbalances. There are small and feeble and completely weak corporate entities, and they're extremely powerful, wealthy individuals. You know, so many people say, well, we should restrict the influence of money. Okay, I'll assume that for the sake of argument. Then write the laws in terms of who's spending the most money or who's the most wealthy individual or entity. But to just single out a particular form is really, to me, quite illogical if what you're concerned about is reducing the influence of wealthy actors. Then go after wealthy actors, not a corporate or union form. Similarly, people talk about how powerful the particular expression is. Again, there are many corporations that are not powerful and many individuals who are powerful. What the ACLU has always advocated in this area, it goes back to the counter speech theme. We've been very strongly in favor of disclosing where the contributions come from, because that is a way of people making an informed decision about the potential influence of the spending. More controversially, we've always advocated public financing of elections. You know, let's make funding available for every ballot qualified candidate who can get onto the ballot. You know, there are many advantages of that, to equal access to the electoral process, to reduce the amount of time that candidates and officials have to spend in raising money. And even though that will sound as if that's extremely expensive, the numbers are shockingly low. I mean, economists have done studies of how much money has been spent for every single election, from Justice of the Peace to President of the United States, and it's like less than the advertising budgets of one or two major companies. And, you know, I think this is not popular with my libertarian friends, but I think that's a really important investment in democracy. And so I support the goals of the campaign finance reform laws, but I think that the legislation is both unprincipled and ineffective. They're basically incumbent protection acts in operation.
Oh yeah, thank you again for being here, and just for all of your comments. So thank you. You mentioned briefly the issues with tribalism and how it's sad that this issue has become a politically polarizing issue. And I think one thing that happens there is we develop really inconsistent viewpoints on things because we just look at the parties, or we look at our moral evaluation of the speech, of the content of the speech. And I think that happens even in law schools, where I think students sometimes, myself included, sometimes I struggle to identify the legal principle or any consistent or countervailing principles of public policy and apply those consistently. But that's really what we need to do to be good lawyers, and some of us future judges as well. So I'm kind of asking, as you know, with the law professor hat on, what can law professors and law students do to continue to develop those critical thinking skills in this area?
Thank you so much. Such an important question. And 2 days ago, I spoke at a day-long conference about illiberalism in law schools and the legal profession. How can we maintain civil and robust discourse? And, you know, law schools were among the last bastions to fall to, for lack of a better term, you know, the wokeness tide that swept across other parts of academia. Let me say, as recently as 2017, Heather Gerken, who was then the newly appointed dean of the Yale Law School, wrote an essay in Time magazine in which she quite, you know, smugly, and I say this with the greatest respect toward her, and I had the same smugness, she said, you know, all these problems that are taking place on other aspects of the campus, including Yale itself, like deplatforming and shouting down, and that doesn't happen at law schools. And at that point, there had not been a single incident at a law school. And she said, and the reason for that is because we have a special culture where we understand, you know, the core of what we do as lawyers and hence as students is to engage with multiple perspectives on every issue. We understand that we can't be effective advocates for our own client and our own position unless we understand different points of view. And that's what the whole adversary system is. And secondly, this was something I hadn't focused on before I read Heather's essay. She said going along with that is a tradition of civility that lawyers are allowed to engage in expression as a social matter in their capacity as lawyers that they could not get away with in society at large. And she gave the example of Thurgood Marshall, second time I'm mentioning him today, when he was a lawyer, black lawyer for the NAACP, he would go, during the Jim Crow era, go into Southern courtrooms and cross-examine white witnesses, including white women, in a way that would be unthinkable to have that kind of exchange in that part of the country at that time. So there was professional courtesy coupled with a rigorous exchange of ideas, and then how quickly that disappeared. I have kept track. The first two incidents on law schools of deplatforming occurred about half a year later in March of 2018. And since then, for a while I was able to keep track of them, and now I can't anymore, including infamous incident at Yale Law School itself, you know, having Stanford law students shouting vulgarities at a federal judge. I mean, this is the antithetical to what we law professors want our students to do. And so what we have to do is make clear to them what the stake is, not only as lawyers in general, but even as lawyers who are going to be effective in advocating their particular causes. That you cannot be an effective advocate for your position unless you have fully grappled with, and I would say along with John Stuart Mill in On Liberty, in actually advocating a countervailing perspective yourself. The rule I have always practiced in my teaching, going back for more than 30 years now, not because of the current crisis, but just because I've always been committed to training lawyers who are as effective as possible. Tap a former student of mine and they can recite this in memory because it's my mantra. You cannot pass my class, let alone get a good grade, unless you can effectively understand, articulate, and advocate every plausible perspective on every issue. And by plausible perspective, that means one that's justified by the relevant sources. So in constitutional law, a constitutional passage, Supreme Court precedent interpreting that passage, your own analysis or analysis by legal scholars. You may not engage in any conclusory arguments. You may not engage in any ad hominem arguments. And you must use professionally appropriate language, language that would be suitable in a court of law. And that does not include shouting at a federal judge, I hope your daughters get raped. You know, interestingly enough, Judge Duncan, who was on the receiving end of that opprobrium, participated in this conference too, and I was talking with him. He seems very confident that the line is going to be held at the courts. You know, he is just completely confident that, you know, courts are not going to tolerate the viewpoint homogeneity or the rude, unprofessional language. I don't share that confidence because I roll back to Heather Gerken saying, you know, law schools are impervious to this trend as well. So I think your question is extremely well taken. We have to maintain those guardrails. And I think we do it starting, well, I mean, ideally, we would do it starting K through 12 or in utero even, but certainly no later than when the student is applying to your law school. In all of your application and recruitment materials, you start acculturating them to this essential aspect of your educational process. If they find that makes them uncomfortable, then let them go to another law school. Let them go to woke law school. The orientation session, just as we appropriately train students not to engage in gender or sexual or any other kind of discriminatory harassment, we have to equally instill in them commitment to viewpoint diversity and to advocating different perspectives with appropriately professional language. And that has to be woven into every single class, every single exam, every single exercise.
Thank you, Professor Strawson, for your time this morning, and a special thanks to Professor Berg for facilitating our keynote discussion. I'd like to invite everyone now to the atrium where we will have a buffet lunch that is set to start right about now. And our afternoon portion of our event will begin back here at 1:15. Thank you. Welcome back, everyone, and to those of you just now joining us, thank you for coming to the Journal of Law and Public Policy's Fall 2023 Symposium, Free Speech and the U.S. Constitution. Just as a reminder, we are offering 5.5 standard board-certified CLE credits today. Be sure to get your information either in the Zoom chat for those of you online or on the sign-in sheet out in the atrium so we can ensure you get those. We are honored to host our next panel of speakers focused on redefining the public square, featuring Professor Jennifer Safstrom, Professor Rachel Houston, Mr. Stephen Ernest, and Professor Kimberly Breeden. I'll introduce each of them in turn. Professor Safstrom is an assistant clinical professor at Vanderbilt Law School, where she teaches the Stanton Foundation First Amendment Clinic, and previously served as counsel for the Institute for Constitutional Advocacy and Protection, and is a supervising attorney and clinical teaching fellow with the Civil Rights Clinic at Georgetown Law. Professor Houston is an assistant professor of American judicial politics at Texas Christian University and focuses her research on the intersection of judicial behavior, political communication, and social psychology. Mr. Stephen Ernest is an associate attorney at the Dallas-based law firm of Thompson, Coe, Cousins, and Irons, LLP, where he works as a litigation associate in the firm's professional liability practice group. And finally, Professor Breeden is an assistant professor of law at Ohio Northern College of Law, where her research focuses on the constitutional and international legal dimensions of corruption or potential corruption by government officials. She's been widely published, including in several editions of the JLPP. We are so glad to have her joining us here again. And we are grateful to all of you for joining us this afternoon. As you may notice, we have 2 speakers virtually, 2 speakers in person, so we appreciate the flexibility with the hybrid model. And I would like to invite Professor Safstrom to begin our 3rd panel. Thank you.
Thank you so much for that warm welcome and for all of your efforts in coordination of today's event. Can you hear me okay? Everything okay?
Yes.
Great. it is both an honor and delight to join you, and not only, and to have had the opportunity to learn from so many of the conversations already today. I am at a disadvantage because I cannot see the room, but I'm going to still start off by asking a question and hope someone will report back to me. So a couple questions. First, raise your hand if you have a social media account of any type. And that includes Facebook, X, Instagram, YouTube channel, whatever you can think of. Okay, keep your hand raised if you follow at least one governmental entity, whether that's an elected official, that's a department, whether that is a school or school board. Okay, I see a lot of hands up. So what this means is that this is a case that affects a lot of people, including all of you. And I want to talk about two sets of cases, and I really appreciate the panel. And so I did get to see some of those hands. I think so, and that's the intro to what I want to talk about today, which is a set of cases that are before the Supreme Court this term that have a deep impact on engagement with public officials in social media spaces. And so I want to talk quickly about the factual background and procedural history of these cases to give some context, and then really focus on the legal dispute, some of the issues as raised by some of the amicus, and maybe some thoughts on reflections on oral argument and predictions if we have enough time. So to dive right in, the two cases in tandem addressing this issue before the Supreme Court are Linke v. Freed and O'Connor-Ratcliffe versus Garnier. The first is a Sixth Circuit case that has to do with James Freed, a city manager in Port Huron, Michigan, who created a Facebook profile that then he converted eventually into a page to have unlimited followers. He designated the page as a public figure, included his official title, shared professional updates on the page, including directives and policies that he initiated in his official capacity, and also did share personal and family updates. Kevin Linke, a citizen, posted criticism on Freed in response to the city manager's handling of the pandemic. Freed deleted the comments and ultimately blocked Linke from accessing the page. Linke sued unsuccessfully, losing both at the summary judgment stage in district court and then at the Sixth Circuit Court of Appeals. In O'Connor-Ratcliffe versus Garnier, petitioners Christopher and Kimberly Garnier, who are parents in the Poway Unified School District in California, posted a number of critical comments on the district's Board of Trustees page, social media pages. The trustees, both O'Connor-Ratcliffe and Zane, who created these Facebook and Twitter pages, included their official titles, posted about school district business and news, and they began to hide or delete critical comments by the Garniers and ultimately blocked them from accessing the page entirely. The Garniers, by contrast, sued successfully in the Ninth Circuit, both winning at the district court stage as well as at the Ninth Circuit Court of Appeals. So the real legal issue and where the circuit split and kind of these two different tests come out and what the Supreme Court is in part being asked to resolve is kind of the Sixth Circuit's conclusion that on this issue of kind of government action, state action in social media spaces, that the right standard is what they call kind of or have labeled an appearance purpose test. And this is one where either the law has to require that an official social media page be a public official's enumerated duties, whether the account is bound to an office instead of an individual office holder, such that it's considered essentially state property, whether the social media account is run using government resources to maintain the page, or whether the public official's social media activity takes place during normal working hours. So all of these kinds of factors come out of the Sixth Circuit as kind of a narrow construction of having to really actually be tied in some very formal way to the office holder's role, and really ties it to things like resources. The Ninth Circuit, by contrast, really looked at whether the public official was cloaking themselves in their social media pages with kind of the power and authority of their offices. So they also looked at things like titles and photographs and whether their government contact information was included. Whether, and that's both email address or phone number, web addresses, or other types of communication. So looking also kind of from a more practical level of someone accessing the page, what does this look like in terms of kind of holistically looking at the page? So the factual background of both of those cases set up this kind of legal distinction in terms of tests, but the real question that both of these standards are seeking to address is whether or not whether or not state action, or when there is state action, such that a social media page essentially becomes a public forum, that it is a space that has been designated by public officials that then for speech that then merits First Amendment protections. And when that attaches, then you have viewpoint discrimination protection. So that's really kind of underlying the claims in both of these cases, that the reason First Amendment is supposed to attach to social media is because it has been made this intentional forum by officials. And so then eliminating folks because of their viewpoint is impermissible under the First Amendment. There are a number of groups that ended up writing amicus briefs on this issue, and just as a microcosm of the much broader social commentary and discussion that has occurred from a number of nonprofit groups, for instance, FIRE, the Foundation for Individual Rights and Expression, discussing how government officials using social media to limit public discourse is problematic, to kind of a local government legal center, National Association of Counties, National League of Cities, and related groups kind of putting forward their own test about kind of government control over these accounts. Even the National Republican Senatorial Committee weighing in and kind of trying to cast a light that much of this could fall in the domain of like unregulatable campaign speech. So kind of a whole range of different viewpoints and perspectives that got brought up in amicus work. But I want to kind of highlight some of the issues that were presented in an amicus brief authored by the Duke, Illinois, Tulane, and Vanderbilt First Amendment clinics that, and Southern Methodist, and as well as some independent First Amendment scholars and activists who have kind of engaged on these issues. And really thinking about the fact that the current state action test is essentially incredibly fact intensive and difficult to apply, and it makes outcomes unpredictable. The test really fails to establish a bright line rule to guide the conduct of government actors and to really protect the interests of members of the public who are engaging in these spaces. The primary, and we essentially propose a test that is more robust than kind of either of the parties, and argue for a rebuttable presumption standard in order to kind of not only promote not only the most kind of speech protective position, but also promote judicial efficiency, reducing the cost of litigation, and providing an incentive for public officials and entities to separate public and private accounts in ways that would then help create some of those line drawing, or prevent having to answer maybe some of those more difficult line drawing questions with a much, kind of blurrier and potentially arbitrary standard. There are kind of four core First Amendment values that are really imperiled by social media blocking. The first is that it facilitates the public's access to information. In the sense that information is provided by government actors and agencies to the public. So everything from, school closure announcements to other types of emergency alerts, but also routine meeting notices or other types of information coming out from the government goes to the public through those channels. Second, social media provides opportunities for direct interaction between constituents and their governments and elected officials. So the ability to, for instance, ask for assistance and receive a direct response to requests for help through these pages. In some instances, elected officials have held polls or conducted other types of surveys where people can give input on proposed or future legislative issues. These are just some of the ways that constituents then can also in turn interact with their government officials of all stripes. Third is that social media has become kind of a quintessential public forum for discussion and discourse about public matters between citizens and individuals. And so protecting that ability to have those conversations in digital spaces that have kind of become our modern public square is of critical importance. Finally, social media accounts also function kind of as a records of governance. And, to the extent that we think about this as a space that is, again, reflective of capturing a broader conversation, we wouldn't think it's permissible to, delete comments from minutes to a public meeting, but, that we kind of get to have the same editorial discretion potentially, if a kind of robust rule protecting speech is not adopted by the court. So kind of shifting then into thinking about and I will also add that we also even say that the rebuttable presumption could extend to campaign officials because, the First Amendment has permitted restrictions even to candidates in, say, the form of campaign finance, contribution limitations along the lines of like Buckley v. Vallejo. But I'll leave that to the side because I think that's less important than the key question of it definitely applying to current government officials and entities, which is kind of at least an undisputed group or a different group of consideration potentially than candidates. The oral argument on this case, I thought, which happened on Halloween, very spooky, I thought was both, very hyper technical and thinking very kind of myopically and word constructionisty about words like duty, but also we're kind of vague in terms of, thinking about incentives and whose speech is, needs protecting, but is also at risk. And so, one example of that manifested in kind of thinking of who bears the burden and do we want that to be, kind of a burden on kind of the rights and speech of officials, or, is there kind of a public interest in this like duty to inform and other values? And, the way that some of those I think played out in argument was really interesting. I think some of the discussion also, demonstrated kind of interesting questions about just like technological application of, kind of how social media is practically used by officials and, some of the technical functionalities on these platforms of what can or cannot be done in terms of accessibility, and just lots of interesting conversations on, kind of, administrability and what guidance to give to kind of local officials in terms of the application of this rule, kind of in the future. I think the conversation was a bit opaque. And so, it's always hard to posit what might come next, but I think, there was, more of an appetite maybe for some of the duty or authority line of conversation, kind of focusing on the clarity that things like a state resource articulation of the rule can be in terms of kind of staff or, hours or space or, which computers were used, or where it's clearly mandated by a statute. But I think, the court could adopt something that is broader than what some of the parties or amicus argued in terms of thinking about policy and operating procedures and practice and, kind of history and custom a little bit to the extent that, some questions about kind of the tradition and historical functions of government, right? So the idea that emergency announcements it may not be accessible to everyone it also is something that didn't seem to sit well with the court. And so I think figuring out, what is a most speech protective standard to apply, as well as one that might address kind of the scope of some of these issues is really important. But I'll kind of just wrap up by saying that, whatever rule the court does come up with is going to have a really significant impact in our day-to-day lives and kind of the day-to-day lives of, many individuals. And this will kind of be a very deterministic case in terms of our accessibility to different types of social conversations online and to both not just receive information, petition government officials, but also engage in discourse with one another. So thank you so much and look forward to questions and the thoughts of others on the panel to their respective issues. Thank you.
Thank you, Professor Safstrom. I will now invite Professor Houston and Mr. Ernest to offer their remarks. Thank you.
Do you want to go up there? And then we can switch.
Oh, we'll just toggle through it. Okay, there we go. Good afternoon, everyone. My name is Stephen Ernest. It's Professor Houston.
Hi.
And our paper is generally focused on how lower federal courts in the wake of the Supreme Court's Packingham decision have interpreted the Packingham Court's definition of the modern public square. So we're all kind of familiar with the term public square. We've seen it in our media, we've seen it in books we've read, and most importantly in our legal discourse. Traditionally, it's kind of referred to a physical space, one that's accessible to the public. Members of the public have a right to access. It's usually owned, operated, or managed by the government, but can also extend to private spaces that are imbued with a kind of public characteristic. Listed some examples. Your usual suspects are going to be like public parks, streets, sidewalks, but they're all physical spaces where people can gather and kind of share their ideas. And that's its relevance to the First Amendment. Public spaces have significant importance in the First Amendment context because people are allowed to engage in the protected First Amendment activity in those spaces. So its historical importance, we've seen it in, with respect to, I've listed kind of the primary important event would be the Civil Rights Movement, and advocates, participants in the movement, people who supported it, they were all, one of the main venues for them to kind of exercise their, or show their support for the movement was in public spaces. So probably the best example of that was on the March on Washington for Freedom and Jobs, where Martin Luther King Jr. gave his famous I Have a Dream speech. It was delivered to a crowd of many people on the Washington Mall. It's kind of the quintessential public space. And through their use of these spaces, they were able to really encourage change at all levels of government, so local, state, and federal. Modern activists also take advantage of physical public spaces. So you have the Occupy Wall Street movement, the Me Too movement, and the kind of related Women's March on Washington. You have the Black Lives Matter movement. They all use these spaces to press for change and promote their causes. But the difference between these older social justice and political movements and the more modern ones is that the modern ones have access to the internet, which is its own form. It's not physical, at least not in a tangible sense. It's kind of in the ether. And there are a lot of benefits to being able to use the internet because you have a wider audience. You can not just spread your message, but you can engage with other people who are supporting your message. So you have just generally, it's a really useful tool for people who are trying to promote a particular cause. However, because the internet is relatively new, it's a novel concept, there's not a lot of case law kind of discussing, we have all this case law that goes to how the state can regulate actors who are on public spaces, what kind of rules and regulations the state broadly, how they can implement on these public spaces or the physical spaces, but not so much with respect to the internet and the digital spaces, just because it's a newer concept. It wasn't until the Supreme Court's decision in Packingham versus North Carolina where the court kind of addressed this issue. What is the public space? Briefly, the facts of that case are there was a North Carolina statute, it was a criminal statute, which made it a felony offense for a registered sex offender to use or to access any website on which a minor could also create an account or host a web page or something like that. The plaintiff in this case, well, he's not really the plaintiff, but the petitioner in this case was a registered sex offender by the name of Lester Packingham. He went on Facebook to celebrate a traffic ticket dismissal and was subsequently prosecuted because obviously Facebook Plenty of people can go on that website, many of them minors, and create accounts. He defended on the grounds that the statute was unconstitutional, and he appealed all the way up to the Supreme Court. The Supreme Court agreed with him. They said it violated his First Amendment rights. They didn't say it violated his First Amendment rights for lack of an interest, compelling state interest, but more because the statute itself was too broad. In reaching that holding, the Supreme Court basically made the proposition that the internet, given its novelty, given its obvious importance for the exercise of First Amendment speech rights, the state couldn't do this. It couldn't just broadly prohibit some person from accessing the internet writ large, which is essentially what the North Carolina statute did. And we've cited some language right here, some of the key language that the court used in support of that was related to its proposition. But generally speaking, Justice Kennedy, who authored the opinion, he drew a lot of comparisons between, the kinds of speech that a person can engage in the traditional physical space, as well as the kinds of speech-related activities an individual can engage in the internet space. However, not a lot of clarity. Just the internet, cyberspace, what's included in that definition. The court doesn't address it. Obviously, Facebook, that's in there. But courts since have had to wrestle with that question as new different social media platforms have been involved in lawsuits, and other courts have had to determine whether or not they're included in this definition.
So the main question we're asking is what constitutes the modern public square in this digital era? And in Kennedy's opinion, he says it's the internet generally and social media specifically, but that's all we're given. And we know that the internet is very complex, and we know it's so much more than just Facebook or Snapchat or Instagram. And so we're curious to see how lower federal courts have grappled with Packingham, and specifically this idea of a modern public square. And so what we do is we look at any lower federal court opinion that cites Packingham, but also cites the concept of a public square. It doesn't have to be modern, but as long as the case says public square, we pulled it. We collected cases from when Packingham was first decided through the end of June this year. We're ultimately going to collect data for the rest of the year for the paper we're going to submit in February. But for the purposes of this presentation, we cut it off at the halfway point. We're looking at 21 district court orders and then 14 appellate court opinions to just see how they are dealing with that modern public square. And while Packingham deals with a sex offender, we can see that Packingham and this idea of a public square has actually been has been applied in a pretty broad range of areas, right? So we have sex offenders, incarcerated individuals, and child pornography offenders, but Packingham in that public square has also been used in other contexts, such as K through 12 education, industry, including businesses, higher education, elected officials. And so the point being that that concept of a modern public square is not just applicable in a criminal context. This modern public square, lower courts are applying that idea across a bunch of different fields here. And we don't have time to look at every single issue. And if you want to do that, you can read our paper next year. But we're going to talk about some of the big ones. So for the purposes of this presentation, we're lumping together sex offenders, child pornography, and incarcerated offenders. And what lower courts have said, very similarly to Packingham, that you can't have overly broad laws on the books, or you can't have policies in place that ban individuals from the internet broadly or social media broadly. In the context of Packingham, it was social media where minors could have access. That was still too broad. If perhaps a law is very narrowly tailored and says that someone cannot access a very particular website, maybe that would be okay. But all of these lower level decisions deal with very broad laws. So looking at banning individuals from social networking sites generally, internet access, one of them was even computer usage and internet, so you couldn't even get on a computer. Facebook, social media posts, internet. So we quantify what exactly is being discussed with that modern public square. And for a majority of these cases, lower courts are coming to that conclusion that these broad bans, you can't do that to people because we use the public square, we use that modern public square for so much more than just hanging out with our friends online, right? We do almost everything online, so you can't just ban people from the internet generally. Another category we have is industry, so looking at businesses, issues dealing with user data disputes, age verification laws, and content censorship. So looking at some of these cases here and the platforms invoked, the lower courts have said that all of these fall under the modern public square. But these are your big box social media platforms, LinkedIn, Facebook, Instagram, Twitter. The lower courts really haven't dealt with, at least in our context, platforms that aren't the normal ones that we can all recite. As for elected officials, we have a couple cases here dealing with elected officials banning individuals from commenting on their Facebook or Twitter posts or even deleting posts. And so what we see here, and just for the sake of time, all of these, so elected officials, Facebook pages, Twitter accounts, general social media accounts, lower courts have said that those all fall under that modern public square, meaning that elected officials can't just delete your comments if they disagree with you. In a very similar manner, if you are on a sidewalk and you're yelling out how much you hate your elected official, that elected official can't just pluck you off the sidewalk, right? You have that right to stay there, and that's exactly what the lower courts have said here. The live streaming one is interesting because while that lower court says that live streaming is a part of the modern public square, they actually nudge the Supreme Court and say, please provide us with more clarity. Does live streaming count? We don't know. Because live streaming is not just on social media. There are individual websites you can go onto that live stream all sorts of things that aren't just Facebook and Instagram. So that opinion, Knight versus Montgomery County, is very interesting for that. Lower courts are asking for that guidance. As for K through 12 schools, so we're dealing with cases with teachers, students themselves, and parents of students. So again, for the sake of time, we're just going to look at those platforms being considered and whether they fall under the modern public square. Again, big box names, Snapchat, Facebook, Twitter. We probably all know the Snapchat case. But really big social media platforms are being considered, and it's a no-brainer for lower courts that these do fall underneath that definition of a modern public square, as outlined by Kennedy. The last case I'm going to talk about, just because we are in a higher education context, is Krasno versus Munkin. And in this case, the University of Wisconsin-Madison, they have their Facebook page. You know, they post general university things. There was an animal rights activist who was posting underneath their posts, advocating for her beliefs about animal rights. And what's interesting in this case is that the lower court said that you can regulate those off-topic comments. So because she was posting about something arguably that doesn't connect to the university had a right to delete those comments. If we look at the use of that modern public square throughout time, we can see that we saw this peak in 2020. It looks like 2023, it's on a decline, but again, we've only collected data through the end of June. So I'm sure this is going to spike back up by the end of the year. I'll turn it to you to keep going.
Yeah, so just to kind of follow up on what Rachel was saying, for the most part, I mean, entirely, all the cases we've reviewed, they've they've involved social media platforms. One case in particular refers to it as a social networking site as opposed to a social media platform, but they're one and the same. And it makes sense because that's where people on the internet, if they're engaging in what one would consider to be protected speech activity, it's going to be on social media as opposed to some other website like Amazon. It just seems less likely to come up in that context. And then here's some specific examples of the companies involved or the platforms involved. They're your usual suspects, so Facebook, LinkedIn, YouTube, right on down the line. Also, like Rachel had referenced, in one particular court opinion, the court was actually expressly pleading that the Supreme Court provide guidance on what was included. And so these are what was included in the definition of a modern public square, and these are some examples. So a private online community. For example, Reddit might fit into this definition, might not, because in some instances you have to have access to get into those particular fora. Private messaging apps, where it's a limited conversation between two people. You're not actively posting to the public, but rather sending a message to someone else. Would that fall under this definition? Or even gaming communities. I see we put gaming communities. Twitch, that would be an example of that. I don't know if any litigation is going to come from a usage of Twitch, but it could, and that may be a question the court needs to resolve. And so kind of in conclusion, it seems as though in light of Packingham, the internet, given its novelty, given its obvious importance in the First Amendment context, courts are going to be very hesitant to allow the state to enact these kinds of sweeping laws broadly prohibiting usage, but at the same time, it's unclear what exactly fits under that definition outside of what you would expect, which would be social media platforms and companies and other things related to that. So down the line, these are questions that the Supreme Court is probably going to have to answer. It just is going to depend on what's brought to it. Thanks, everyone.
Thank you both. Now I will invite Professor Breeden to share her remarks.
Afternoon. I've been fighting an upper respiratory infection for a week, and I lost that battle, and I also am losing my voice. If you cannot hear me, please let me know somehow, and I'll talk short. Do want to share? Point slides, if I can. Can you see those?
Yep, we can both see in here, and also we totally appreciate and understand if you want to give brief remarks today.
Okay, thank you. I did do a quick review of my PowerPoint slides and tried to abbreviate things somewhat. First of all, I just want to express my thanks again to Charles and Olivia and the JLLP team for inviting me to participate in yet another stellar symposium. You guys just really set the standard. I also want to thank Xander and Hannah for their contributions in getting the technology set up and for keeping me on time here. So, do you want to talk about how the Supreme Court's First Amendment campaign finance jurisprudence has changed, to some extent, the public understanding of what constitutes public corruption? And the court has done this, at least in part, I argue, by essentially erasing relevant context from its opinions. So before we talk about the Supreme Court's jurisprudence, excuse me, and the role of corruption as a compelling interest in campaign finance cases, I first want to talk about the role of context in the formation and interpretation of the meaning of utterances. Particularly, I want to talk about a concept drawn from the linguistic field of pragmatics, which is the concept of implicature. And implicature involves underlying common ground among discursive participants, which create shared but unexpressed presuppositions about the context which forms the meaning of an utterance and informs the interpretation of an utterance. And I should note here, I'm oversimplifying pragmatics and I'm oversimplifying semiotics. But semiotics is the study of signs and symbols, including words, and the way these signs and symbols are interpreted. Semiotics conceives of language as a system of signs, and it provides a framework for understanding how humans use signs to form and to interpret the meaning of language. So pragmatic implicatures and semiotics influence each other as the shared underlying presuppositions relating to a particular sign or symbol change the meaning I'm sorry, the meaning of that sign or symbol also changes. That is the public's understanding, or maybe a subset of the public. Usually it's going to be a subset of the public, but the discursive participants' understanding of the meaning of that sign or symbol also changes. So just as an example, I want you to think of the word literally, right? The collection of letters together, making up word literally. So formally, the word means actual or adhering to fact, as in the bird literally flew into the open window. Informally, although this informal meaning has been around for a long time, it is a much more recent development than the former reading. And it's a development that occurred as the word's contextual usage changed over time. But informally, literally means the actual opposite of literally. Informally, it means figuratively, and it's used for emphasis, as in, my neighbor literally flew into the room. So I submit to you that a similar pragmatic implicature, semiotics change in the meaning of corruption is currently underway as a consequence of the court's campaign finance jurisprudence, which first minimized relevant shared context for defining corruption in this space, then backgrounded it, ultimately erased it. And today our story about context, corruption, and campaign finance begins in 1974, although it could have begun much, much, much earlier. In 1974, Congress passed the Federal Election Campaign Act, which was a comprehensive framework of campaign regulations adopted in the aftermath of the Watergate scandal and President Richard Nixon's subsequent resignation, amidst public demand for campaign finance reform. The FECA established limits on campaign contributions and expenditures. It imposed disclosure requirements for both contributions and expenditures. And it provided for, it provided for optional public finance funding of presidential elections. 1976, Buckley v. Vallejo overruled the expenditure caps under the First Amendment, but upheld the contribution limits, the disclosure requirements, and the public financing provisions. And in striking down the expenditure limits, the court held that money in the form of individual campaign spending is political speech, deserving of the highest First Amendment protections. So as we've discussed in multiple contexts earlier today, in doctrinal terms, that meant that any government regulation of such expenditures needs to be narrowly tailored to advance a compelling government interest. me. The court recognized as a compelling government interest the prevention of the appearance or reality of corruption caused by suspicious forms or amounts of campaign financing. In this regard, the species of corruption the court identified, can't read my own writing now. The species of corruption the court identified was a quid pro quo transaction of some sort. And although the court upheld contribution caps because of the risk of the appearance or reality of corruption, the independent expenditure provisions were invalidated based on the court's determination that because the spender, supposedly I'll add, in my opinion, has no contact or coordination with the candidate, the risk of quid pro quo corruption, whether real or apparent, is minimal. One of the important relevant contextual features of Buckley v. Vallejo is an understanding that campaign contributions in exchange for access and influence is itself a form of quid pro quo corruption. Money in exchange for a vote is clearly quid pro quo, but money in exchange for access and influence, at least according to some of the court's language in Buckley, could also be understood as a form of quid pro quo corruption. And in this regard, the Buckley case cited the lower court's decision approvingly, referring to a number of findings that the final report of the Select Committee on Presidential Campaign Activities had made as part of its investigations leading up to the enactment of the FECA. And I just want to read you some of these findings. As I said, the Supreme Court incorporated these by reference. Looming large in the perception of the public and congressmen was the revelation concerning the extensive contributions by dairy organizations to Nixon fundraisers in order to gain a meeting with White House officials on price supports. The industry pledged $2 million to the 1972 campaign, a pledge known to various White House officials, with President Nixon informed directly by Charles Colson in September 1970. Since the milk producers, on legal advice, worked on a $2,500 limit per committee, they evolved a procedure after consultation in November 1970 with Nixon fundraisers to break down the $2 million into numerous smaller contributions to hundreds of committees in various states, which could then hold the money for the president's reelection campaign so as to permit the producers to meet independent reporting requirements without disclosure. March 23, 1971, after a meeting with dairy organization representatives, President Nixon decided to overrule the decision of the Secretary of Agriculture and to increase price supports. In the meetings and calls that immediately followed the internal White House discussion and preceded the public announcement 2 days later, culminating in a meeting held by Herbert Kimbach at the direction of John Ehrlichman, the dairymen were informed of the likelihood of an imminent increase and of the desire that they reaffirm their $2 million pledge. It is not material for present purposes to review the controverted issue of whether the president's decision was in fact or was represented to be conditioned upon or linked to reaffirmation of the pledge. The footnotes continue. The findings document lavish contributions by groups or individuals with special interests to legislators from both parties. The record before Congress was replete with specific examples of improper attempts to obtain governmental favor in return for large campaign contributions. Immediately preceding this footnote, was a report from Center for Political Studies from the University of Michigan market opinion research, which polled popular opinion to determine from 1964 to 1974 the extent to which voters believed that government was, quote, pretty much run by a few big interests looking out for themselves, or that is run for the benefit of all people. And notice that in that 10-year period, the percentage is roughly reversed. 1964, 64% of those polled said that government was run for the benefit of all. 29% said it was run for the benefit of a few big interests. In 1974, only 21.3% of the public polled believed that government was run for the benefit of all, and 69.9% believed that it was run for the benefit of a few big interests. These are important underlying considerations. This is important unexpressed presuppositional context that gave rise to the Supreme Court's, indication, nod to the fact that money in exchange for access and influence would be considered corrupt activity. I notice I'm almost out of time, so I'm going to skip ahead to the much beloved Citizens United case. Yes, I say that tongue in cheek, which stated that quid pro quo corruption does not include campaign expenditures in exchange for access and influence, because such an exchange poses no risk of the reality or the appearance of corruption. And again, you can see that there's this shift between a focus on quid pro quo corruption as including campaign finance in exchange for access and influence as posing the risk not only of the reality of corruption, but also the appearance of corruption. And now we see in 2010, the court is backing off on that and almost doing a 180 on it. And in fact, by the time we get to the McCutcheon case in 2014, the court specifically says ingratiation and access are not corruption, even when granted in exchange for campaign finance contributions. So ultimately, over the course of time, we can see that the shared, if applied, contextual presuppositions concerning public corruption no longer form part of the narrative in the court's campaign finance opinions. By erasing the previously shared underlying presuppositions, the court is helping to shift the public understanding of what constitutes sanctionable corruption. But more perniciously, the contextual erasure alters the semiotic structure of what conduct is actually understood to be corrupt by the public. And this alteration, in turn, has the potential for changing the way society at large views corruption, opening the way for the creation of a culture of government corruption, an increase in voter cynicism and alienation, and the further loss of trust in representative government. And with that, I thank you for your indulgence in putting up with my voice and my cough, and I invite your questions and comments.
Thank you, Professor Breeden. We really appreciate you being here today and wish you a speedy recovery. I'd like to open the floor to questions, starting with Professor Reed and then those in the audience.
I'd like to first begin by thanking the afternoon presenters, and I have questions for each of them. Professor Safstrom, I'll begin with you. And your presentation raises a number of questions that I've kind of lumped together and under the rubric of public interest. So let me ask the following questions about the social media presence of public officials. First off, they're related questions, but they have some distinctions. Would a public utility model of social media work best in allowing broad public access to public officials' accounts, imposing limits of responsibility and public welfare upon public officials, which would effectively prohibit them from blocking private citizens from having access? Conversely, does the immediacy of social media and the anonymity pose potential for harassment of public officials that is unique to the features of social media? Finally, a third question is, do public officials have a private life? Are they free to establish personal social media presences where they may keep track of family matters and matters of purely personal concern? Those are my questions to you, Professor Sastrom. Thank you. To Mr. Ernest and Professor Houston, again, a series of questions. Thank you again for your presentation. My first question is the public square. I actually have done some of the work you've done on this for an article I've not published, but I have looked through. But I have looked through the cases on the public square, and what I find interesting is it's a metaphor that could be very, very enriched, but courts have avoided enriching that metaphor so far. They've really held back on drawing out the implications of what that metaphor means. And maybe it's because of the follow-up question I'm going to ask, and that is, when we speak of the internet, Anthony Kennedy speaks of the internet, and he it's a warm, fuzzy concept of the internet. It's the internet circa 1999. Okay, but it's 2017, but Anthony Kennedy's 20 years in the past. But we really know that the internet is a series of interlocking, privately controlled corporations. We really know that's what the internet is, right? It's not a public square. Using that metaphor would be a useful way of shoehorning in a concept of public utility. And so I'd like you to think about expanding the metaphor. Can we expand the metaphor to unlock this meaning of the internet? This warm, fuzzy 1999 notion of the internet is, some grand public square. No, the internet is YouTube, it's Google, it's Yahoo, it's Instagram, it's TikTok, et cetera, et cetera, et cetera. That's what the internet is. So I'd love to see something with the public square. Professor Breeden, I thank you so much for being here. I hope you feel better soon. You're a good friend of the University of St. Thomas. Is this your third presentation or your fourth? Fourth, I thought so. And I wish you were here in person. And thank you for your presentation. Let me pose a couple of questions to you. First, parallel to the Citizens United cases and the McCutcheon case is the Virginia governor's case, the McDonald case, where we see this tremendous relaxation of public corruption standards. And can we draw connections between the research you've done on Citizens United and parallel developments in the criminal law governing public corruption? I think we probably can. And then secondly, I'm going to be very, very provocative and throw in a name guaranteed to provoke: Noam Chomsky, manufacturing consent. Are we really in a world where we're watching manufacturing consent? Does the Supreme Court really facilitate this? So I've thrown a couple of metaphorical bombs here. What do you all think?
I'm happy to jump in quickly in responding. In maybe not the exact order, but yes, government officials can have private accounts. The idea is that we want to draw clear lines I think the public utility analogy is helpful. Some people use that kind of language to think about the platforms themselves, the Meta, X, other types of providers, about who they host on the platforms. And it's a little distinct than kind of the issue of when a public official creates their own space on those broader platforms, rents out the proverbial ballroom in a hotel, but that, it's for free and it's, from one of these sites, whether, that is a space that they have intentionally opened up to the public such that First Amendment protections apply, and kind of build, that's kind of what the current test is. And our suggestion of building in a rebuttable presumption just kind of balances some of the underlying interests of making sure that speech is, protected unless there's like a showing that it is not an official page.
Yeah, and I guess I'll just kind of bounce off of kind of your second question, which is, I think, so our paper is kind of concerned more with the nature of the space as opposed to the actor who's doing the thing that impacts the speech. But I do think that, I believe Professor Sastrom, she alluded to this in her presentation, which is over time, the court has kind of narrowed its state action test. It used to be, there are several very famous Supreme Court cases in the past, one whose name eludes me, but involved a completely private city. And there was an individual who was trying to, I think, proselytize, and it was a private city, wasn't publicly owned, but it had the company town, yeah, and it had the
Martin versus Alabama, I think it is. Am I right with that?
I believe so. I think yes. It had the quality of being a public, kind of a public forum, and so because I know there were some other factors as well. I believe the company had an off-duty sheriff doing its security work, but it had those qualities, and so the court held that it sort of held the town to be constitutionally responsible. It sort of applied the First Amendment to it, even though it was totally private. Similar to the internet. I know that court has kind of backpedaled, and its state action test is a lot more fact-specific. They require a much higher threshold to impose constitutional responsibility, but I do think it's possible that this public square test, given that it is the court is treating, and other courts as well are treating these totally private spaces as public squares, there could be some nexus between the state action doctrine and this public square in terms of how the court begins to perceive these private actors.
Professor Houston?
I was just gonna let him.
Okay.
Yeah.
Professor Brayton.
So it's back to me. So I'm really glad you brought up the McDonald case. Charles, I think you and I are, I think our minds think alike in many ways, and this is one of them, because I was planning on actually drawing a connection to the McDonald case, which is not a First Amendment case, but is a case involving statutory interpretation of the federal bribery statute and what constitutes an official act. And the court, is a unanimous decision, determined that the sort of access that what seems to the average person to be very clearly efforts at corruption by an individual who wanted the state of Virginia to sponsor scientific studies into a tobacco extract that his company had developed as some sort of nutritional supplement. It had given and paid for the governor and his wife. I can't remember what the final amount was. It was well over $100,000, but bought him a Rolex watch, paid for the inaugural gown for for McDonald's wife, gave it at least, I think it was $50,000 in loans for some residential property, and there was a lot of contact between the governor and his wife on the one hand, and Williamson on the other. And in exchange, he was given, this individual was given significant access to government officials to try to make his case. And the court found that that sort of conduct did not open the door to a violation of it was an honest services convict or an honest services charge, but they interpreted the official acts language from the bribery statute as part of the interpretation of the honest services statute. That even that kind of quid pro quo conduct didn't constitute an official act, because government officials routinely set up meetings and introduce people to other people and host events and things of that sort. And so McDonnell wound up, just kind of eviscerating a lot of the bribery charges that could be brought against public officials for the kind of conduct that I think most of us would think of as corrupt. What's interesting in part in making this connection, I think, is that in the campaign finance context, many of the justices, while recognizing that the reality and appearance of corruption constitutes a compelling government interest, say that the regulations often fail on the narrowly tailored prong of the analysis. And one of the reasons that the narrowly tailored prong fails is because they say disclosure laws and bribery laws are sufficient to address the corruption concerns in those contexts. But then the bribery law gets, again, eviscerated. And some of the same justices who have said disclosure laws are sufficient to address the corruption concerns would also find the disclosure requirements to be unconstitutional. So,
or if not unconstitutional, certainly onerous for when applied to themselves.
Yes. So, and I didn't quite catch your question about Noam Chomsky.
Oh, Noam Chomsky, Manufacturing Consent, his book, it's about 20 years old now. Do we really live in a democracy, or do we live in a world where consent is manufactured through, among other things, the corruption of large pools of money?
So I have to confess, I have not read Noam Chomsky since I was a graduate student in the early 1990s. And then my limits on his work at the time had to do with the difference between deep structure and surface structure of grammar. So I'll have to take a look at that, Charles.
Okay. Thank you.
You want to open it up to the audience questions? Go ahead.
Thank you. I'm more interested in this conversation that you guys started on around Pakenham, because I look at that case and I feel as if it's like under the overbreadth doctrine, striking the law down because of its just vagueness and its application so broadly, right? But I wonder if you all have looked at it in the sense of, when does a state's interest become so compelling as they can make laws to limit who can access social media and who cannot? Specifically, I asked that in regards to looking at, kind of the dangers that those spaces impose, and how some speech that's being put out there could actually be harmful to certain communities. Yeah.
Yeah, so we haven't looked at the cases using Pakenham that don't talk about that modern public square and use that language. So I actually have no idea how Pakenham has been applied to other cases where maybe maybe the bans weren't so broad, right? I don't know. I don't know. Yes.
No, but I guess as a follow-up, I do think, just as a hypothetical, if, say, the North Carolina statute at issue was more narrowly limited to preventing the use of for example, preventing the use of Facebook to actually engage in the conduct that the state was interested in, prohibiting or eliminating, which would be, for example, Mr. Packingham, who was a sex offender, if he was actually using Facebook to perpetuate that activity, then that probably would have survived scrutiny. But because it was so broad, and there was no allegation that he had actually used it to accomplish, what he was, what the state was actually interested in prohibiting, that was a relevant fact. The court brings that up in the opinion as well, that the state, he was prosecuted for just celebrating a traffic ticket dismissal. If the facts were different, the court probably would have gone a different way. But so in that way, it was a good case for Mr. Packingham and the people who were supporting him to fund that litigation.
We're going to stay in the public square area. Going off Professor Reed, what he had to say about the public square, where when we think of it, it's an actual physical place that nobody essentially owns, right? It's open to the public, whereas now with the internet, public squares are run through private servers. And so I'm specifically thinking about the shutdown of apps such as Parler after the UVA riots. How do you think courts will address that issue where private entities are stepping in to prohibit any action to even make it to the public square, any discord to come to the public square in the first place?
It's kind of a boring answer. I guess we don't know, because kind of how in the conversation with Professor Reed, they're kind of doctrinally, they're two separate areas. So the public square is it's the character of the space as opposed to the character of the actor. The court has taken a decidedly, I think, so it's like the composition of the court matters over time. It's been increasingly conservative. I do think that has an effect insofar as the court is much less likely to find state action unless you can really show significant involvement or encouragement by the state in the conduct itself, not just writ large. So they have to be involved in the specific conduct. So if you could show that the state was involved, for example, in encouraging Parler to shut down its servers in the wake of the riots, then I think you might find state action. Otherwise, I'm not sure, at least at this stage, that the nature of the space being pulled in under that public square umbrella really matters for purposes of the state action doctrine, although it might.
So perhaps here's my question. It wasn't Parler that shut itself down, it was Amazon that disallowed Parler to use its servers. Does that change your answer at all?
I still think probably not, just because of the nature of Amazon.
Right. Well, thank you to all of our speakers today. We really appreciate you making time for us. We're going to take a short, about 5-minute break, and then be right back in here for our fourth and final panel. Thank you. Welcome back, and to those of you joining us, thank you for coming to the Journal of Law and Public Policy's Fall 2023 Symposium, Free Speech and the U.S. Constitution. We are honored to host our fourth and final panel of speakers focused on combating bad speech and its effects, featuring Professor Brittany Raposa, Professor Enrique Guerra Pujol, Ms. Giovanna Vorn Montiero, and Dr. Caitlin Ring Carlson. Professor Raposa is a legal educator and family and probate law litigator at Raposa Law, focused on reproductive rights in the intersection of family law and justice for families. Professor Guerra Pujol is an associate professor at the University of Central Florida, where his research focuses on markets, property rights, and the philosophy of law. He's been widely published, including in JLPP's Spring 2021 edition, and we are very glad to have him joining us here again. Ms. Montiero is a graduate student pursuing her master's degree in law from the Pontifical Catholic University of Campinas in Sao Paulo, where she's focused her research on human rights, public policy, and sustainability. And finally, Dr. Carlson is an associate professor and chair of the Communication and Media Department at Seattle University, specializing in media law and policy with a focus on freedom of expression, social justice, and hate speech. We're so thankful to have each of them here with us this afternoon. As you can see, we are all, again, with a hybrid model, some folks in person, some folks virtually. So we appreciate the flexibility, and I would like to invite Professor Raposa to start off our final panel.
Thank you so much. I think I got the screen sharing working. I'm so happy to present on this issue today, mainly because when you think of free speech in the Constitution, family law doesn't always come to mind right away. And so I'm going to be discussing and writing on free speech and the right to parent and whether parents can have both of those things. So I'll first talk a little bit about the First Amendment right to free speech and how it interweaves some of the issues that are interwoven with the fundamental right to parent under the 14th Amendment Due Process Clause. Specific issues that come up in the family law context, using real cases that I've had recently in the past and that mimic closely other cases in case law where such orders regarding the restriction of parent speech has been upheld as fine and is constitutional. And then the tension between the right to free speech and the right to parent, and then final considerations that I'll be thinking about when writing this paper and continuing to think about as I keep exploring the tensions of the First Amendment and family law. And so we know that there are two rights at stake here. Essentially, we have the constitutional right to be a parent in the general sense, and then we also have the constitutional right to free speech. And so the Supreme Court has told us that the Due Process Clause encompasses the right to an individual to marry, to have a home, to bring up children, and to enjoy those privileges without government interference, essentially. And then we are also told or emphasize this right and how it's quite paramount and largely rooted in history. It's one of the oldest fundamental liberty interests recognized by the Supreme Court, it said, and that the custody, care, and nurturing of a child resides first with parents. And so the role of the probate and family court, essentially, a probate and family court gets involved when a family is no longer what we call an intact family. So either two parents are no longer together if they weren't married, or a divorce has happened. And so that's kind of the narrow context I'm going to be speaking about speech in. There's a lot of other family law matters, but I'm going to specifically focus on what happens when we had a family that was intact, and then it's now a family that is separated when we have parents and children. And so the family court is entitled to decide parenting decisions and child custody decisions for parents who can't agree. And so parents go to the probate and family court and seek assistance of the court, specifically the judge, to make determinations on who should parent the child, who should make decisions regarding the child. And from those decisions stems other orders from the probate and family court that can control other conduct or speech of parents. And they can do this because, right, the family court essentially is the protector of children. They're allowed to protect the health, safety, and welfare of its citizens who cannot support or help themselves, and minor children fall within that category. And so if you've heard anything about the probate and family court, it's likely been that it's the cornerstone of the best interests of the child standard. So in order to make any determinations regarding any issues regarding the children or really issues then that stem in relation to the parents, the court first typically considers the best interest of the child standard. And that's going to be any issues regarding custody, visitation, or parenting time, or what a parent can or cannot do. And so in most jurisdictions, a family court judge considers the best interest of the children as the primary factor, so paramount to all other factors that could potentially be considered in decision making. It's the one that holds the most weight. Other courts, which is not a majority of courts, make it one of many factors, and that factor is going to be decided equally with others. Even in the jurisdiction where this factor is technically equal with others, there's typically a lot of bias surrounding the best interests of the child being the paramount standard. And so it could necessarily be viewed as a problem, right? So one of the problems seen with the best interest of the child standard is that it's quite broad. It's typically not defined in statute and instead expanded upon in case law. And it's still not necessarily defined. It doesn't have a strict test that judges or courts have to apply. It doesn't have a specific list of everything a judge needs to consider and how a judge should consider those things. It provides the judge with a lot of flexibility and discretion in determining what is in this child's best interest. A judge can consider the child's age, the child's surrounding circumstances, the child's health, education, but generally, all statutes also have a provision that says that a court can consider any relevant factor in determining the child's best interest. So it's quite broad. It allows judges arguably unfettered discretions in making decisions regarding children. The best interest of the child standard, in which I'm focusing on, really becomes tricky with First Amendment considerations when we have a judge or a court that needs to make a determination regarding the child's best interest when both parents are fit to parent. Of course, there's going to be limits on parental conduct and potentially speech when there is a parent who is abusive, when there is a parent who has substance abuse issues and has characteristics that will make them lean towards the category of potentially being unfit and harmful to the child. But what I'm going to be focusing on in large part is when we use this best interest of the child standard in most determinations of custody and parenting time where both parents are arguably fit in order to parent their child. And so just a slight background on family court litigation. A judge potentially or a court potentially has a very wide area in which to restrict a parent's conduct or a parent's speech. Family court litigation is quite drawn out. It's not like there's one hearing and then the case is over. A complaint is filed and then there's typically many motions. A motion for what we call a temporary order, which makes a determination on custody and parenting time and potentially other issues affecting the parent. While the case is pending, that order can be modified. A complaint for contempt for noncompliance of an order can be made, in which then the court can make further orders restricting or perhaps commanding a certain conduct or speech. So they all work together to structure a parent and child's life throughout this process. And so the family court has multiple avenues in which it can control, restrict a parent's conduct or speech. So the central issue happening here with the tension between the First Amendment and family court is, right, in a general sense, can a parent be punished and can their right to parent be diminished or minimized due to their speech or their conduct? The answer is almost always yes, right? And then the more specific issue is using this vague and filled with discretion, best interest of the child standard at many times justifies restricting parental speech, and a parent's First Amendment right to free speech is typically or arguably violated. So there's many instances where the First Amendment can infringe upon a parent's rights or a parent's First Amendment freedoms can be minimized, right? But these are the things that we see most often. So there's the regulation of when a parent can see or contact or even associate with their child. There's a regulation of what family court information a parent can share with their child or a third person. So an order saying, don't talk about anything regarding court with your child. Don't talk about anything regarding court with any third person. A regulation of a parent's right to bring their child around third persons. So that could look like anything. The minor child cannot be around your sister during your parenting time, or you cannot bring your child to the park located on Main Street during your parenting time, right? So certain specific orders that prohibit the parent from bringing a child around third persons. A regulation of what a parent can speak about on social media. And I'll talk about that a little bit more, but the family court typically makes orders regarding what a parent can say on social media or what they cannot say. Judicial determinations of custody and parenting time based on speech or views. So if a parent is so we've seen this recently in some lower court decisions. If a parent is pro-abortion and a judge makes a determination regarding a parent's custody based on their political views, or a parent is perhaps homophobic or they are pro LGBTQ plus community and issues based on parenting time are made based on their views. Judgments ordering a parent to bring their child to church, potentially a church that the parent doesn't practice that particular religion. Restrictions on speech, where the speech is seen as inconsistent with the religious education of the custodial parent. So if the child is primarily with parent A and that parent is of the Catholic faith, parent B may be ordered to not talk about the Christian faith, right? If they are a practicing Christian, since the custodial parent or the parent the child is primarily with practices a different religion. And then judgments ordering a parent from bringing children near new significant others or spouses. And like I said, these are just the most common, but there are other ones. And then these are the particular provisions that have been upheld, right? Neither parent shall make negative statements about the other in the presence or hearing of the children or question the children about the other parent. So again, just specific limits on speech and what a parent can say or not say. The parent shall communicate directly with each other and shouldn't talk to the children or use the children as a messenger. Children shouldn't be exposed to court papers or disputes and things of that nature. These are also common family law provisions and ones that I have seen recently ordered by judges with my clients or colleagues' clients. So mother shall not under any circumstances allow the children to be in the presence of a significant other. Father shall not bring the children to his girlfriend's home when exercising his parenting time. Mother shall, during her time with the children, bring the children to Sunday Mass. Although mother does not practice the Catholic faith, it is important to create religious continuity for the children when they are in mother's care, forcing the mother to then go to Sunday Mass. Father shall not take the children on a jet ski during his parenting time. Neither parent shall post about this family litigation or about each other on any social media platforms, including but not limited to Facebook, Twitter, and other accounts. Neither parent shall disparage the other parent to any third parties, right? So if a parent is with their friend and says, I hate my ex-spouse, and that somehow gets to them, are they in violation of a court order for what they say? Father shall be permitted to contact the child on Tuesdays at 5 p.m. via FaceTime. Father shall limit communication with the child to this time only, so the child's routine and schedule is not disrupted. So a parent's limitation and restriction on speech as to when they can even contact their child and communicate with them. So we see this existing tension. Parents have a fundamental right to control the upbringing of their children, but through the best interest of the child standard, family court judges can exert tremendous power in parental decision-making, relationship, and control a parent's speech. And so, First Amendment is rarely discussed in family court, and little to no analysis is done regarding free speech issues when making orders. So, orders are made in family court, but there's no rationale attached to those orders. And so finally, these are the questions that I hope to consider when thinking about these tensions. So, are a child's interests compelling enough to override parental claims to free speech? Can parents have both free speech rights and the right to parent simultaneously? Is it fair to limit the free speech of parents in separated families, but not intact families? So, is there a specific erosion of First Amendment freedom for only specific types of groups of family who happen to have to enter the probate and family court system, where other parents are not experiencing that restriction on speech when we have an intact family not within the probate and family court system? And is there a balance to protect a child's interests while also protecting a parent's free speech rights? And so, really looking at the issue of whether the family court should now arguably make rationales and decisions not only on the child's best interests, but also analyzing whether the child's best interest is outweighing some parental, one of the parents' First Amendment freedoms, and whether it should be. Thank you.
Thank you, Professor Raposa. I will now welcome up Professor Guerra-Pujol to offer his remarks.
All right. Thank you, Olivia and Mike. It was great to meet you last night. Thank you, Professor Reed, to meet you in person. I'm especially honored to be back here. I did a virtual presentation on the Alternate Realities, Conspiracy Theory, and Democracy Symposium in 2021, and I'll make a brief reference to that paper. Oh, good. I was going to go back actually because I wanted to make an apology. I changed the title of my talk because I try to be intellectually honest, and if you look at the program, my original plan, and what happened was in September, I believe, when the deadline was, I was going to do this idea, which I'll discuss in a moment, of using it's called mechanism design in economics. It's called specifically a dominance assurance contract. It's Kickstarter with a twist. And as I was developing my idea, writing the paper, I just realized it's not going to work. So I had to scrap that. I had to scrap that idea, and I'll explain why in a moment. I'll say more about that. But this is just a quick outline. I've actually posted this paper to SSRN, Social Science Research Network, under the new title, Solving the Free Speech Dilemma. And the main thing here that I want to say is that I'm going to try to keep under my time so I can get re-invited again in the future. And what that means is when I reach the part of objections, I'll just leave that for Q&A or for those who want to write the paper, and focus more on what the idea is. So first I want to talk about what I'm calling the free speech dilemma. And what is the free speech dilemma? On the one hand, if we adopt a laissez-faire attitude toward speech, how do we screen out disinformation or lies? And by the way, there's a whole literature on what is false information versus disinformation versus misinformation. But I'm just going to, as a blanket, just bad information. If, on the other hand, if we attempt to screen out bad information via content moderation policies or other forms of censorship, how do we distinguish falsehoods from truth? Was Lee Harvey Oswald, for example, part of a conspiracy to assassinate President Kennedy? Did COVID-19 really originate from a lab in Wuhan, China? Were the 2020 US presidential elections stolen? How do we define stolen? Did Jeffrey Epstein kill himself? I mean, we could go on and on about various things that are posted on the internet that there are different partisans. Now, in principle, there are three types of responses, to this dilemma are possible. By the way, one of the things I learned the hard way, writing law review articles and peer review and getting students and faculty to read my work is never start a sentence with there is or there are. That's probably the worst things you could do. It's a very boring way. So 3 types of responses to what I call the free speech dilemma are possible. And by the way, this dilemma, of course, is in the context of internet speech, right? Where the marginal cost of posting something, reposting something, is basically zero. Once you have a laptop, once you have a smartphone, et cetera. So here are my 3 types of responses. 1, hardcore government censorship, what I'll call the communist China model. Soft censorship, and so I should also have President Xi up there, but to not offend sensibilities, not to do that. Soft censorship or content moderation, which I'm calling the Mark Zuckerberg model, but really all the big tech companies and all social media platforms have some form of content moderation. I just think that Zuckerberg's probably the most clumsy about it. And absolute free speech, which I'll call for short the Elon Musk model. Of course, with the caveat that Elon Musk is not really about free speech. Try criticizing Elon Musk on Twitter and see what happens. One of my students, Jack Sweeney, actually is the student who created the bot that could follow, that does in fact follow, he's now on Threads, that does follow the private jet of Elon Musk and the private jet of Zuckerberg and Bill Gates and many others. I think even Donald Trump, Air Force One, all using publicly available information. Now, whether it's wise they should do that, and this and that, I'm not going to discuss that, but I thought it was pretty creative and pretty cool. And of course, my theory is that's a real reason why Elon Musk paid the $44 billion to buy Twitter so he could kick him off his website. Again, we could subject that conspiracy theory or that is that false information. But anyways, so these are the 3 models. And under the Chinese model, right, government strictly monitors internet access and blocks website content wholesale. While what I call the Zuckerberg or soft censorship model consists of some combination, right, of content moderation, deplatforming, shadow banning, and other forms of speech suppression. By the way, it's been a great, I can follow up at the end here, because that's all the stuff we've been talking about in the previous panels. Free speech absolutism, by contrast, right, is the most permissive or laissez-faire approach to this problem of disinformation. Everyone is free to post whatever information they want. I'm assuming, right, so long as no laws are being violated. Alas, here's I think my contribution comes into play. None of these solutions is capable of distinguishing truth from lies in a reliable or consistent manner. The main problem with the Chinese model and with any type of content moderation approach more generally, right, is that one cannot, so I'm going to just lump Zuckerberg here with Chairman Xi. You can't determine ahead of time, right, what's false, as we've seen with the COVID lab leak theory. Even Jeffrey Epstein, there's some questions that have been answered. Stolen election narrative, it's really never been answered how all these laws were changed to permit voting, make it easier for people to vote from home. So we cannot always determine ahead of time what theories, conspiracy theories, or disputed news stories are true and which are false. By the same token, with free speech absolutism, and I wish Nadine were here, push back on this, but there's no real disincentive for posting false information on the internet, since the marginal cost, and this, as I mentioned, right, marginal cost of posting speech is virtually, is zero. Also, to the extent, and then this is, something that's been discussed earlier, to the extent many internet users, well, I like the term motivated reasoning, where you just like the stuff that you already, conform with your priors, right? Free speech absolutism might actually exasperate the problem of false information. So what is to be done? And let me go through just really quickly. This is now that we've talked about what the free speech dilemma is. Right, on the one hand, if you're too permissive, you get a lot of garbage. On the other hand, if you're too restrictive, do you really trust Zuckerberg or Chairman Xi or to get it right? Here I think is here is worst idea ever. So Kevin Roos, in this New York Times op-ed in February 2021, right before our conference, by the way, the spring symposium that year, recommended what later the government tried to implement. And I won't go, this is a whole separate paper. This whole thing had to get disbanded. Once the public got wind of this became a huge controversy. I just call it the worst idea ever. I think for the reasons that Nadine Stroessner explained in her question and answer session. Second best idea. Here's what I'm going to, I'm going to propose a market for truth. And I want to say here that the idea of and so everyone's talking about the marketplace of ideas as a metaphor I actually want to see, if this could be really happen. And so while this paper is just a thought piece or thought experiment, I am looking for a co-author that could help me design this kind of a market prototype. But I want to say as a shout out, the idea, because I think this is important, the idea of using financial incentives to uncover false information on the internet has two recent antecedents. And one is Marshall Van Alstyne's paper, Proposal, a Market for Truth to Address False Ads on Social Media. And the other is another paper that I've summarized, is a paper by Jonathan Arbel and who I know personally, great guys at Alabama, and Matthew Gilbert. And their paper is, which I believe is going to come out in the University of North Carolina Law Review, Truth Bounties, Market Solution to Fake News. Now, in summary, under Professor Van Alstyne's ingenious proposal, social media platforms like Facebook and Twitter would require advertisers to guarantee the truth of their ads. How? By requiring advertisers to put a large sum of money in escrow as a quote-unquote honest ad pledge that the claims being made are true. Anyone who doubts the veracity of the ad could dispute it, but they would have to pay a non-refundable fee first, kind of like a court filing fee. If anyone decides to dispute the ad, then an independent fact checker, and I think Van Alstyne in his proposal proposes, like there's a couple of these organizations, would judge the truthfulness of the ad. And if the ad proves false, right, here's where the monetary incentive comes in. The disputing party, right, would then receive the advertiser's pledge. For their part, Professors Arbel and Gilbert propose a system of truth bounties. What's cool about their proposal, it wouldn't just cover political ads, it would cover all kinds of claims on the internet. And so the idea is that, and really the other difference is that they would replace the independent fact checker with an actual arbitration panel. And by the way, this is an idea that I initially proposed in the context of conspiracy theories, which was our topic in the spring 2021. I had actually proposed a conspiracy theory court, but it'd be like a group of private arbitrators to determine the truth values of any given conspiracy theories. But as problem with both of these, I think these market-oriented proposals are a step in the right direction, since they attempt to harness financial incentives, such as either escrow accounts in the case of Van Alstyne, or bounties in the case of Gilbert and Arbel. Both, I hate to be that guy, but both are doomed to fail in actual practice. For starters, Van Alstyne's proposal, but it's not the fact that it's just limited to political ads. It assumes the existence of an independent fact checker, right, that everyone can agree to ahead of time. And in reality, there is no such thing as an independent or bias-free fact checker, right? No individual fact checker, no matter how smart or respected, will be free from bias, because biases are inevitable. Let's start there. That's a cognitive psychology literature. And the degree of independence of any individual fact checker is always going to be called into question, right? Especially if you lose on the, whatever they're claiming to be a fact. And there's a whole literature on this as well. By the same token, I think the other proposal, the truth bounty proposal, though again, step in the right direction, right? It enlists this dedicated body whose members can be trusted to collectively arrive at the truth. And I think that's a step in the right direction. I think a collective body, this is the so-called wisdom of crowd literature, is actually a good innovation. But how are they, what are going to be the rules? This is presumably by majority vote. But putting that to one side, the flaw with this particular proposal is that a small body of so-called experts or arbiters is really no more likely to arrive at the truth of a disputed, fake news story or conspiracy theory than a sole independent fact checker is, And that would be subject to empirical testing. Because I'm down to just a few minutes, I'm just going to go to my proposal. And my proposal would be, basically, we have prediction markets, beginning with the Iowa electronic market. We have now Kalshi, which was actually launched in July of this year, if I'm not mistaken. We have a bunch of other kind of, I don't think they're as user-friendly as Kalshi, but it's predicted. Now there's, what I would do is just extend the prediction market model with a tweak, and the tweak would be, to have backward-looking contracts, what I call belief contracts now. Now, I'm not going to use the dominance insurance contract model because that requires, though it's really cool, look it up on Wikipedia, I discuss it in the paper, but it's just not going to work for the same reasons I say Van Alstyne and Arbel and Gilbert's proposal is not going to work, because that's going to require whoever creates the dominance insurance contract is going to have to determine, it's basically Kickstarter. Someone's going to have to determine, well, what is the truth of the claim, that the contract is about, and we're back to where we started. Whoever that person is going to be is going to have bias. Even if you have a collective group, you might be in the step of right direction, but how is the collective group? How are they going to be chosen? What voting rules will they use? So why not? And so I call this a Hayekian approach. Why not just have a market and have a bunch of people? And what they're doing is they're buying and selling belief contracts. And this, by the way, addresses a key ethical problem with most prediction markets. Two key problems. One is a problem of manipulation. Prediction markets are basically you're betting on event contracts on something that's going to happen in the future. So if I have large enough stake, in the outcome of a game, you know what I mean? Then maybe I'll pay a player to throw the game, or at least, score a few less points so that we're within the spread or whatever. And this, but in the political context, it's called the terrorism futures problem. We have people betting on assassination of world leaders or coup d'etats. So here, because these are all backward-looking, we just solve that problem once and for all. Specifically, the structure of these belief contracts, it would be a binary option. It basically would be like an event contract, very precise statement, but about a past event. Did Jeffrey Epstein commit suicide or not? Did Lee Harvey Oswald act alone, et cetera, et cetera. And then the options, it would work like a price market where like a prediction market where the price of the contract would reflect, the demand and supply conditions of how many people are buying what I call true, T contracts, yes, this statement is true, or are buying, the opposite type of contract. Here is, I think, the key advantage to my thing. This could be very Quixotesque, you know what I mean? I was a Spanish literature major, so, it's one of my literary heroes, the Quixote. So I do need that Sancho Panza to keep me grounded. But the idea is you don't need experts for this. And the market would just stay open, so people could just come in and come out of the market at any point in time. That, however, all my reviewers, people I've shared the article with, is really there's two main objections. I won't go over all of them, leave that for Q&A, or you can read the paper. But one is, unlike a prediction market where there is resolution, right? Either the event happens or it doesn't happen by the specified date, this market would stay open. I say, like, big deal, markets stay open all the time, like a stock market, But the other problem, and this is a problem I'm grappling with, it's the Keynesian beauty contest problem, What are people really betting on? Are they really betting on whether they think the event really, happened in the past or not? Or are they betting on what other people think, whether the event happened or not? So that's something that I'm actually exploring, and it's actually why I love this particular project, because the Keynesian beauty contest problem is something that's been fascinating me for years. And so I think this is a good time to test, because markets do work, right? Stock market, when Keynes made the beauty contest objection, he was actually talking about stock markets, but stock markets generally work, and there's, different versions of the efficient market hypothesis, from the strong version to the weak version to complete rejection. That's another thing that this could test. And this time I didn't go under time, but I stayed within time. So thank you for your time and attention. It's great to be with so many young people and students. And it's not every day that you get to be in a conference with with my hero, Nadine Strasser. So super honored about that. Thank you.
Thank you, Professor. I'll now invite Ms. Monteiro to offer her remarks.
Good afternoon, everyone. Thank you for being here. It's a true pleasure. Let me share my screen. Here we go. So my name is Giovanna Monteiro, and this is my first time doing an international work presentation. It's my first experience speaking with Americans, and I'm thrilled to have this opportunity. Thank you all very much. And before I actually delve into my theme, the duty of care of digital platforms in tackling fake news in the light of freedom of expression in Brazil, I will introduce a little bit of who I am. Therefore, I'm a Brazilian master student in law at Pontifical Catholic University of Campinas in Brazil. And here I will use my Portuguese accent, PUC instead of, and here I will use the acronym PUC with my Portuguese accent PUC instead of PUC, which is located at São Paulo State. I am in the area of concentration of human rights and social development, in the line of research on human rights and public policies. And I have my studies involving energy transition, artificial intelligence, data protection, in which I maintain parallels with the Paulista Center for Energy Transition, CPTEN, Living Laboratory of the State University of Campinas, UNICAMP, to investigate the legal and regulatory aspects fundamental for the development and technological information like artificial intelligence and the Internet of Things apply to the electricity sector, since UNICAMP doesn't have a law school. So as a result, they enter into a partnership with PUC's researchers to study those regulations aspects, which the focus of my research is data protection regulation within the scope of smart grids. Said that, just for curiosity, I don't intend to dwell too much on this subject. Nevertheless, this is the PUC Campinas Law School where I am currently studying, located on your campus 1, and this is UNICAMP. Interesting thing is that both universities are located opposite each other. So if you look closer to the picture of Campus 1 at the bottom of this image, you can see UNICAMP. All those buildings are already UNICAMP. Furthermore, it is also important to say that both UNICAMP and PUC Campinas are considered the best universities to study in Brazil, especially UNICAMP, considered one of the 3 best universities in Latin America. Finally, to conclude this small introduction that I've prepared, I bring you these 2 images, one of the city of Campinas, which is located in the state of São Paulo, where I'm speaking from, and where the 2 universities are located, and one of the capital city of São Paulo, 2 cities with the highest economic index in Brazil, with a distance of only 100 kilometers each other. And just for comparison, the capital of São Paulo is basically the New York City of the USA, even though the real capitals of Brazil and the United States are Brasilia and Washington, D.C., respectively. Thus, the subject of my work, as I've already mentioned, is the duty of care of digital platforms in tackling fake news in the light of freedom of expression in Brazil. First things first, kind of similar to First Amendment protections of USA, I brought the Article 5, the heart of the 1988 Constitution of the Federative Republic of Brazil, which establishes and protects fundamental and human rights in sections 4 and 9, freedom of expression as the respective right of all citizens, both the expression of thought and the expression of intellectual, artistic, scientific, and communication activity. From this perspective, the aim of my proposal is to take a legal approach to the duty of diligence of digital platforms in dealing with fake news. Therefore, what is duty of care? I bring Liz Nóbrega's definition, which is a legal principle of Brazil's civil law based on the assumption that people, both individuals and companies, must adopt the necessary and reasonable measures to prevent damage from occurring as a result of their activities. What is happening now with digital platforms is that the application of the duty of care is being legally discussed, and this is mainly due to the great participation that platforms have in the population's daily communication flow, given that our society is adopting a new communication paradigm, whose way of expressing and informing is accompanied by the use of technology through the connection of mobile devices with access to countless digital platforms that make it possible to materialize the fundamental right to freedom of expression. However, at the same time, as outlined by Lee McIntyre in his work Post-Truth, are an instrument that also facilitates the manipulation of the format of the news, sparking the term fake news, allowing the favoring of erroneous content and biased beliefs that confuse its recipient, this dissemination of which deserves a critical look to confront. The problem in my work is that recognizing the duty of care as a set of measures capable of reducing the risks that the network promotes, such as imposing accountability and control of the circulation of false information on platforms, is legally blocked by Article 19 of the Brazilian Civil Rights Framework for the Internet. In our Portuguese saying, it's Marco Civil da Internet, or MCI, which exempts platforms from responsibility for content and damage resulting from illegal acts committed by third parties, and requires the removal of offensive content only through legal action, as well as the federal constitution in its Article 5, Sections 4 and 9, which established that the expression of intellectual, artistic, scientific, and communication activity is free, and in paragraph 2 of Article 220, determines the prohibition of any censorship of a political, ideological, and artistic nature. And despite this, our Supreme Court wants and is still debating the legality of Article 19 Civil Rights Framework for the Internet, MCI, to target digital platforms and impose liability on them for those kinds of content committed by third parties, which is a case similar to USA Supreme Court's assessment of the legality of Section 230 of the Communications Decency Act, which, like our legal provision, exempts digital services from liability for content posted by users. And from what I've already researched, I've seen that the US Supreme Court has decided to keep this provision in force. This leads us, Brazilians, to the following question. If Article 19 of the MCI is declared unconstitutional in the face of other personality rights, such as physical integrity, honor, among other rights that are also enshrined in Article 5 of our Constitution and are inherent to the individual sphere of each person, how will digital platforms react? What are the impacts of demanding the removal of content from internet users under penalty of fine? Platforms afraid of being penalized if they do not remove something will act intensely, even removing legitimate content from the network. Would that be a result of the fear of penalties? Can a chilling effect occur? This allows us to talk about a limitation that happens before the expression of opinions to be uttered or published by users, leading to the silencing of ideas due to prior and unbridled censorship of reasonable and legitimate digital content on the network by the platforms that occurs through legislative sanction. With this in mind, the aim of my proposal will be highlight the importance and the need to respect freedom of expression, carrying out a comparative analysis between the fundamental right of freedom of expression versus the duty of care of social networks in confronting the circulation of fallacious information, focus on heteronymous normative sources in Brazil, seeking to establish a connection where applicable with those of the USA. In order to confirm whether the legal attribution of accountability of social networks contributes to a certain extent to combating the spread of fake news respecting the principle of communicative freedoms, and investigate if misinformation is a matter of social understanding, making it necessary to provide citizens with quality information for their major participation in democratic debate through the implementation of a public policy that encourages media education, that allows users of these social networks to investigate digital information on their own. With this concludes my presentation, and I would like to thank the entire Journal of Law team and the University of St. Thomas for all the support from the very first email I sent to Professor Reed, to Mrs. Boyer, and I'll be at your disposal, and I want to thank and hear the comments and considerations from those in present. Thank you once again.
Thank you, Giovanna. Last but certainly not least, I'd like to invite Dr. Carlson to share her remarks today.
Great. Thank you so much. I'm really happy to be here with you all and also appreciate the flexibility offered by the virtual format. You can see the title of my paper here. I actually want to start with a little bit of levity because I think there is a lot happening when we think about expression and how we do or don't regulate it on social media. And so, whether that's, as we've heard earlier today, kind of how social media is used by public officials, or the upcoming net choice cases where we're going to see whether, the government has a right to force platforms to carry certain content. There's just a lot happening. And so the particular thing that I'd like to dive in and look at more closely are these new transparency laws out of New York and California, which essentially require social media platforms to adopt certain policies and practices around how they regulate hateful content. The question that this specific paper seeks to answer is whether these transparency laws are likely to be considered constitutional, and if not, spoiler, what is the analysis of the arguments being offered in favor of and against really tell us about a potential path forward. So my interest always is to minimize hate speech on social media while also, protecting the right to free expression for both users and for the platforms themselves. So what I want to do today is essentially look at these two laws, look at some of the key arguments being offered, and in that analysis, hopefully carve out a potential path forward. So the Hateful Conduct Bill is a bill that was passed in New York that was essentially a response to the Buffalo mass shooting. So many of us remember the mass shooting in Buffalo at a grocery store. A white supremacist walked in, killed 10 Black shoppers. The event was live streamed on social media, went viral. And so the governor of New York, in response, essentially asked the Office of the Attorney General to look into it. And the response is this law, right? So you can see up here how they're defining hateful conduct. Essentially, the key parts of the law are that they require platforms to have an easily accessible mechanism for users to report incidents of hateful conduct, and then also for the platform to respond to those individual reports, letting them know, how the flagged content was handled, whether it was rude, left up, etc. It also requires platforms to actually have a specific policy about hateful conduct and make that available. The penalties are civil, $1,000 a day, or no more than $1,000 a day for noncompliance. Now, the California law is a little bit different. So it's worth noting that in California, they actually already have a law in place that requires platforms to post their privacy policy. This law would build on that and essentially require networks to post their terms of service and then provide reports that will eventually be made public that outline their content moderation practices, particularly, and it's funny, these 5 elements are listed towards the bottom of the law, but they do call out these 5 areas and say, hey, you've got to tell us what your policies are about these specific things. They also require transparency reports. So national transparency reports that say, how many posts were reported that violated, for example, their content policy on hate speech, what the decision was in terms of leaving up, taking down, what action was taken. These are somewhat similar to the transparency reports that a lot of platforms already provide, but these would go even deeper. So what I want to do today, and kind of where I think the meat of this discussion lies, is looking at the issues raised. The New York law has actually been challenged. Eugene Volokh, who I think a lot of us are familiar with and likely subscribe to his conspiracy theory blog and email, he, along with a platform called Rumble, challenged this law in the state of New York, and a district court judge issued an injunction. And what I think is really interesting is kind of the insight that that decision provides us into how judges are thinking about these different issues that are raised. Some are fairly straightforward, where others, you can see the two that I've highlighted, I think are really ripe for discussion around kind of what a transparency law that doesn't violate the First Amendment might look like. So again, I'll kind of run through these. Some are pretty simple. Some I think require more in-depth consideration. So the court here agreed that the law is clearly content-based. They cite Rav and Snyder and remind us that no, in the United States, you can't prescribe speech based on content. If you do, it's got to pass strict scrutiny. They also agree that it's likely this law could chill speech, right? There's also some a lack of clarity around the terms like humiliate or vilify. What does that actually mean? When it comes to strict scrutiny, I tend to agree with the district court judge here that the state really doesn't thread the needle. So the claim that the state is actually making is that it should pass strict scrutiny because this law against or around hate speech policies on social media is necessary to prevent mass shootings. But, the state really doesn't thread the needle. And it's honestly kind of hard to read when you think about placing the blame on media or social media specifically without even mentioning the role of the automatic weapon used in this shooting, which is legal in New York. That's a different symposium and a different paper, but I think worth noting. The two pieces that are, I think, really interesting and worth kind of digging further on are this idea around compelled speech, right? And I know a lot of us, myself included, were enamored with getting to hear Nadine Strossen speak earlier today, and she touched on this a little bit. But when the New York judge was asked to kind of wrestle with this idea of, are regulations on platforms, content moderation policies, a form of compelled speech? He said, absolutely, they are. And he actually cites both NIFLA, which, as a reminder, is the Supreme Court case that essentially said, a law requiring California pregnancy centers to provide information about abortion access was compelled speech and unconstitutional. He cites that, and then he also cites the 11th Circuit net choice case. And so that case is one which struck down the Florida law and basically said, that content moderation decisions about what speech to allow or not allow are a form of editorial judgment. And so, we could see how laws like this one in New York would be considered unconstitutional. That position is at odds with what the Fifth Circuit says, right? So in their net choice case, looking at the Texas law that also essentially requires platforms to carry protected expression, even if it violates their own community standards, right? The Fifth Circuit says, wait a second, right? These platforms are really common carriers. And in fact, they are not exercising editorial judgment when they have content moderation policies. And so in the Fifth Circuit decision, we hear the Court of Appeals talk about intermediate scrutiny as the level of review that would apply. And so we've got some tension there around this question of, are content moderation policies a form of editorial judgment? And when we start to think about Section 230, it gets a little messy, right? And the Fifth Circuit case, for those of you who have read it, right, it really, it hinges on this idea that, platforms have been telling us for years that they're not making editorial judgments and aren't responsible for what's on their platforms. And so they're kind of taking a different tact here. But this area, I think, is again, really complicated and nuanced. I think social media platforms are not the same as newspapers. And so we may need a new way of thinking about compelled speech, content moderation policies, and editorial judgments. So I'll come back to that here in a second. This question around commercial speech, I think, is also really interesting and worth digging into. The case in New York raises the question of, are content moderation policies commercial speech? The judge there says, no, I think there's some room to push back on this, right? I agree that it does more than, simply propose a commercial transaction. But I think if we look to commercial speech disclosure rules around disclosures that involve speech, we might get some guidance there. So we'll come back to that. On the 230 argument, the judge in New York is basically saying, not buying it, right? There's no liability imposed on platforms for either failing to respond to particular reports or giving them any liability for what users are doing. So that's kind of moot. Now, when it comes to the California law, all we have right now is the complaint from X, aka Twitter. You can see the arguments that they're making outlined here. Some of these I think are pretty interesting and worth our consideration. They talk about the legislative history of this law and say, really this law is a roundabout way for the state to get us to regulate more protected speech than we might choose to, right? They also say that the requirement in the law that they would disclose their policies around the different kinds of content moderation, whether it be hate speech or harassment, those 5 that are specifically listed in the bill, they say, wait a second, that's forcing us to speak about political issues, right? And so I would personally push back on that, but the example that they might give is, if our hate speech policy needs to say whether dead naming a trans person violates our hate speech or hateful conduct policy, that puts them into the fray on these political issues. Again, I can think about a lot of disclosures related to, let's say, like requirements by the EPA to disclose what chemicals are on a site that you could say, well, that's political. I don't want to necessarily get into that. Again, I think there's some room for debate there. The other really interesting thing is the law requires disclosures around the actions that the platform has taken at a national level. And so they cite specifically to the Dormant Commerce Clause, which, as a reminder, prohibits state legislation that discriminates or unduly burdens interstate or international commerce. And so they're basically arguing, wait a second, this is a California state law, and you're telling us we need to provide national level reporting. That provides a burden on us. It violates this clause. And therefore the law should be nixed. I do think there's potentially something there. They cite to what is it? The National Pork Producers case, which struck down a law in California that said, you can't sell pork in California that wasn't raised humanely. Supreme Court hears the case, says, wait a second, pork is mainly raised outside of California. So you can't necessarily make that law that would impact all these other areas. And so I think there's something there. Again, when it comes to the 230 argument, I don't think there is much ground to stand on. You can't really say that this law violates their shield from liability because there's no liability being for what users do. So I think for me, the best path forward is one that tries to get away from this content-based approach and instead goes with something much more content neutral. So, just to sum up, I don't think the New York law is constitutional. I don't necessarily think that we're going to be finding that the California law is constitutional, particularly because it calls out those 5 areas and then also requires national level reporting. But what this analysis does tell us is that were we to develop a transparency law that was content neutral, so rather than saying, you have to share your policies on these specific things, said you just have to share your policies, right? That users have a right to know how you're making decisions about what does or doesn't go on your platform for a variety of different reasons, including to tell, which platforms we want to spend our time on. I think if we can find a content neutral policy and also move to a state level reporting mechanism, right, where you're only required to report your actions at a state level, then we might really have something here. So, if we were to propose something like that, would it be considered constitutional? I think the answer to that question is going to be driven a lot by the precedent around commercial disclosure laws. And so I think I mentioned Zouderer earlier. The standard in Zouderer is essentially that disclosure that relates to factual or uncontroversial information is only subject to rational review. They also look at things like whether it's related to the speaker's services or is needed to prevent deception. I don't think we're at that level, right? And I mentioned NIFLA, the court struck down those disclosure requirements, said it wouldn't even survive intermediate scrutiny. And so I think, again, there's a place to negotiate like where the line is. Could we argue that intermediate scrutiny is the level of review that would apply to a content neutral transparency law? I think so, but these kind of key questions around are content moderation policies a form of editorial judgment, I think are going to determine what level of review. But, I hope and I argue in the paper that content moderation policies are in fact a form of commercial speech because they do communicate factual information about the service, and they do influence our decision about which product or platform to use, right? I don't have an account on Gab because I know how they allow for a lot more hate speech than I would be comfortable with. So I think if we were to pursue this content neutral transparency law, Central Hudson would apply. As a reminder, Central Hudson requires a substantial government interest. The state's responsible for demonstrating that the regulation advances that interest, and it's got to be narrowly drawn. And so the two government interests that I would point to as justification for a content neutral transparency law are ensuring that the public has access to information about the terms of service, about community standards, so that we can make decisions about what platforms to use. Whenever I think about this, Virginia Pharmacy comes to mind, right? So there the state said, the government can require disclosures about how a product works so that the users have a chance to decide whether this is something they want to use. The other thing, and I think this is really where transparency laws need to kind of find their footing, is a First Amendment argument, right? We know that in the past, content moderation policies, community standards have often been developed in ways that were biased and also enacted in ways that were biased. And so I think that as a public, we have a right to know what policies are being used to regulate speech on these platforms in order to protect expression, ensure that everybody has a right to express themselves on these platforms. So again, I'm right at 15 minutes, so I'm going to call it. I do think, the SCOTUS answer to questions about content moderation in these upcoming net choice cases is going to make a difference, but I think there's a way to thread the needle and find a way to use content neutral transparency laws to better put some guardrails around content moderation as a practice. Thanks so much.
Thank you, Dr. Carlson, and thank you to all of our speakers this afternoon. We'd like to open it up for questions now, starting with Professor Reed.
And I'd like to thank each of the presenters. A wonderful final set of papers. Thank you so much. And Professor Raposa, I'm going to begin with you. And I found your presentation very, very interesting from the standpoint of First Amendment free speech theory. And that is, how do we reconcile on a constitutional theoretical level the dense body of regulations, restrictions, and case law that you've identified that permeates family law with the mainstream of First Amendment jurisprudence? I think that's one question that occurs to me. A second question that occurs to me is the distinction you drew between separated and intact families. And I'm wondering there whether you have not only a free speech interest, but also an equal protection interest in having these families be treated more similarly. Perhaps the distinctions, the differential treatment might be subject to an equal protection analysis as well as a free speech analysis. Enrique, thank you so much. Thank you so much. But I'm going to pose a challenge to belief contracts, and that is, who would be the market and who would be the market makers? And how thinly would the market be traded? And if the market is too thinly traded, will it be subject to manipulation? And what are the motives of the participants in the market? Is the motive of the participants really to identify, ascertain some underlying truth? Or is it the purely instrumental means of making money? And so driving not an interest in discovering truth, but driving an interest in profiteering perhaps off deceit. Ms. Montiero, thank you so much for your presentation. I'm interested in two aspects of your two aspects of your presentation, and a question that about Brazilian politics that I'd like to pose to you. And the questions I have about your presentation is the intersection of Article 19 and the relationship that presents between the state and free speech. There seems to be a more active role in Brazil regarding the role of the state than we see in the United States, where it's much more free form. And so I'd like you to, if you could, compare and contrast the two systems. But I also have a question about Brazilian politics. And that is, I did follow the election between Lula Inácio da Silva and Bolsonaro. And I know that there was a very close moderation, very close regulation of the speech content of that campaign. Would you be willing or interested in elucidating on that and connecting that perhaps to Article 19 or other provisions of the Brazilian Constitution? And finally, Professor Carlson, thank you so much for your presentation. And I agree that the path forward that you identify must be content neutral. As you were describing California law in particular, I was taking notes, particularly the language about radicalization. Radicalization is dare I say, at the heart of so much of free speech jurisprudence. From Gitlow all the way forward. Gitlow, Abrams, the Communist Party case of the 1950s, all the way forward. Radicalization is one of the centerpieces of the First Amendment, and one of the things we're concerned about protecting. Well, what we don't want is someone blowing up buildings, obviously. We don't want people acting on beliefs. But the formation of, let's say, to take some of the classic 1920s cases, the formation, articulation of beliefs that the Soviet Union might represent a superior form of governance. Well, those cases were adjudicated and decided, and that certainly represented a form of radicalization that the First Amendment was deemed to protect. So I find the California law unsettling. And I'm glad you're charting a neutral course forward that seems to be more in conformity with historically important First Amendment values. Thank you.
Sure. I think that in regards to your first question about the First Amendment jurisprudence, in family law, to be frank, there hasn't been much association between First Amendment violations and that of the parents, mainly because the almost, I guess we can say, shield is always, well, all of our determinations are made in the best interest of the child, and your First Amendment freedoms and your right to parent are not absolute, right? And so that shield of the best interest of the child standard and, making decisions based on the child's best interest has been almost like a shell that hasn't necessarily been cracked when it comes to First Amendment. However, I will say that I think recently we have seen an uptick in First Amendment advocates looking to strengthen free speech rights, and we're starting to see that advocacy seep into the family law and parental context. And so, especially with recent case law that is specifically applicable, or in the context of businesses and compelling speech, the family court compels speech all of the time, and so it's interesting to see perhaps where that might be headed when we are looking at family law in relation to the First Amendment. And your second question, I always think about equal protection, usually, especially when I'm practicing and in trial, thinking about how a lot of families aren't subject to, a stranger making decisions on behalf of when they can call their child when they're not involved in the family court system. And so there is, I think, an equal protection argument to be made in terms of First Amendment freedoms and fundamental First Amendment freedoms being violated for one group of people, presumably families who are separated, rather than intact individuals who aren't involved in the court system at all.
I look forward to your paper. Thank you.
Oh, well, thank you, Professor Reed, for excellent questions which really get to the heart of the matter, especially on my both theoretical, practical objections. And I should say, this is why I'm looking for a co-author, right, to help me deal with this on the prototype. But on the first set, really the related questions, right? Who would be in this market? Who would be the market maker? How thin or thick the market is? Absolutely right. And it's one of the objections by economist Tyler Cowen that the problem of liquidity, right? A market, you really need to have a critical mass of buyers and sellers. And one of the things that I'm looking at that I discuss in the paper in a little detail is I would love it if an academic research institution took this over as sort of kind of a thought experiment, and I even throw it out there, these foundations that are conservative or religious affiliated, like the Templeton Foundation or the Koch brothers, if they could throw some money at this, and I would use the subsidy or bounty idea to actually give people money to play with. And on the manipulation and on the last 2 points, manipulation and motives, with motives, I think there'll be a wide variety of motives, including the profiteering motive. But again, it's really related to how many people you have in, what would be the dominant motive. And I think that's why if an academic institution were to take, or a foundation were to take this under its wing with the purpose of exploring those questions, that would be great, before rolling it out, because, at first I was going to say this is DraftKings, but for conspiracy theories, but that just doesn't sound very appealing. And on the market manipulation, that is a very serious concern. If the market, though, is well functioning, if you have enough people in it, then actually I would welcome the manipulators, right? Because I would create a sort of a price distortion, and that would bring more people in, and then things could work out. But again, that goes to the efficient market hypothesis literature, which is a whole can of worms. But those are excellent objections. You're certainly getting a shout out in the paper, and I appreciate it because it helps discipline my thinking. And thank you for taking my idea seriously.
Welcome. Ms. Monteiro.
Hello, everyone. Thanks again. Excellent question, Professor. Thank you very much. And nowadays, society has adopted a new communication paradigm whose way of expressing and informing is accompanied by the use of technology through the connection by the mobile devices with access to the many digital platforms that allow the materialization of the fundamental rights guaranteed in Article 5, Section 4, 9, 14, and 23 of the Federal Constitution of Brazil. On the other hand, the manipulation of the news format is facilitated, giving rise to the term fake news, which can be understood as the way in which false information of public or private interest is disseminated by communication technology, allowing the favoring of erroneous content and biased beliefs that confuse the recipient. As such, this dissemination deserves a critical eye concerning the growing international trend, just like McIntyre says, of considering truthful facts irrelevant to shaping public opinion in the face of appeals to emotion and personal belief, where some feel encouraged to distort reality to suit their opinions rather than the other way around. So, recognizing the duty of care as a set of measures capable of reducing the risks that the network promotes, such as accountability and control of the circulation of false information by the platforms, is to think of an alternative that can mitigate the spread of disinformation by the recipients. However, this position is legally, as I've already said, blocked by Article 19 of the Brazilian Civil Rights Framework for the Internet, MCI, which exempts platforms from responsibility for content and damage resulting from illegal acts by third parties, and requires the removal of offensive content only through legal action. Therefore, at first glance, this duty to repair damage caused by third parties through the dissemination of fake news is pertinent, since the reality of society's communication goes hand in hand with the use of the internet, and more cases involving fake news are accumulating in Brazilian jurisprudence, such as General Repercussion Issue 987 being analyzed by the Federal Supreme Court here in Brazil with a view to the constitutionality of the aforementioned article, either through the spread of false content by people or robotic mechanisms to favor content endowed with biased beliefs that can lead to discrimination and violation of rights. However, it is still a delicate subject that must be analyzed in great legal depth. This is because our federal constitution in Article 5, Section 9, as I've already mentioned, established that the expression of intellectual, artistic, scientific, communication activity is free. And in paragraph 2 of the Article 220 of the same constitution determines the prohibition of any censorship of a political, ideological nature. So therefore, providing citizens is with quality information for major participation in the democratic debate, which at the same time respects the principle of communicative freedoms in the fight against fake news, is an interesting measure that can be developed, for example, by implementing a public policy that encourages media education that allows citizens to investigate digital information on their own, since considering that for one of the committees of our federal Senate, this information is a matter of social understanding, and we don't know the consequences of giving platforms the power of supervise and impose sanctions. Even if in the future, Article 19 of the MCI is declared unconstitutional by our Supreme Court. So first and foremost, as far as I'm concerned, it is necessary to establish criteria, concepts, well-defined guidelines on what is false information, and time for the effective implementation of the duty of care to achieve the protection of human dignity in harmony with freedom of expression, in the adoption of measures to control the content published on the platforms to protect human rights. The question about Lula and Bolsonaro, what happens here in Brazil is that we had two presidential candidates who defends opposing ideas for Brazil, while on the one hand, you have former President Bolsonaro, who aligns himself with capitalist ideals close to the idea of optimizing individual rights, opening the economic market, seeking tax reductions, aligning with the capitalist ideals of Donald Trump on this other side. And on the other side, you have the current president, Lula, who aligns himself with socialist ideas, like Cristina Kirchner here from Argentina, defending the centralization of the state. So regarding this topic, the emergence of this discussion, around Bolsonaro is because he wants his election through the social media. So as far as that, it started the same way as McIntyre says into his book, Post-Truth. It happens here in Brazil, but with Bolsonaro instead of Donald Trump's. It starts circulating some fake news, and this term just awakened here in Brazil as well. And at the first year of Lula's getting the president, he just this discussion starts to occur into our jurisprudence, into our Supreme Court, and this is the discussion that is being here the whole year. So that is still our Supreme Court didn't judge if this duty of care is going to prevail here in Brazil, but they are still analyzing. I think, and I really think that they're going to follow what your Supreme Court from USA has decided. But I'm still researching. They didn't decide it, but they are still open for discussions. But this, I think I resumed very well. But if you professor has some question, feel free to ask again.
Well, thank you. You've answered the questions well. Thank you very much. And finally, Professor Carlson.
Well, I want to be mindful of time. I do wish I was here or there in person to debate this with you, Professor Reed, because while I am concerned about the California law's requirement that platforms tell us whether and how they're defining radicalization, I also feel like where my biggest concern lies is with the fact that platforms get to decide, right, without anybody having any insight into what goes into that decision, what they consider radicalization, extremism, hate speech.
You and I are agreed on that point.
Oh, good. I'm so glad to hear that. But I'm also glad you brought up those early cases, because whenever I teach those with students, I mean, it blows my mind that, when we look at those, we've got some really, meaningful dissents, but the decisions in those cases, right, really bend over backwards to say that all kinds of dissent is a violation of the Espionage Act, whether that's, avoiding the draft or, encouraging people to think differently about socialism, whatever's going on. And I always think it's fascinating. I think those cases to me are a clear indication that the Supreme Court can at times get things wrong and can change and we can grow and evolve to see issues around free expression differently. And so honestly, in some ways, mentioning those cases really gives me a lot of hope. I think when we think about a regulation of content on social media and how that intersects with our right to free expression in the First Amendment, I always want to remind myself and my students that we're only, 25 years almost into this thing. And so we will find a way, I hope, and I'm confident to, put some guardrails up to have more insight into what platforms are doing, because they have become essentially the arbiters of free speech. So much of what happens, as some of our previous panelists mentioned, in the digital public square is decided by these platforms. And so I am cautious, but also confident that we're going to find a way to strike a balance where we're able to have some insight into what they're doing. And I don't know if insight is the right word or oversight, but then also to, again, protect the rights of users to engage in free expression in these public digital spaces. So that's, I think, my 2 cents on that. But I, again, want to be mindful of time.
Thank you so much. And I think this brings to a close our symposium on free speech. And we,
Professor Reed, we do have an online question before you get started.
By all means, let's bring in the online question.
All right.
And there's, audience may have questions too, yes.
So I'm also going to be mindful of time. Professor Carlson, thank you for your presentation. I just wanted to flag, I believe the 11th Circuit Net Choice case did find that the disclosure requirement of the policies was at least not enjoinable, applying Zauderer to that. So if that wasn't on your radar yet, it is on appeal to the Supreme Court. So status of authority, whatever. But as an example of court going through that analysis, check out the disclosure requirements from the Florida law in the Net Choice case in that 11th Circuit opinion.
Thank you for that. I will absolutely dig in and include that. It shows you how far along my paper is. I will absolutely do that before
I'm in the same boat on my paper. So nobody heard that. It's actually done. I'm just not turning it in. My question actually though was for Enrique, who long time no see, and I wanted to start out by saying that I think your idea is very sort of out of left field and outlandish. You know how offended I am by thoughts like that from my work on that subject. I guess I had a very similar question that was asked earlier, but I guess my sort of manipulation point that I wanted to flag that I started thinking about is, in your market, I want to have a diverse portfolio. I want to invest in a lot of belief contracts, and I also want to sell things off when they get high. So probably what I'm going to do is I'm going to invest in something that I think will go up to, the top price. And then I'm going to begin or start circulating belief contracts in a countervailing conspiracy theory set of facts. And I'm going to try to pump the price up of those as high as I can. And then I'm going to try to strategically sell off something whenever it gets to a certain point. I think all of this is a bit of a byproduct of kind of this being a perpetual marketplace where there's no real event like kind of in a prediction market. And so I feel like that sell-off point raises a problem and raises, I think, this particular sort of incentivization towards undermining the truth of other belief contracts submarket, which I'm not sure if you've contemplated, and I'd be curious if you have, what your response might be to that or how you would think through that problem.
Thank you, Michael. By the way, yeah, we were at a conference together at Loyola Chicago last weekend, and we've been reading each other's work, and so it's really an honor to be here and to back in the trenches. Those are great. Those are great questions, and it goes to a sort of if you will, a strategic manipulation. The idea here, is it really goes to Professor Reed's point, right? How thin the market is. A thick market, should be robust to these kind of potential manipulations. But what I would say, I would kind of turn it around and say, actually, the more manipulators, the better, or the more attempts at manipulation, the better, because that means people are in the market, and there will be other alert traders, there to spot those opportunities. But that is presuming that you have that critical mass of traders, and that's going to be the difficult. That's why you need the co-author, right? That's how do you create a platform that could attract sufficient number of people. My initial idea, to go back to having a foundation or an academic institution do it. First, there's one, by the way, elephant in the room here. Right, and that is the legality of these. In my paper, I talk about this is backward looking. We should be able to skirt the legality issue, but that's I have to make a probability estimate with that. But I will say one other thing too that I've been considering is because it's been the consistent problem that there's no resolution here. Perhaps. Have it when the next tranche of, let's say, JFK documents come released, perhaps there is a way to tie in a conspiracy theory or a bet on fake news on the revelation of new information, But again, that we come back to that problem that, I don't want experts deciding or supposed experts or fact checkers, because they're always going to be disputed in one way or the other. But I appreciate the question. It gives me a lot to think about. And I think the next time we see each other, I will compare notes on this. Thank you.
And I'll say on the legality front, if you haven't run it past Brian Fry, I would maybe suggest doing that. I feel like he would have some very interesting thoughts on that.
By the way, thank you for the Professor Fry. By the way, if you haven't, don't know who he is, check him out on Twitter. Actually, he's a great friend of mine. We met in Savannah at a conference on the rise of the automatons, and he had just a wonderful paper. I actually forgot what my paper was about, back then, but I remember meeting Brian Fry and just enjoying his company. And I know exactly the work you're talking about. I'm going to recheck it out. And shout out to Brian Fry. He's a great and beloved friend. I see we have some academic colleague in common.
I love the brainstorm session we have going on here. Are there any questions from the in-person audience? And Professor Reed?
I just want to say thank you all for a wonderful day. It's been a long day. It's been a fruitful day. We began the morning with the concept of free speech as both instrumental and intrinsic to the development of the human person. We've explored that in all its many facets across the morning and the afternoon sessions. And maybe we're closer to some answers. Thank you so much for being here. Thank you so much for being part of it. Thank you to the speakers, to the editors, the symposium editor, the editorial staff of the Journal of Law and Public Policy. It's been a wonderful, wonderful learned endeavor today. Thank you.
I have a few more thank yous to add on to his. We want to thank the university for allowing us to use the space and for supporting JLPP in its mission. We also want to say thank you to the team of people at the university who have made this event happen: Angela Disick, Carrie Hilger, Xander Mosier, Lorette Hankum, and Michelle Huber for all their work in making this date possible. Additionally, thank you to the Symposium Committee for all of their hard work and everything they've done today to make things move seamlessly. Additionally, thank you to the board and to Professor Reed for setting the groundwork for today's events, to the presenters for their time and talents, and making those of you who were able to travel here with us, we thank you for that. And finally, thank you to all of you who stuck it through and participated in the entire day. We appreciate your engagement and your attention. And please be sure to clean up your area on the way out. We want to respect the facilities, and drop your name tags at the table at the door if you could. And then we wish everyone safe travels and a great night. Thank you.